300. 24 connected case ಇದೆ. ಆದ್ಮೇಲೆ 93 ಕನೆಕ್ಟೆಡ್ ಕೇಸ್ ಪುನಃ 23 93 ಆಯ್ತಾ ಪುನಃ 83 98 32 48 22 90 70
ಆತರ ಸಾಹೇಬ್ರ ಹೆಂಗ್ ಹೇಳ್ಬೇಕು ಹಂಗೆ ಹೇಳ್ಬೇಕಲ್ವ ನೀವ್ ಹೇಳ್ದಂಗೆ
ಅದು 4073 4037 ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 32 69 ಅದಕ್ಕಿಂತ ಮುಂಚೆ 32
ಅದೇ ಪೇಜ್ ವೈಸ್ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್
32 ಮುಂಚೆ ಅದಾದ್ಮೇಲೆ 69 ಅಡ್ರೆಸ್ ಅಲ್ಲಿ
ಸರ್ ನೆನ್ನೆ ಮೆಮೋ ಕೊಟ್ಟಿದ್ದು ಇಲ್ಲ ಕೇಳ್ಬೇಕು ನಮಗ್ ಗೊತ್ತಾಗತ್ತೆ ನೀವು ಕೊಟ್ಟ ಮೆಮೋ ಅಲ್ಲಿ ಹೋಗುತ್ತೆ ಅಷ್ಟೇ ನಾನು ಫಾಲೋ ಅಪ್ ಮಾಡ್ತಾ ಕುತ್ಕೊಳಕ್ಕಾಗಲ್ಲ ಅವತ್ತು ಒಂದ್ಸಲ ಮೆಮೋ ಮಾಡಿದ್ಮೇಲೆ ಮತ್ತೆ ಮೂವ್ ಮಾಡಬಾರ್ದು ಏನಾಯ್ತು ಅಂತ ಕೇಳ್ಬೇಕು
ಮೆಮೋನೇ ಬರಲ್ಲ ಸರ್.
ಹೇಳಿದ್ರು ಸರ್
ಅಯ್ಯೋ ಅಲ್ಲಿ ಕೇಳಿದ್ರೆ
ಕೇಸ್ ವರ್ಕರ್ ಹತ್ರ ಮಾತಾಡ್ಬೇಕು SOR ಹತ್ರ ಮಾತಾಡಿ ನಮ್ಮ ಸ್ಯಾಂಕ್ಟಿಟಿನೇ ಹೊಟ್ಟೋಗಿದೆ ಅವ್ರಿಲ್ಲ ಅಂದ ತಕ್ಷಣ ನೀವು ಇಲ್ಲಿ ಓಡ್ ಬರ್ತೀರಾ
ಸರ್ ತೋರ್ಸಿದ್ರೆ ತಾನೇ ನಮ್ಗೆ
ಮಾತ್ರ
ಬುಕ್ಕಲ್ಲಿ ನೋಡ್ರಿ ಇಲ್ಲ ಅಂತಾರೆ ಏನ್ ಹೇಳೋದು
ಮೂವ್ ಮಾಡೋದು ತೀರಾ ಕುತ್ತಿಗೆ ಬಂದಾಗ ಸುಮ್ನೆ ಮೆಮೋ ಇವಾಗ ಅವ್ರು ಕೊಡ್ಲಿಲ್ಲ ಇವ್ರು ಬರ್ಲಿಲ್ಲ ಅಂದ ತಕ್ಷಣ ಮೆಮೋ ತಗೊಳ್ಳಿ ಬುಕ್ ಯಾರು ತಗೊಂಡಿದಾರೋ ಕೇಳಿ ಅವ್ರನ್ನ ಈಗ ಇನ್ನೊಂದು ಮೂವ್ ಮಾಡ್ತೀರಾ ಮುಂದಕ್ಕೆ ಹೋಗುತ್ತೆ ಅವ್ರು ಅದೇ ಇದ್ ಮಾಡ್ತಾರೆ ಎಲ್ರಿಗೂ ಅದೇ ಹೇಳ್ತಾರೆ ಅವ್ರು ಮೆಮೋ ಬಂದಿಲ್ಲ ಮೂವ್ ಮಾಡ್ರಿ ಇನ್ನೊಂದು ಮೂವ್ ಮಾಡ್ರಿ ಅಂತ ಮೆಮೋ ಬುಕ್ ಕೊಡಪ್ಪ ಅವ್ರು ಯಾಕೆ ಹೋಗಿಲ್ಲ ಕೇಳಿ ಅವ್ರು ಅಲ್ಲೇ ನಾವು ಕೋರ್ಟ್ ಮಧ್ಯದಲ್ಲಿ ಕೆಲಸದಲ್ಲಿ ಬರ್ದು ಅದು ಎಂಟ್ರಿ ಮಾಡಿ ಅಲ್ಲಿ ಕೊಟ್ರೆ ಅದು ವೇಸ್ಟ್ ಆಯ್ತಲ್ಲ ಅಲ್ಲಿ
ಹಂಗೆ ಆಗಿದೆ ಅಲ್ವಾ ಬಂದಿಲ್ಲ ನೋಡ್ರಿ ಯಾರಿಗೆ
ಕೊಡ್ತಾ ಇದ್ದೀನಲ್ಲ ನಾನು ರಿಜಿಸ್ಟ್ರಾರ್ ಜುಡಿಷಿಯಲ್ ಮುಂದೆ ಇಡಿ ಅದ್ಯಾವುದು ಮಾಡೋದೇ ಇಲ್ಲ ಯಾರು ಹೋಗಿಲ್ವಾ ಹೋಗಿಲ್ವೇನಪ್ಪ ಮತ್ತೆ ತಗೊಳ್ಳಿ ನಾನ್ 10 ಕಾಲಕ್ಕೆ ಬಂದಿದ್ರೆ ನಾನು RJ ಹತ್ರ ಬರ್ತಾ ಇದ್ದೆ ನಾನು
ಫೋಟೋ ತಗೊಳ್ಳಿ
ಹೇಳ್ತಾರದು ಎಲ್ಲಿ ಕೋರ್ಟ್ ಆಲ್ ಮೇಲೆ
ಫೋಟೋ ತಗೊಂಡ್ಬಿಡಿ ಇಲ್ಲಾಂದ್ರೆ ಅಲ್ಲಿಲ್ಲ ಅಂತಾರೆ
ಹೇಳಿ ಸಾಹೇಬ್ರಿಗೆ ಹೇಳಿ ಇವಾಗ
ಅವ್ರಿಗೂ ಸಿಗಲ್ಲ ಹುಡ್ಕಕ್ ಆಗದೆ ಹಂಗ ಹೇಳ್ಬಿಡ್ತಾರ ಅವ್ರು
ಅಷ್ಟೇ
ಅದು ತೊಡ್ಕಿ ಅದಕ್ಕೆ ಲೇಗಲ್ಲಾದ್ರೆ ಅವ್ರ ಮೇಲೆ ಹೋಗ್ಬಿಡ್ಲಿ ಟೈಮ್ ಸಿಗುತ್ತೆ ಅಂತ ಅವ್ರು
ಇವರು ಕ್ಯಾಶುವಲ್ ಆಗಿ ತಗೊಂಡು ಇವರೇ ಅವ್ರಿಗೆ ಎನ್ಕರೇಜ್
ನಿಮ್ಗೆ ಏನ್ ಮಾಡಕ್ಕಾಗ ಇವಾಗ ಬೇಡ ಸರ್ ಮೂವ್ ಮಾಡೋದು ನಾಳೆ ಬರುತ್ತಾ
ತಗೊಂಡೋಗಿ ಕುತ್ಕೊಳ್ಳಿ ಅಲ್ಲಿ RJ ಹತ್ರ ಹೋಗ್ತೀನಿ ಇವಾಗ ಮಾಡ್ತೀಯ ಮಾಡಲ್ವಾ ಅಂತ ಅದ್ ಹೆಂಗ್ ಮಾಡೋದಿಲ್ಲ ಆಮೇಲೆ ಹೇಳಿ ನಾನೇ ಬರ್ತೀನಿ ಅಲ್ಲಿ RJ ಹತ್ರ ಒಬ್ರು ಯಾರಾದ್ರೂ ಪಾಠ ಕಲಿಸ್ಬೇಕು ಸರ್ ಸುಮ್ನೆ ಅನ್ನೆಸೆಸರಿ ವೇಸ್ಟ್ ಈಗ ಕೋರ್ಟ್ ಮಧ್ಯದಲ್ಲಿ
Third one, matter for tomorrow, my lord. The similar matters, CH-10. Tomorrow, my lord. The correct of disposition, petition matter. Yesterday, my lord, in the local.
No, that what is that matter?
CH-10 PTCL matter.
Tomorrow.
Agricultural land, 230 address.
Is there any caveat?
No caveat.
No caveat.
No caveat.
tomorrow. For page wise adjournment, list number 1, page number 1, serial number 1 to 4, page number 2, serial number 5 to 10.
My lord, I represent the council for the respondent number 2. Serial number 10, my lord.
Yes.
I seek for an adjournment, my lord.
Yes. Who is that? Gopal Krishna or Vishweshwar?
Vishweshwaraya.
Yes, sir. The request of council for respondent number 2. Is this matter next week?
Much obliged.
Page number 3, serial number 11 to 13.
Lord, serial number 13, Your Lordship, in first matter, Lord, I appear for the appellant, Your Lordship.
Hmm.
In connected cross objections, my Lord, I have not been served even a copy, Your Lordship. Therefore, I request, Your Lordship, to have it by 2 weeks, my Lord. In the meantime, I will secure a copy with the other.
Request of counsel for the appellant in MFA 2393 of 2019. Leaves this matter of 2 weeks.
Great.
Page number 4, serial number 14 to 21. Page number 5, serial number 22 to 26. Page number 6, serial number 27 to 30. Page number 7, serial number 31 to 34. Page number 8, serial number 35 to 38. Page number 9, serial number 39 to 43. Page number 10, serial number 44 to 48. Page number 11, serial number 49 to 53.
My lords, I am for 51. My lords, respondent number 2.
Yes.
51. Another connected matter is there, my lord. MFA 50 of 2020. It should be connected,
Filed by insurance.
filed by
company.
the appellant, my lord. Same appellant. For
No,
the
this is for
damages of the vehicle. Two MFAs he has filed, my lord.
Yes, at the request of counsel, learned counsel for respondent number 2 submits that this appeal may be called along with that so and so.
Madam, number repeat
50.
ಮಾಡಿ madam.
The 50 of 2020, my lord.
Yes.
Page number 12, serial number 54 to 58. Serial number 56, I appear for respondent number 3.
Hmm.
Inform the petitioner counsel at the
Yes. At the request, what you want? At the request of counsel for R3, leave this matter next week.
Page number 13, serial number 59 to 64.
Number 59.
Hmm.
This case under petitioner, my lord.
Yes.
Madam, we kindly have it on next week, my lord.
At the request of counsel for the petitioner, leave this matter next week.
60 malad 60
Yes.
for petitioner malad, I inform malad Badrinath sir could be extend next week malad.
At the request of counsel for the petitioner next week.
The interim order may be extended.
The order granted earlier.
Please,
Extended till next
detail.
week.
Page number 14, serial number 65 to 68. Page number 15, serial number 69. Page number 16, serial number 70. List number 1 for dismissal, serial number 1. SA Kar-
Everything is there, man.
SA
Only I have to send the
Kadri,
copy to the other side.
Srinivasa
1 week
Babu.
time, please. I will file. Everything is, only, in this case, petitioner is expert. I have
No,
not.
to compliance office objection, 10 times time has been
Sir,
granted.
What happened, I entrusted it to my junior. They are not brought to my notice. Yesterday I came. I have everything I have prepared. I will file it now.
Yes.
One
See,
week.
unless it is posted for dismissal, nobody will come before the court.
Sorry.
10 times it is matter posted. 1 or 2 times it is worked.
Sorry.
2015 matter. Yes. Learned counsel for the petitioner submits that. He will do that needful within 2 days.
Sir, 1 week.
Yes.
Day after the week, holidays are there. I have to send it off to
Yes.
the other side.
Weeks time to comply that office objection. We'll release this matter next week for orders.
What?
Preliminary hearing matter, serial number 2, Rajeshwara PN for petitioner.
Hearing for the petitioner, my lord.
Hmm.
My lord, this petition is filed seeking declaration that the section 5, clause 1 of clause C of Karnataka Scheduled Caste and Scheduled Tribes Prohibition of Transfer of Certain Lands Act 1978.
Why
1978.
there is a delay?
Yes, my lord, there is a delay of 40 years, my lord, in filing the application.
Have you produced that amendment copy?
Yes, my lord, annexure A, my lord.
There is no limit. For the number shown, so 5A, 1 of that, there is no time limit for applying for land after registered from the place by the complaint authority. Just notice that complaint authority has been disposing to.
Deputy Commissioner had ordered for restoration of land to the original grantees, my lord, even though there was a delay of 40 years.
Yes.
uh, The same is actually
Issue
covered by
notice.
judgment. My lord,
Government advocate is directed to take notice for respondent number 1, 2, and 3. Counsel for the petitioner is directed to serve 3 sets of copies on government advocate. Issue emergent notice to 4 to 18.
my lord, there may be stay of order
Annexure
B, my lord.
Annexure B till next date of it.
Admission matter, serial number 3, Prakasha HC for petitioner.
For the petition, in this
Yes.
case,
Yes,
petitioner is the wife, my lord.
yes,
File transfer of petition to file before the Chikmagalur family court, my lord. From family court to Changiri, my lord. He is a-
family court to Chengiri.
she's
Uh,
residing in Changiri,
She is staying Chengiri with whom?
independently in Changiri town. Her parents is residing in the village, my lord, near to Changiri.
What is she doing?
Nothing, just.
Is there any,
33 days,
due to marriage, any issues?
not my, only 33 days they were lived as a husband and wife, my lord. Marriage
Yes.
of, date of marriage.
Has
is-
she filed any case?
My lord, she has filed a maintenance case before the Changiri court. Thereafter, they filed a restriction of conjugal rights in a family court in Chikmagalur.
Yes. How issue notice. Stay of further proceedings in MC number 147 of 2024. Pending in the file of Principal Judge Family Court at Chikmagalur till next date of hearing.
Serial number 4, RB Deshpande.
For the petitioner, my lord. Petitioner is the wife, my lord.
Yes,
The husband filed the GNWC, my lord, before the family court at Bangalore, my lord.
yes.
The wife is staying in Mysore, my lord. The wife also filed a criminal mispetition, my lord, for maintenance, my lord, 523/24, my lord, before pending before the Mysore court, my lord.
Husband has filed case for what? GNWC.
GNWC as well as MC, my lord. MC is not listed today, my lord. Wife is filed CMIS, my lord, and also, my lord, MC for
Now
restriction
you
of
are
conjugal
seeking
rights, my
transfer
lord.
of GNWC.
GNWC, my lord. My
Is
submission.
that child is residing with?
Child is residing with the wife, my lord, with Mysore, my lord,
Mysore.
and also, my lord, disabled child, my lord.
Yes, heard. Issue notice. They have further proceedings in GNWC number 1555 of 2024 pending in the file of Second Additional Principal Judge Family Court Bangalore till next date of hearing.
Serial number 5, SP Prakash for petitioner.
My lord, I appear for petitioner, my lord. My lord, petitioner is the mother of the deceased one Disha ML. He is the daughter of the petitioner, my lord. On the basis of the will, my lord, letter of she sought for letter of administration in PNDC number 1/2023, my lord. 1/2024, my lord. Later on converted into OS number 9/2024. My lord, the deceased daughter is working in Bescom. My lord, she died due to intestate cancer. My lord, on the basis of she executed will in favor of the petitioner herein. My lord, on the basis of will, my lord, she sought for PNDC. Thereafter, it is converted into OS.
Yes.
OS number 9/2024 before the court of senior civil at Shimoga.
Yes.
My lord, the husband of the daughter of the petitioner, my lord, the son-in-law of the petitioner herein has filed one more suit before the Haryana court in OS number 100/2024, my lord, at page number 40. Seeking declaration and also for benefit, retirement, death benefit of the daughter of the petitioner herein. My lord, now, my lord, the petitioner herein, my lord, who is the mother-in-law of the petition, one Praveen Kumar.
Hmm.
He is filed OS number 100 before the Harihara court. Now the petitioner sought for transfer of the said OS along with my lord OS filed by the petitioner herein.
No, you see, you have filed an OS for what? P&SC.
Appendix, letter of administration earlier, my lord.
No, that.
Now
who has
that is
executed-
converted into OS.
No, who has executed in a will?
My lord, her daughter.
Your daughter
She
has
is no
executed
more.
an. What is her name?
Her
After
name
that
Disha
only will
ML.
can be executed. Yes.
Disha-
What is her name?
Disha ML.
Yena?
Disha ML.
Nisha?
ML.
MN.
L.
Hmm. She has executed. Who is that? Praveen Kumar.
Praveen Kumar, my lord, husband of his petitioner son-in-law.
No, that Nisha's husband.
Please.
He has filed in a suit for what?
Suit for my lord at page number 40. Declaration and compensation. Declare that plaintiff is the only intent to pension benefits.
Pension benefit. No, she was working in that this thing.
He was also working in Bescom.
No, that he is seeking for an pension and that appointment.
Of
Compulsory appointment.
her wife.
that-
His
you-
wife. His wife.
No, will is for what purpose?
My lord, all benefits and letter of administration, etc.
No, where is that will? Is it will related to this appointment and the pension benefit or only property?
My lord, I have not produced a will before this honorable court, my lord.
That is nothing to do with this case. Why it has to be clubbed? Mr.
My lord, Annexure A, my lord, sorry, my lord, Annexure A.
His suit is declaring that pensionary benefit and compulsory appointment.
Your lordship, kindly
Whether
come.
in the will that right has been executed in your favor.
Your
What is
lordship,
that?
kindly paragraph 2, my lord, at page number 15.
Yes.
I have produced the will.
Hmm.
May read, my lord.
Yes, yes.
ನನಗೆ ಈಗ 32 ವರ್ಷ ವಯಸ್ಸಾಗಿದ್ದು ನಾನು ಮೇಲ್ಕಂಡ ಬೆಸ್ಕಾಂನಲ್ಲಿ ಸಹಾಯಕಿಯಾಗಿ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿದ್ದೇನೆ. ನನಗೆ ಈಗ 1.5 ವರ್ಷಗಳ ಹಿಂದೆ ದಾವಣಗೆರೆಯ ಮಳಲ್ಕೆರೆ ವಾಸಿ ಪ್ರವೀಣ್ ಕುಮಾರ್ PS ಬಿನ್ ಶೇಖರಪ್ಪ PT ಇವರೊಂದಿಗೆ ಕುಟುಂಬದ ಸಮೇತ ಕಾನೂನುಬದ್ಧವಾಗಿ ವಿವಾಹ ಆಗಿರುತ್ತೇನೆ. ಆದರೆ ನನ್ನ ಯಜಮಾನರಾದ ಪ್ರವೀಣ್ ಕುಮಾರ್ PS ಇವರು ನನಗೆ ಮಕ್ಕಳಾಗದೇ ಇರುವ ಕಾರಣ ನನ್ನಿಂದ ಮತ್ತು ನನ್ನ ಸಂಸಾರದಿಂದ ದೂರ ಇದ್ದು ಬೆಂಗಳೂರಿನಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿರ್ತಾರೆ. ನನ್ನನ್ನು ಸರಿಯಾಗಿ ನೋಡಿಕೊಳ್ಳದೇ ಇರುವುದರಿಂದ ನಾನು ಹಾಗೂ ನನಗೆ ಈಗ 3 ತಿಂಗಳ ಹಿಂದೆ ಹೊಟ್ಟೆ ನೋವು ಬಂದಾಗ ಸ್ಕ್ಯಾನಿಂಗ್ ಮಾಡಿಸಿದಾಗ ಜಠರದಲ್ಲಿ ಕ್ಯಾನ್ಸರ್ ಆಗಿದೆ ಎಂದು ದಾಖಲೆಗಳಿಂದ ದೃಢಪಟ್ಟಿದೆ. ನಾನು ನನ್ನ ತಾಯಿ ಮತ್ತು ನನ್ನ ಅಣ್ಣನ ಮನೆಯಲ್ಲಿ ಆರೈಕೆ ಮಾಡಿಕೊಳ್ಳುತ್ತಿದ್ದೇನೆ. ನಾನು ಯಾವಾಗ ಮರಣ ಹೊಂದುತ್ತೇನೋ ಎಂದು ನನಗೆ ತಿಳಿಯದು. ಆದ್ದರಿಂದ ನನ್ನ ಬಾಬ್ತು ನನ್ನ ಸ್ವಂತ ಸಂಪಾದನೆಯಿಂದ ಕ್ರಯಕ್ಕೆ ಪಡೆದಿರುವ ಹಾಗೂ ನನ್ನ ಹೆಸರಿಗೆ ಖಾತೆ ಸ್ವಾಧೀನ ಇರುವ ಈ ಕೆಳಗೆ ಅನುಸೂಚಿಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಪೂರ್ವ ಸ್ವತ್ತಿನ ಬಗ್ಗೆ ನಾನು ನನ್ನ ಖಾಸಾ ತಾಯಿಯಾದ ಹಾಲಿ ಮೇಲ್ಕಂಡ ಶಿವಮೊಗ್ಗ ನಗರದ ಅಶೋಕನಗರ 1ನೇ ಕ್ರಾಸಿನ ವಾಸಿ ಹಾಗೂ ಆಧಾರ್ ಕಾರ್ಡ್ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಹೊಂದಿರುವ ಸುಮಾರು 56 ವರ್ಷ ವಯಸ್ಸಿನ KB ಸೌಭಾಗ್ಯ ಕೋಮ್ಲೇಟ್ MK ಲಕ್ಷ್ಮಣಪ್ಪ ಇವರು ನನ್ನ ತಾಯಿಯಾಗಿದ್ದರಿಂದ ನನ್ನ ಮರಣಾನಂತರ ಈ ಕೆಳಗೆ ಅನುಸೂಚಿಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಸ್ವತ್ತು ಈ ವಿಲ್ ಪತ್ರದ ಮೂಲಕ ನನ್ನ ತಾಯಿಯಾದ KB ಸೌಭಾಗ್ಯವರಿಗೆ ಮಾತ್ರ ಸೇರತಕ್ಕ ಸ್ವತ್ತಾಗಿರುತ್ತದೆ. ಈ ವಿಲ್ ಪತ್ರವು ನನ್ನ ಮರಣಾನಂತರ ಜಾರಿಗೆ ಬರತಕ್ಕದ್ದು. ಈ ವಿಲ್ ಪತ್ರದಲ್ಲಿ ಕಂಡ ಸ್ವತ್ತಿನ ಖಾತೆ ನನ್ನ ತಾಯಿಯವರಾದ KB ಸೌಭಾಗ್ಯ ಇವರ ಹೆಸರಿಗೆ ಸಂಬಂಧಪಟ್ಟ ಕಚೇರಿಯಲ್ಲಿ ಖಾತೆ ವರ್ಗಾಯಿಸಿಕೊಂಡು ಈ ಸ್ವತ್ತನ್ನು ಇವರು ಮುಂದೆ ಅನುಭವಿಸಿಕೊಂಡು ಬರಲು ಇವರಿಗೆ ಮಾತ್ರ ಸಂಪೂರ್ಣ ಹಕ್ಕು ಇರುತ್ತದೆ. ಈ ಸ್ವತ್ತಿನ ಮೇಲೆ ನನ್ನ ಯಜಮಾನರಾದ PS ಪ್ರವೀಣ್ ಕುಮಾರ್ ಬಿನ್ ಶೇಖರಪ್ಪ PT ಇವರಿಗೆ ಏನೊಂದು ಯಾವ ಹಕ್ಕು ಅಧಿಕಾರ ಇರುವುದಿಲ್ಲ. ಹಾಗೂ ನಾನು ನನ್ನ ಜಠರದ ಕಾಯಿಲೆಯಿಂದ ಮಧ್ಯದಲ್ಲಿ ತೀರಿಕೊಂಡಾಗ ನನ್ನ ನೌಕರಿಯಿಂದ ಸಿಗಬಹುದಾದ ಅನುಕಂಪದ ನೌಕರಿಯನ್ನು ಮತ್ತು ಪಿಂಚಣಿ ಹಣವನ್ನು ಮತ್ತೆ ನನಗೆ ಬರಬಹುದಾದ PF ಹಣವನ್ನು ಮತ್ತು ಇನ್ಶೂರೆನ್ಸ್ ಹಣವನ್ನು ಸಹ ನನ್ನ ತಾಯಿಯವರಾದ ಶ್ರೀಮತಿ KB ಸೌಭಾಗ್ಯ ಕೋಮ್ MK ಲಕ್ಷ್ಮಣಪ್ಪ ಇವರಿಗೆ ಮಾತ್ರ ಸೇರತಕ್ಕದ್ದು. This is the will executed by the deceased daughter. Now your lordship kindly come to page 40. The suit filed
100 of 2024 pending in the file of Senior Civil and JMF Senior Civil Judge and JMFC Harihara till next date of hearing.
Much obliged.
Serial number 6, Ashok Mehta for petitioner.
For petitioner, it's wife petition, my lord. Husband has filed, respondent has filed a petition before Oscote, my lord. And she is residing in Bhatkal, Uttar Kannada district, my lord, which is 550 kilometers far from her distance, my lord. She has to come to Bangalore, then to move to Oscote, my lord. It will be a
So
very
that,
tough.
what is she doing there?
She is nothing, my lord. She is a
With whom she is
husband.
residing?
Father, my lord.
Parents.
Parents, my lord. They are also aged
Due to
about
wedlock,
56.
any issues?
Yes, my lord.
Due to wedlock, any issues?
No, my lord. Issues, no issues, my lord. But
Has she filed any case?
no, my lord, nothing has been filed. He is
What
also residing in same place, my lord, but to harass her, he has filed it in Oscote, my lord.
Why Oscote?
Oscote is working there, my lord, so he is filing there, file there.
He is residing in Oscote now.
No, he is working there. He is residing at Bhatkal only.
How can you residing in Bhatkal and working in Oscote, mister?
No, my lord, the husband as I'm talking about.
That is what that.
He's working.
You are saying that husband is residing in
His main resident is permanent resident is Bhatkal, my lord, but he's working in Oscote, my lord.
but now he is residing
Yes,
here.
yes, man.
Then, yes. Or issue notice. Stay of further proceedings in MC number 48 of 2024. Pending in the file of. Elri, yaudri adu?
Senior civil judge.
Huh?
Senior civil judge Oscote, man. Senior civil judge and JMFC Oscote.
Elakidri.
Telecast.
Yes, 48 of 2024 pending in the file of senior civil judge JMFC Oscote. Till next date of hearing.
Serial number 7, O Mahesh for appellant, connected matter, Vivekananda TP.
For the
Yes, Mahesh.
claimant respondent, and I have also filed cross objection. Now, this matter is squarely covered by the judgment of the Honorable Supreme Court in the case of Mukund Devangan. But no doubt, my lord, the judgment has been referred to the larger bench. But now the larger bench has clarified by an interim order. Your lordship might be aware of it.
No, now that I think Mahesh might have been challenging that negligence also.
No, my lord, negligence part. No, the challenge is only to the extent of, my lord, the liability.
Where is that Mahesh? Yes, now we will condone the delay
Please,
per case. There is a delay of 535 days in filing.
they have filed objections, my lord, of course, it can be taken.
Yes. Respondent has filed an objection. Consider that filed an objection. Peruse that affidavit filed along with that application. For the reason stated in that accompanying affidavit, delay of 535 days in filing an MFA crop is condoned, subject to condition in case appellant is succeed, not entitled for interest for enhanced compensation amount for a period of 535 days. Please this matter next week.
It's, accident is of the year 2013.
No,
He
now
has
that-
not received any, my lord, compensation till now. He has spent, my lord, 2,87,000 towards medical expenses.
Then we'll pass it over.
Your lordship may kindly pass.
Pass over. Adನ್ನ order ಬೇಡ ಅದಂಗೆ. Yes.
Serial number 8, Renuka HR for appellant, KT Gurdeva Prasad.
Yes.
Appealing for the appellant, Your Honor.
Hmm.
Page number 5, para number 6, my lordship. The insurance company has taken a specific defense in the written statement that the driver of the insured vehicle did not possess valid and effective driving license to drive the insured vehicle. As on the date of the accident, the license possessed by the driver of the insured vehicle possessed as per Exhibit R2. The driving license enabled the driver to drive non-transport vehicle up to 29/6/2019, transport vehicle up to 29/6/2017, and hazardous vehicle up to 8/6/2015. The vehicle involved in the accident in the tanker class of the vehicle is Maruti axle goods vehicle, and the permit obtained is to carry petroleum products.
Hazardous goods.
Hazardous
Tribunal ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ? Paint recovery.
liability fix ಮಾಡಿದ್ದಾರೆ.
No, that paint recovery you have to be modified because it is in hazardous goods. You don't have any driving license.
Ultimately pay and recovery, but meanwhile, he was having a license to drive goods vehicle.
But this is this.
No, to carry hazardous goods vehicle, he required a refreshment course of every year.
Yes.
Earlier year, he had a refresher course certificate. For this year, he had no refresher course. But meanwhile,
They have not proved whether that vehicle was carrying hazardous goods or not. It is an empty vehicle.
Yes,
They-
madam.
ಸ್ವಾಮಿ ಆ ಟೈಮ್ ಅಲ್ಲಿ ಅವ್ರದ್ದು ಪ್ರಾಪರ್ ಡ್ರೈವಿಂಗ್ ಅಂದ್ರೆ he was like
No, it was not there.
Yes.
And it was also his case is that he was not carrying any hazardous goods.
Hazardous goods.
Then
That is-
tribunal order is right.
That is
Finding ಕೊಟ್ಟಿದಾರ ಆತರ ಟ್ರಿಬ್ಯುನಲ್ ಅವರು
ಅಲ್ಲಿ ಸರಿ ಡಿಸ್ಕಷನ್ ಮಾಡಿಲ್ಲ.
ಕೊಡಿ ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಎಲ್ಲಿ ಏನ್ ಅಂತ ಹೇಳಿದ್ರೆ ಲಯಬಿಲಿಟಿ ಮೇಲೆ.
ಹೌದು ಪ್ಯಾರಾ 14.
para number 13.
Yes, para 14. 14 you read.
The RW1 is the deputy manager of the insurance company and filed evidence affidavit returning written statement ornaments in the lieu of chief examination. It is specific defense that as per RC and permit for a lorry tanker vehicle, the driver was not holding valid and effective driving license.
ಅಲ್ಲಿ ಪ್ಯಾರಾದಲ್ಲಿ ಮುಕುಂದೇವನ್ ಕೇಸ್ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ. ದಟ್ ಇಸ್ ನಾಟ್
ತಪ್ಪದು. That is wrong.
It is e citations namud baralas.
Now that which is the judgment, Mr. Guru?
ILR 2000.
ಕೊಡಿ. Which is that paragraph?
Paragraph.
So far as the point number one.
Yeah,
Does not dispute the driver possessing valid license to drive heavy. Contention the appellant is that since the vehicle in question is as a petrol tanker, special endorsement was required to be obtained that in cross-examination admitted that. Therefore, it is clear that when the accident has occurred, there was no petrol product in the tanker. Clear that accident occurred, it was the empty tanker. In order to drive empty tanker, no endorsement is required, so on so. In the case of license drive, so on so. The point admittedly, it would be ordered to drive empty tanker, no such license is required to goods vehicle. Yes. ಇದ್ರಲ್ಲಿ ಏನಾರ ಇದೆಯಾ? Materials that it is an empty.
Even in FIR, Mazar, nowhere it is stated that the vehicle was carrying.
That is the only contention. Yes, you have not filed any appeal.
ಇಲ್ಲ.
Sorry. So and so learned counsel appearing for. Insurance company has contended that. At the time of the accident, driver of the offending vehicle was having driving license. Now, at the specific contention of learned counsel for the appellant that driver of the offending vehicle has holding driving license to drive non-transport vehicle up to 29/6/2019, transport vehicle up to 29/6/2017, hazardous vehicle up to 8/6/2015. The accident was occurred on 16/1/2016. The vehicle involved in the accident is a tanker classified as multi-axle goods vehicle. Permit to obtain is to carry the petroleum product. Since as on the date of the accident, he don't have any permission to carry hazardous vehicle. He don't have any license to ride in a hazardous vehicle. Therefore, insured has violated the policy condition. Insurance company is not liable to pay compensation. Tribunal error in fastening the liability on insurance company. Shri Gurudev Prasad, learned counsel appearing for.
Respondents 1 to.
Respondent number
1 to 4.
1 to 4 has contended that it is not in dispute the offending vehicle is a multi-axle goods vehicle, but at the time of the accident, it was not carrying any hazardous goods. The appellant has not proved that the offending vehicle was carrying any petroleum product, even in that FIR, complaint or charge sheet, even in the Mazar, it is not mentioned that it was carrying the petroleum product. Therefore, he doesn't require the endorsement to carry hazardous goods. The tribunal has rightly fastened the liability on insurance company. In support of his contention, he has relied on judgment of this court in ILR 2015, Karnataka 393. Heard the learned counsel for the parties. Feroz, judgment and award. Serial number ಎಷ್ಟಿದೆ?
Sir, 8.
TCR ಇದೆಯಲ್ಲ? And original records. It is not in dispute. In death injury na?
Death, case of death.
Yes.
ನಾವೇ ಹಾಕ್ಬೇಕಿತ್ತು.
Pai died in road traffic accident occurred on 16/1/2016 due to rash and negligent driving of driver of lorry bearing registration number TN52Z6894. Only contention raised by the appellant before this court that the offending vehicle is classified of multi-axle goods vehicle. The driver of the offending vehicle was not having any endorsement to carry hazardous goods as on the date of the accident. The permission which is granted was been expired on 8/6/2015. As per that material available on record, that is FIR, complaint, Mazur, spot Mazur, and charge sheet. Nowhere it is mentioned that at the time of the accident, the offending vehicle was carrying any hazardous goods, much less petroleum product. The appellant insurance company has failed to prove that the offending vehicle was carrying petroleum product at the time of the accident. Therefore, the driver of the offending vehicle did not, it is not, driver of the vehicle failed to prove that. For that, therefore, he doesn't require obtain permission to carry hazardous goods. He doesn't obtain special license to drive a hazardous goods. Even this court.
Refresher course certificate.
Special course certificate antana. He doesn't require special course certificate to carry a dangerous or hazardous nature of goods. Even this court in ILR 2015 has held that if the tanker is not carrying any goods of dangerous or hazardous nature, there is no necessity to obtain such a special license to drive an empty tanker. In view of the above, since offending vehicle is insured with appellant insurance company, the insurance company is liable to pay the compensation. there is no error in judgment and award passed by the tribunal. Accordingly, the appeal is dismissed. Judgment and award passed by the tribunal is confirmed. Amount in deposit is transferred to the tribunal.
Serial number 9, Ramesha KR for petition appellant, Nagaraja K.
Here for appellant in this matter.
I appear for the respondent KSRTC matter.
No, it is a case of death. My lord,
Yes.
claim petition was dismissed. My lord, date of accident, my lord, 9/3/2007. My lord, date of death is 24/6/2007. My lord, as in the date of accident, my lord, he has aged about 40 years. My lord, the tribunal was dismissed the claim petition and the reason, my lord, the appellants herein has not produced the post-mortem report 1. Second, my lord, not filed the charge sheet before the trial court. Thirdly, my lord, the appellant failed to prove nexus between the death and accident, death of the injured. My lord, in this regard, my lord, the trial court, my lord, dismissed the claim petition filed.
Where is that? You have not lodged the complaint for the death?
My lord, complaint was not given.
Hmm.
My lord, my lord, he has taken date of death, my lord, on 9/3/2007. My lord, he has continuously taken in the fourth hospital.
Even for the accident, you are not lodged the complaint.
Complaint was lodged. My lord, charge sheet was filed. My lord, we are not the produced before the trial court.
Where is that charge sheet and all?
Lord, it is there.
You produce it here by filing an application. Yes, on that ground it is dismissed. We will send it back.
Regarding
ಅದು ಒಂದೇ-
also
ಅದು
one
ಒಂದ್-
ground. Then, my lord, the second ground is, my lord, the appellants here not produce the post-mortem report regarding the death is due to the accidental injuries. My lord, on that ground, my lord, I have put it one.
ಆಯ್ತು ಫಸ್ಟ್
Para 17 ನೋಡಿ ಸ್ವಾಮಿ. Para 17.
Yes.
Now it is necessary to consider whether the injuries mentioned in Exhibit P17-18 would result in death of a person. For this evidence of PW3, it is relevant to consider the relevant admissions of PW3 is as under. ರಂಗಸ್ವಾಮಿ ನಮ್ಮ ಆರೋಗ್ಯ ಕೇಂದ್ರಕ್ಕೆ ಬಂದಾಗ ತಾನು ಚಿಕಿತ್ಸೆ ಪಡೆದ ಆಸ್ಪತ್ರೆಗಳ ಡಿಸ್ಚಾರ್ಜ್ ಸಮರಿ ತಂದಿತ್ತು. ಅದನ್ನು ನೋಡಲಾಗಿ ಆತನ ಬಲಗಾಲಿನ ಮಂಡಿಯ ಚಿಪ್ಪು ಮುರಿದಿತ್ತು. ಅದಕ್ಕೆ ಅವರು ಚಿಕಿತ್ಸೆ ಪಡೆದಿದ್ದರು. ಆಮೇಲೆ ಮುಂದೆ ಮಂಡಿ ಚಿಪ್ಪಿನ ಗಾಯ ಸುಮಾರು 2 ತಿಂಗಳು ಚಿಕಿತ್ಸೆ ಹಾಗೂ ವಿರಾಮದ ನಂತರ ಸಂಪೂರ್ಣ ವಾಸಿಯಾಗಿರುತ್ತದೆ ಎಂದರೆ ಸರಿ. ಸದರಿ ಗಾಯ ಮಾರಣಾಂತಿಕ ಅಲ್ಲ ಎಂದರೆ ಸರಿ. ಸಾಮಾನ್ಯ ಸ್ವರೂಪದ ಗಾಯಗಳು 1 ವಾರದಲ್ಲಿ ವಾಸಿಯಾಗುತ್ತವೆ ಎಂದರೆ ಸರಿ. ಒಬ್ಬ ಮನುಷ್ಯನಿಗೆ ಕುತ್ತಿಗೆಯಿಂದ ಕೆಳಭಾಗದಲ್ಲಿ ಯಾವುದೇ ಭಾಗಕ್ಕೆ ಸಾಮಾನ್ಯ ಸ್ವರೂಪದ ಗಾಯಗಳಾದರೆ ಅವು ಮಾರಣಾಂತಿಕ ಅಲ್ಲ ಎಂದರೆ ಸರಿ. ನಾನು ರಂಗಸ್ವಾಮಿಯ ಮಂಡಿಯ ಚಿಪ್ಪಿಗಾಗಲಿ ಬೇರೆ ಸಾಮಾನ್ಯ ಸ್ವರೂಪದ ಗಾಯಗಳಿಗಾಗಲಿ ಚಿಕಿತ್ಸೆ ನೀಡಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಅದು ಯಾವುದೋ ಅಬ್ಡೋಮಿನಲ್ ಸ್ಟಮಕ್ ಪೈನ್ಗೆ ಯಾವುದೋ ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದಾರೆ.
My lord, he is not a doctor. My lord, the PW3 is not a doctor who has treated Rangaswamy for his injury sustained in the road traffic accident. My lord, he is a last treated doctor. My lord, the treated doctor to the injuries was not examined before the trial court. And that ground, my lord, I will remind.
You produce that FIR and that charge sheet.
Charge sheet. Regarding charge sheet is concerned, my lord.
You filed an additional
FIR filed, my lord. Exhibit P1 is the FIR filed against the driver of the KSRTC bus, my lord.
ಅಲ್ಲ, ಆಕ್ಸಿಡೆಂಟ್ FIR ಅಲ್ಲಿ ಆಕ್ಸಿಡೆಂಟ್ ಆಮೇಲೆ ನೆಗ್ಲಿಜೆನ್ಸಿ ಅದು ಅಡ್ಮಿಟ್ ಆಗುತ್ತೆ ಅಷ್ಟೇನೆ. ಇದ್ರೊಳಗಡೆ ಬೇಕಾಗಿರೋದು ಏನಂತ ಹೇಳಿದ್ರೆ PM ರಿಪೋರ್ಟ್. ವೆದರ್ ದ ಡೆತ್ ಇಂಜುರೀಸ್ ಆರ್ ಡ್ಯೂ ಟು ದ ವೆದರ್ ದ ಡೆತ್ ಈಸ್ ಡ್ಯೂ ಟು ದ ಇಂಜುರಿ.
There is a judgment just because not filing in a PM report. It's not.
ಬೇಡ, ಅವರು ಡಾಕ್ಟರ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದಾರೆ.
My lord,
question is that they have to prove death is due to that accidental injury.
ಹೌದು, ಅವರೇ ಅಲ್ಲಿನ ಡಾಕ್ಟರ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದಾರೆ.
My lord, he is not a treated doctor who the disease was sustained in the injury. My lord, he is the last doctor. My lord, he was and that time, my lord,
doctor who has treated.
ಆಮೇಲೆ ಒಂದು ತಮ್ಮ ಗಮನಕ್ಕೆ ತರ್ತೀನಿ.
Helpline Hospital. My lord, first he had taken treatment on 9/3/2017. Helpline Hospital, my lord, Bangalore. Then, my lord, he was shifted to Siddharth Medical Hospital, my lord, Tumkur. Then Kidwai. My lord, they are the treat hospital, my lord, the doctor was not examined. And that ground, my lord, I will state it.
ಒಂದು ತಮ್ಮ ಗಮನಕ್ಕೆ ತರ್ತೀನಿ ಸ್ವಾಮಿ. ಡೇಟ್ ಆಫ್ ಆಕ್ಸಿಡೆಂಟ್ ಸ್ವಲ್ಪ ನೋಡಿ. 9/3/2017. Claim petition is filed on 1/1/2013. After 6 years, why should they wait for 6 years if the death is due to the injuries caused in the accident? This is again after thought. ನಾವು ಈಗ ಅವರೆಲ್ಲ ಬಿಲ್ಟಪ್ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ತಾರೆ.
When is the death?
My lord, date of death is my lord 24/6/2007, my lord.
ಹಾ 3 ತಿಂಗಳಿಗೆ.
2017.
7, my lord.
Seven.
Please.
What are you doing for third?
ಈಗೆಲ್ಲ
not-
ಬಿಲ್ಟಪ್ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ತಾರೆ.
Regarding that, my lord,
ನಾವೇನಾದ್ರು
regarding that, my lord, they have not objection before the trial court.
Yes.
ನಾವು ಅಲ್ಲ ಅದನ್ನ ನಾವ್ಯಾಕೆ ಅಬ್ಜೆಕ್ಟ್ ಮಾಡೋಣ, ನೀವು 10 ವರ್ಷ ಬಿಟ್ಟು ಹಾಕೊಳ್ಳಿ.
Yes.
When the court is in our the tribunal, you yourself.
Regarding postmortem is concerned, my lord, already.
Postmortem, mister. What are you doing? What is your explanation? But 6 years after death, you have not filed.
Husband was dead, my lord, wife and children, minor children, they have not know anything about
ಅಲ್ಲ ಲಾಯರ್ಗಳು
In all cases, if the husband is died, the wife has to be filed.
But my
6
lord,
years. Wife is not a minor.
Yes, my lord, because of.
No, mister. 6 years. I thought that only.
They are not, it is not a ground, my lord, it is
Now
not
the-
ground of the
No,
insurance company
accident
to
is
claim.
occurred after 10 years also, now you can file a case. This is all not that correct.
My lord, it is not a ground for the insurance company to claim.
We will, it is an appeal. We can consider that. Yes. Yes.
Serial number 10 adjourned. Serial number 11, Suresham Lathur for appellant. P. Pradeep.
Kindly grant 1 week time, my lord. Next week, my lord.
Yes, at the request of counsel for appellant, reach this matter after 2 weeks.
ಸೀರಿಯಲ್ ನಂಬರ್ 10 ಏನಕ್ಕೆ ಅಡ್ಜರ್ನ್ ಆಯ್ತು ಅಂತ ಗೊತ್ತಾಗಲ್ಲ ಸುಮ್ಮನೆ.
Vishweshwaraya R2 adjourned.
Somebody has taken time, mister.
ಅಲ್ಲ ಸಾರಿ, ಸೀರಿಯಲ್ ನಂಬರ್ 9.
No, we have admitted that matter, mister.
ಆಯ್ತು ಸರ್.
Serial number 12, H.C. Rushabhendraya for appellant, connected matter, Suma K.
The lordship, opposite advocate asked me to adjourn, to take an adjournment. It may be passed over.
Which one, serial number?
12. He said he will come a bit later.
Pass over.
Pass over.
Serial number 13 adjourned. Serial number 14, Padmanabha Kedilaya V for appellant, Krishnappa NR, S.S. Srishaila, Manjula and Tejasvi.
My lords, I have not received a copy of the appeal memo, so I couldn't find my vakalat.
For the respondent, my lord.
No, that Srishaila is appearing.
Yes,
Who is
I appear.
Yes,
I
yes.
appear for
In that view of the matter, my name may kindly be deleted, your lordship.
Yes, he has filed Vakalat, Nodi.
Yes, your lord.
Office is directed to delete the name of. He has filed an Vakalat, madam.
Yes, your lordship. Yes,
Yes.
obliged, your lordship.
Yes, madam, what is this?
Your lordship, this is a case of death. Accident is of the year 2017.
Yes.
Accident is of the year 26/2017. Your lordship, he was aged 42 years.
Yes.
He was working as a security and a supervisor in a resort, your lordship.
Yes.
He was looking after everything. Now he has told that he was getting a salary of 10,000 rupees per month. He has claimed, and he also had agricultural land and used to get rupees 2 lakh per year from that.
Yes.
Your lordship, to sustain that, he has produced exhibit P9. Your lordship, which is the salary certificate which is produced. In that salary slip, they have taken the gross income at rupees 8,000. Gross income is
Ultimately, we have to take that notional income. That's all.
Yes.
That's all. Notional income plus 25% future prospects will be taken and disposed of.
Tribunal, what is the tribunal has taken? 7,000.
7,000. 11,000 plus 25% because he was 42.
Kotilva?
Kottilla.
Future prospects.
Future prospects ಕೊಟ್ಟಿದ್ದಾರೆ 25% ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕೊಟ್ಟಿದ್ದಾರಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ.
Okay. Yes, Mr. Srishaila, that's all.
And loss of love and affection for
Yes, madam.
All that.
ಅಷ್ಟೇ.
Yes. So and so learned counsel appearing for the claimant has contended that at the time of the accident, deceased was aged about 42 years. He was working as a security guard.
ಹೌದು, security guard and
Security guard.
supervisor.
Where?
He was working in Red Earth Resort, HD Kote Taluk.
Delhi Transport Corporation.
Red Earth Resort,
Red Earth Resorts,
HD Kote.
HD Kote, and he was getting a salary of rupees 10,000.
Plus,
he is also having an agriculture land and he was earning 2 lakhs per year. The monthly income assessed by the tribunal, 7,000 per month, is on lower side. Secondly, she has contended that in view of judgment of apex court in case of Pranay's magma, the claimants are entitled 40,000 each. Hence is sought for enhancement of compensation. For contra, Shri Shaila Learned Counsel appearing for insurance company has contended that even though claimant has claimed that he was getting 10,000 salary per month and also earning 2 lakhs per year from agriculture, but he has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income of the deceased as 7,000 per month. He further contended that considering that age and avocation of the deceased, overall compensation awarded by the tribunal just and reasonable, sought for dismissal of the appeal. Heard the learned counsel for the parties, peruse judgment and award. It is not in dispute. Swami died in road traffic accident. Is it correct, Swami?
yes, yes, your lordship.
Road traffic accident occurred on 20th 6, 2017 due to rash and negligent driving of driver of lorry bearing registration number KEZ 3996. Even though claimant has claimed that deceased was getting salary of 10,000 as a security guard and also earning 2 lakhs per year from agriculture crops, he has not produced any document to establish the same. Therefore, notional income has to be assessed as per the guidelines. For the accident occurred in 2017, notional income has to be considered as 11,000.
My lord, one submission, my lord, when he has said 10,000 rupees salary.
No, then also said he is earning 2 lakhs from agriculture. We'll enhance that.
ಅಲ್ಲ ಅವರು ಡಾಕ್ಯುಮೆಂಟ್ ಏನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಅಗ್ರಿಕಲ್ಚರ್ ಬಗ್ಗೆ.
Agriculture because of his death.
Agriculture ಬಗ್ಗೆ nothing is produced, but salary 10,000 ಅಂತ ಹೇಳಿದ್ದಾರೆ. Therefore, lordship take it at 10,000.
What is that documents you have produced for agriculture?
Said that he gets tips also 200 per day. In addition, I have examined PW3.
Yes, where is that?
Your lordship, in the evidence of PW3, I have said I am getting tips 200 rupees per day. Your lordship, PW3.
ಅದು ಓಟಿ occasional ಓಟಿ ಅದು.
Yes, your lordship. Because he was a security.
That is nothing to do with salary. ಅವರೇ 10,000 ಹೇಳಿದ್ದಾರೆ.
Yes.
In paragraph 2 at the end, ಬಂದವರು ನಮ್ಗೆ rupees 200
ಓಟಿ
is to get ಬಂದಿರುತ್ತಾರೆ. Evidence of PW3, second para at the end. Next page, second paragraph.
ಸುಮಾರು 200ಕ್ಕಿಂತ ಹೆಚ್ಚು ನೀಡುತ್ತಿದ್ದಂತೆ ಸದರಿ ಹೇಳಿಕೆ ಸಂಬಂಧಿಸಿದ ನ್ಯಾಯಾಲಯದ ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸಿದ್ದು ನಿವೇಶನ ಗುರುತಿಸಬೇಕಂತ. You has examined whom?
He was the owner of Red Earth Resort. Who was owning the resort.
No, Swami H ಯಾರು ಇದು?
Swami is the person who is dead.
But evidence has been PW3 is the Swami. His name is.
His name also is Swami.
Yes.
Both of them.
Exhibit P9. P9 salary certificate shows 8,000 is the salary.
Yes, we'll consider. ದಾಖಲೆ ಹಾಜರು ಮಾಡಿರುವುದಿಲ್ಲ, ಮಾಡಲು ತೊಂದರೆ ಇಲ್ಲ. ರೆಡ್ ಡೇ ಸೋ ಹಾಜರು ಸರಿ. ನಮ್ಮ ಕಂಪನಿ ನೋಂದಾಯಿತ ಕಂಪನಿ ಇರುತ್ತದೆ. ಈ ಬಗ್ಗೆ ದಾಖಲೆ ಹಾಜರು ಮಾಡಿಲ್ಲ ಎಂದು ತೋರಿಸಲು ವ್ಯಕ್ತಿ ಖಾತೆ ಆತನ ಸಂಬಳ ಹಾಕಲಾಗುತ್ತಿತ್ತು. ಆ ಬಗ್ಗೆ ದಾಖಲು ಹಾಜರು ಮಾಡಿಲ್ಲ. ಈ ಕೇಸಿಗಾಗಿ 15 ಸೃಷ್ಟಿ ಮಾಡಿಕೊಂಡು ಅರ್ಜಿದಾರರಿಗೆ ಸಹಾಯ ಮಾಡಲು ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇನೆ. ಏನು ದಾಖಲೆ ಅದು? ಎಸ್, ಸುಮಾರು ಎಸ್. he was earning 10,000 as a salary, and also he was earning 200 rupees tips per day. To prove that, the claimant has examined the employer as PW3. He has specifically stated that he was paying salary of rupees. Yeah, additional to that salary, he is also getting 200 rupees tips. Nothing worthwhile has been elicited in cross-examination of PW3 by the respondent. Considering that evidence of PW1 and PW3, I am of the opinion that monthly income of the deceased has to be assessed 11,000 per month. The tribunal has rightly added 25% of the income of the deceased for personal expenses. 25% for future prospects.
Yes.
1/3 has been deducted for personal expenses. The multiplier applicable to that age group is 14.
Your Lordship, 4 dependents are there. 1/4 should have been deducted.
Now, why the tribunal has 1/3? Supreme Court in the above judgment has decided, directed to tribunal to cut. They are guided by the paragraph 30. The deduction of the personal living expense, paragraph 42 of the Sarala Verma case, out of the annual income deceased, considered the age of deceased 1/3 to be 1/3 ಅಂತ ಹೇಳ್ತಾರಲ್ಲ.
But 4 dependents are there.
Who are that?
Wife, 2 minor children, and the mother.
Yes, mister.
This is what they have
1/4.
said.
Yes.
72 years, mother.
Yes, since there are 4 dependents, in view of judgment of apex court in case of Sarla Verma, 1/4 of the income of the deceased has to be deducted for personal expenses. Accordingly, loss of dependency has been reassessed as follows.
11,000 plus 2,750 at the rate of 25%, 13,750 minus 3,437 at the rate of 1/4, 10,313. 10,313 into 12 into 14, 17 lakhs, 32,584.
In addition, 15,000 for loss of estate, 15,000 for funeral expenses. In view of judgment of apex court in case of Magma, first claimant is entitled 40,000 for spousal consortium. Claimant number 2, 3 are entitled 40,000 for parental consortium. Claimant number 4, 40,000 for filial consortium. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows.
Serial number 15, Anil Kumar M for appellant. Okay. Serial number 15, Anil Kumar.
Office objection complaint ಮಾಡಿ. National Insurance Company ಯಾರಿದ್ದೀರಾ?
National Insurance.
I take notice, my lord.
Yes.
National
Patil is-
Insurance.
Yes, Patil is directed to take notice. Issue emergent notice to respondent number 2. Learned counsel for the appellant is directed to serve one set of copies. Yes.
Serial number 16, Venkatesha TS for
If,
appellant.
appellant in this case, your lordship.
Yes.
Your lordship, in this case, the court has held that salary itself as 10,782 at paragraph 17. But while calculating, it is calculated at 9,000 rupees, your lordship. And the other thing is that a multiplier, a 17, like.
Matter has been,
Look,
ಲೋಕ ಅದಾಲತಲ್ಲಿ ಏನಾಯ್ತು?
ಸ್ವಾಮಿ ಗೊತ್ತಾಗಿಲ್ಲ ಅದು ಅವಾಗ ಇಟ್ ವಾಸ್ ಪೋಸ್ಟೆಡ್ ಬಿಫೋರ್ ಡಿವಿಷನ್ ಬೆಂಚ್. ಸಾರಿ ಅಂಬಲ್ಸ್ ಅದೇನಾಯ್ತು ಅಂತ ಗೊತ್ತಾಗಿಲ್ಲ ಮತ್ತೆ ಬಿಕಾಸ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಬಂದ್ಬಿಟ್ಟಿತ್ತು. ಆಮೇಲೆ ಬಿಕಾಸ್ ದ ಕಂಪಲ್ಸರಿ ಕಮ್ಮಿ ಮತ್ತೆ ಅಲ್ಲೇ ಹೋಗಿದ್ದ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ಸ್ವಾಮಿ ಹಂಬಲ್ ಸಬ್ಮಿಷನ್ ಅಲ್ಲ. ಇದೇ ಸರಿ ಕಳಿಸಿದ್ರೆ ತೊಂದ್ರೆ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಅದಾಲತ್ತಲ್ಲಿ ಆಗಿರೋದು ರೀಕಾಲ್ ಮಾಡಿಸಿದ್ರಾ? ವೈ? So that the above matter and before local learned counsel appearing for the appellant claimant submitted that not agree with the settlement. You are not in the beginning. You are not.
I'm in the beginning, your lordship, but it was posted before division bench. I was at that point of time I was sorry, humble submission, your lordship, ನಂಗೆ ಗೊತ್ತೇ ಆಗಿಲ್ಲ ಅದು ಹೋಗಿದ್ದು. ಅದೇನಾಯ್ತು it may posted, your lordship.
No, matter has been referred to that Loka Adalat. It was settled there.
Sir.
ಆಮೇಲೆ ನೀವು ಅಲ್ಲಿ ಒಪ್ಕೊಳೋದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ಕೆ ವಾಪಸ್ ಬಂದಿದೆ. That's why I'm asking, you are in a counsel from the beginning or somebody else?
From the beginning, I'm the counsel, your
No,
lordship.
but you are not aware this.
Sorry.
Yes. Pradeep Idra. Yes. Pradeep is directed to take notice for respondent number 3. Issue emergent notice to 1 and 2.
Serial number 17, Sripadvi Shastri for appellant, Ashok N. Patil.
For respond number.
Yes, Shastri.
Serial number 17, Sripadvi Shastri.
An enhancement,
Enhancement.
Password.
Serial number 18, Sripadvi Shastri for appellant, B. Pradeep.
Whether Shastri is there today? Yes, password.
Serial number 19, Kavita HC for appellant, Jwala Kumar.
1 week time. 1 week. ECM matter.
Huh?
ECM matter. Next week.
You want time? Records ಬಂದಿದ್ಯಾ? Yes, he wants time. Yes, at the request of appellant, leaves this matter after 3 weeks.
Public.
Serial number 20, Ravi Shankar Shastri G for appellant, Lalita PM.
Seeking enhancement of compensation.
Who is that Lalita PM? Company or
KSRTC?
KSRTC.
Please. Only
Yes, enhancement.
Yes, ma'am.
Who is that Lalita? Yaru? ಹಾಕಿದಾರ? Yes.
Not the.
No, because these newcomers, whether I have to show their name of appearance or I have to say they are not present. That is the problem. If regular counsels, if I know, I can say that they are argued.
Lordship may say appeared, my lord. If they object, Lordship may recall the order. Small
Not
object.
object. The problem is that if they are not come to the court and something is happened, it's difficult. If the counsels who are regularly appearing before me, I can say that. If I say that she is not present, it may affect her.
Their career.
That is what that I am thinking. We'll pass it over. Let us see once.
Serial number 21, A. Ravi Shankar for appellant, Srinivasan MOI.
Narrow compass insurance company.
Yes.
ಮೊದಲೊಂದ್ಸಲಿ ರಿಮಾಂಡ್ ಆಗೋ ಮುಂಚೆ we came before the court, stated that the employee relationship is not established. But this court found that the owner of the vehicle had admitted the employment. Therefore, there is no question of you being an insurer saying something against him ಅಂತ ಹೇಳಿ ರಿಮಾಂಡ್ ಮಾಡಿದ್ರು. ರಿಮಾಂಡ್ ಮಾಡಾದ್ಮೇಲೆ ಈ ಕ್ಲೈಮೆಂಟ್ಸ್ ಏನು ಇದು ಮಾಡ್ಲಿಲ್ಲ,
ಎವಿಡೆನ್ಸ್ ಕೊಡ್ಲಿಲ್ಲ, ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಡ್ಲಿಲ್ಲ. ಅದ್ರ ಮೇಲೆ ನಾವು ಬಂದಿದ್ದೀವಿ. Only one point I have. They themselves admit it is 6,000 rupees. The trial court gives him 8,000 rupees. 8,000 is the maximum in the event of not establishing anything.
No, it is a maximum or it's in a fixed.
Fixed ಅಲ್ಲ. That not was act. It is ಅಂದ್ರೆ ಏನು ಇಲ್ಲ ಅಂದ್ರೆ 6,000 8,000 rupees ಕೊಡ್ಬೇಕು.
No,
ಈಗ
there
if
are
I
the
were to come,
argument saying that 8,000 is the minimum.
ಅಲ್ಲ ಈಗ ಅವ್ರು ಬಂದ್ಬಿಟ್ಟು ಪ್ಲೀಡಿಂಗ್ ಅಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ನಂಗೆ 6,000 ರೂಪಾಯಿ ಇದೆ ಅಂತ.
No, if it is on the factor, we have to be calculated, is not under 166.
ಇಲ್ಲ, ಇದು ECA. ECA.
Therefore,
ಅದು ಒಂದೇ ಪಾಯಿಂಟ್. ಅಕಾರ್ಡಿಂಗ್ ಟು
8,000 is minimum.
ಅಲ್ಲ
If he is-
minimum.
No, I will, you have to convince me that that was the arguments which was going on here. Then, but if it is minimum is 8,000, because I have taken so many orders that 8,000 is the minimum. Then, if it is earning more than that, if it is proved, then that has to be taken. Then AK Bhatt has argued 2 days before. He's saying that by a new amendment now, it is fixed 8,000. Even if it is in higher also, it can't be taken.
Not be correct.
That is
Suppose
what that
because
wording he has said.
ಈಗ
that
ತಮ್ಮ ಡ್ರೈವರ್ಗೆ ಈಗ ನನ್ನ ಡ್ರೈವರ್ 25,000 ರೂಪಾಯಿ ಕೊಡ್ತೀನಿ.
No, whatever you.
ಹಾಗೆ ಹೆಂಗ್ ಹೇಳಕ್
No.
ತಮ್ಮ ಡ್ರೈವರ್ಗೆ ವಿಲ್ ಬಿ ಅರ್ನಿಂಗ್ ಮೋರ್. We can't fix him at 8,000 rupees. So that I don't think that logic will work.
No, that what is that?
Actually, correct, 8,000.
8,000 is
ಜಾಸ್ತಿ ತಗೊಂಡ್ರೆ 8,000 ತಗೊಂಡ್ಬೇಕು. Minimum 8,000.
Minimum wages is 8,000 ಅಂತ ಮಾಡಿದ್ದಾರೆ.
ಈಗ 12,000 ಏನೋ ಮಾಡಿದ್ದಾರೆ. ಅವಾಗ 2011 ಅಲ್ಲಿ 8,000 ಇತ್ತು.
My lord, directly on the point, division bench judgment 6905.
15,000 ಇದೆಯಲ್ಲ. My senior friend is also saying.
From 5/1/20 it is made 15,000.
15.
ಅಲ್ಲ ಅದು ಜಾಸ್ತಿ ಆಯ್ತು. That is not the issue. That is, we have notification at the time.
8,000 ರೂಪಾಯಿ ತಗೊಳ್ಳೋದು.
You what Ravi is arguing, his salary is less than 8. Therefore, you can't take it 8. It should be 6 anta.
But when they are given on oath, if the income is 6,000, it cannot be taken.
Now, what is the legislation says we want? Yes, which is the Shastri judgment?
That is 6905/2018. It's a reported that judgment of the division bench of this court headed by B.V. Nagaratna J.
6-1 ಇನ್ನೊಂದ್ಸಲಿ ಹೇಳಕ್ ಹೇಳು.
6905 of 2018.
Yes.
Managing Director versus Srimati Nirupama. My lord, in this judgment, this fact is elaborately discussed. And finally, it comes to the conclusion that 8,000 is the minimum. And there is no slab.
Yes, that's what that I am also following, but let the
ಇದೊಂಚೂರು ನೋಡಿ ಹೇಳಿ. ನಾನು
No,
contribute.
my lord, reason, it's a reason judgment, elaborately discussed. Why it is
Division
so?
bench.
division bench.
ಓದಿ ಹೇಳ್ತೀನಿ.
If that judgment is there, you have to follow.
ಅದಿದ್ರೆ ನಾವೇನ್ ಮಾಡಕ್.
No, but not only that, after that, in so many cases, I have taken 8,000, but now we have raised that. We'll see that if it is that.
ನಂದು ಇಷ್ಟೇ ಕಂಟೆನ್ಷನ್ಸ್. ಇದು ಅಗೇನ್ ಎಸ್ಟೋಪಲ್ ಬರುತ್ತೆ. ಏನು ಅಂದ್ರೆ ಎಸ್ಟೋಪಲ್ ಬೈ ಪ್ಲೀಡಿಂಗ್. There is no estoppel against statute. That is one thing. There is no estoppel against statute. Statute ಇಲ್ಲ. ಇದು ಸ್ಟ್ಯಾಚ್ಯೂಟ್ ಅಲ್ಲಿ ಇಷ್ಟೇ ಕೊಡ್ಲೇಬೇಕು ಅಂತಿಲ್ಲ. ಈಗ ಅವ್ನು ನನ್ ಬಂದಿರದೆ 6,000 ರೂಪಾಯಿ ಅಂತ ಹೇಳಿದ್ರೆ ತಾವ್ ಹಿಂಗೆ 8,000 ರೂಪಾಯಿ. And let's we'll see this.
ಮತ್ತೆ 100 ರೂಪಾಯಿ ಡೈಲಿ ಬ್ಯಾಟಾ ಅಂತ ಹೇಳ್ತಾರೆ.
Subject to the provisions.
ಅಲ್ಲಿ 9,000 ಆಯ್ತಲ್ಲ.
Bata is not wages. ಅದಕ್ಕೂ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ.
60% of that monthly wages of the insured employees multiplied by the relevant factor. Amount of 1 lakhs to be 40,000. Provided central government by notification the official letter from.
They made this statement before this honorable court in an earlier round of litigation, saying that my earning is only 6,000. Insurance company is simply denying it when the owner has admitted the employment. They can't do it ಅಂತ ಅವರೇ ಈ ಕೋರ್ಟ್ ನಲ್ಲಿ ಹೇಳಿದ್ರು. ಈಗ ಹೆಂಗೆ ತಿರ್ಗಿಸಿ
ಆ ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡ್ಬಿಟ್ಟು then we will discuss. If it is everything is decided on that, why should I has to scratch my head? I can directly follow that. Otherwise, we will see that. Since it is in a division bench also.
My lord, sorry, my lord, may I make one submission, madam?
Yes.
Serial number 17 and 18, both I am ready actually. Party
Yes,
list also.
Pass or Mr. Shastri.
At 2:30, my lord, 2:30 or after.
Yes. When do you want, Mr. Ravi? Next week?
next Friday ಆಗ್ಬೋದು.
Yes, next Friday.
Serial number, office objection, first time matter, serial number 22, M.E. Tanuja for appellant.
But this is the 4 matters are there. 22, 23 and 39, my lord. And another matter, today I have moved in WP 4 matters, my lord, connected matters. We have challenged the constitutional validity, my lord. One matter in serial number 39, constitutional validity amendment application was put up. In another serial number 20 to 23, that amendment application was not put up.
Have you filed it?
Yes, my lord, I have filed it, it was not put up.
No, that is secondary.
Yes, ma'am.
You first comply that.
We will comply, madam. Minor office objections is there.
Minor, you have
Yes.
not paid the court fee.
Yes, madam. We have failed, madam.
If you paid the court fee, I.
Yes, we paid, madam.
Can't ask me to look into.
Yeah, I'm sorry. I'm so sorry, madam. I filed, madam. Kindly 1 week time may be granted, madam. Tomorrow, I'll all the office objections remove, madam. Because in the similar matter, interim order granted, madam.
No. Without complying.
I will
office
comply it, madam. I will comply.
Sir,
I'm sorry.
Petition itself cannot be
Sure.
registered because there is no court fee has been paid.
Actually, I have paid, madam, 2 days back. We will complete.
At the request of
1 week, madam.
39.
39, madam. 3 matter. 20,
time is granted to,
22, 23 and 39.
week's time is granted to comply that office objection. 39 ಏನಿದೆ?
39 is
Same.
Office objection.
Yes,
all the 3 matters.
yes.
Much of it.
Office objection, third time matter. Serial number 24, Andhra Ningappa for
petitioner,
petitioner.
I complied all of these office objections, subsequently raised an objection, placed for weeks accommodation.
Yes, at the request of counsel for.
Serve ಮಾಡ್ರಿ GML.
Only
ಯಾರಿಗೆ?
one objection only.
State you have to serve a copy, that's all. Yes.
Malad, in amendment in the last matter, serial number 22, 23 and 39, amendment application may be put up, malad. In 39 amendment application.
Comply ಮಾಡಿ ಆಮೇಲೆ
I'll-
ಮಾಡ್ತಾರೆ. Yes. Yes, at the request of petitioner, release this matter, week's time is granted to comply of subjection.
For order, serial number 25, Ravi Shankar Shastri Ji for appellant, HC petitioner.
Seal number 25, 26 and 45 are, my lord, arising out of a common judgment, my
Common
lord.
judgment. Yes, where is Bestur?
Bestur.
ಇರ್ತಾ
fact,
ಇರಲ್ಲ Bestur.
One of the appeal, my lord, has disposed of, my lord, wherein
ಇಲ್ಲಿಗೆ ಕ್ವಾಂಟಮ್.
ಕ್ವಾಂಟಮ್ ಮತ್ತು ಅದು ಮುಕುಂದ ದೇವಗನ್ ಲೈಬಿಲಿಟಿ ಇಶ್ಯೂ ಬಗ್ಗೆ
Yes,
ಫಾಲೋ ಮಾಡಿ ತಾವು ಒಂದರಲ್ಲಿ ಜಡ್ಮೆಂಟ್ ಮಾಡಿದಿರಿ,
yes.
ಉಳಿದಿದ್ದಲ್ಲಿ ಬಾಕಿ.
Memo for dispensation of notice to R5 and 8 is
And-
dispensed.
R1 also dispense ಮಾಡ್ಬೋದು ಸರ್.
Notice to R1 is also dispensed.
Memo.
Yes, ಕೊಡಿ.
My lord,
That case, there cannot be any dispute. First matter,
My lord,
MEC,
MEC 1017 of 14.
ಎಲ್ಲಿ page?
My lord,
There are 4.
R2 ಮತ್ತು R4 ಗೆ ಸರ್ ಸೇಮ್ ಕಂಪನಿ ರಿಲಯನ್ಸ್.
ನಾವು ಬೆಸ್ಟ್ ಒನ್ 4 ಅವರೇ ಅಲ್ಲ.
ಅವರೇ ಸರ್, ಅವ್ರೆ.
ಯಾಕೆ 2 ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪನಿ?
2 ವೆಹಿಕಲ್ ಇದೆ ಸರ್. My lord, there was one maxi cab, my lord, and there is auto
ಇದ್ರ
rickshaw.
ಮೇಲೆ ಲೈಬಿಲಿಟಿ ಇದೆಯಾ?
ಒಂದರಲ್ಲಿ 65%, ಇನ್ನೊಬ್ರಿಗೆ 35% ಹಾಕಿದ್ದಾರೆ ಆಟೋಕ್ಕೆ. ಆಟೋಕ್ಕೆ
ಬೇರೆ ಬೇರೆ ಒಬ್ಬರೇ ಕ್ಯಾನ್ ಬಿ ಡಿಫೆಂಡ್
my lord ಅಲ್ಲ
ಮಾಡ್ಬೋದು. ಇನ್ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಏನಾಗಿದೆ ನೋಡಿ.
ಅವರೇ ರವಿ ಸಂಪ್ರತಿ ಅವರು ಹಾಕಿದ್ದಾರೆ.
ಯಾರಿಗೂ direction ಆಗಿಲ್ಲ.
ರವಿ ಸಂಪ್ರತಿ ಅವರು ಹಾಕಿದ್ದಾರೆ.
ಇದ್ರಲ್ಲಿ ಯಾರಿದ್ದಾರೆ?
ಇದರಲ್ಲಿ ಬೆಸ್ತೂರ್ ಅವರು R2 ಗೆ ಹಾಕಿದ್ದಾರೆ, R4 ಗೆ ಹಾಕಿಲ್ಲ. ಸೇಮ್ ಕಂಪನಿ.
ಅವ್ರಿಗೆ clear ಕೇಳ್ತಾ ಇದ್ದಾರೆ. First matter ಅಲ್ಲಿ 26 ಅಲ್ಲಿ ಸರ್ವು unrepresented. ಒಬ್ರು R2 ಮಾತ್ರ.
26 ಅಲ್ಲಿ ಯಾರು ಹಾಕಿಲ್ವಾ?
ಇಲ್ಲ ಸರ್.
ಬೆಸ್ತೂರ್ ಅವ್ರು ಹಾಕಿಲ್ವಾ?
ಇನ್ನೊಂದು ಯಾವ್ದು ಸರ್?
45.
45 ಅಲ್ಲಿ ಬೆಟ್ಸೂರ್ ಒಂದಕ್ಕೆ ಹಾಕಿದ್ದಾರೆ, ತಿರ್ಗಾ ಇನ್ನೊಂದಕ್ಕೆ ಹಾಕಿದ್ದಾರೆ.
ಹಂಗಾರೆ ಅವ್ರು ಬೆಸ್ತೂರ್ ಅವ್ರನ್ನೇ ತೋರ್ಸೋಣ.
ಆಗ್ಬೋದು ಸರ್.
ಎಸ್
My lord, so far as the 2 aspects, my lord. One is, my lord, the
ಯಾವ ಕೇಸಲ್ಲಿ ಡಿಸೈಡ್ ಆಗಿರೋದು? MEC
MEC number 36 of 15 ಅಲ್ಲಿ.
36 of 15.
ಹೌದು ಸರ್. My lord, this appeal arises out of MEC 1017 of 14, wherein, my lord, death of, my lord, son of the appellant,
Page?
the page, my lord, 69 regarding quantum, my lord. Page 75, para 75.
75.
There, my lord, so far as income is concerned, my lord, gets
Wait.
it at para 75.
Yes.
There, my lord, petition number 4, examined as PW4 in her evidence, has deposed the nature of works in which the brother of her was engaged and dependency and the entire family of his income. In regard cross-examination.
No, you said 6,000.
6,000 was taken, my lord. It is the accident of the year 2010-2013.
ನೀವ್ ಎಷ್ಟ್ ಕೇಳಿದ್ರಿ?
ನಾವು ಕೇಳಿ ಸರ್ 500 per day ಅಂತ ಹೇಳಿದೀವಿ.
ಅಂದ್ರೆ 15,000.
ಹೌದು. My lord, 2013 accident, my lord, 8,000 could be taken, my lord.
What is his age?
He was aged, my lord, 30 years. 17 multiplier was taken by MACT.
ಅದ್ ಕರೆಕ್ಟ್ ಇದೆ.
ಇದೆ. 40% future prospects ಕೊಡ್ಬೇಕಿ ಸರ್, ಕೊಟ್ಟಿಲ್ಲ.
ಆಮೇಲೆ
Then mother is the claimant, my lord, and other are the brothers and sister. Against them it was dismissed.
one of correct
50%.
50% ಮಾಡಿದ್ದಾರೆ. In others is
The
same.
other heads, my lord, 50 and 25 was awarded. Lordship may
Yes.
suitably modify, my lord. And so far as the liability aspect is concerned, my lord, Lordship may kindly turn to page.
ಅದ್ ಕೊಡಿ ನಮ್ದು ಇನ್ನೊಂದು ಜಡ್ಜ್ಮೆಂಟ್.
Sir.
ಪೇಜ್ ನಂಬರ್
Page para 60, my lord, at page 60. Para 60 at page 65, my lord.
Yes.
Lord, there, para 60, my lord.
1660.
Internal page 61, my lord.
Yes. Documentary place to clearly disclose that
Driving license only for non-transport vehicle.
not possessing the badge is also another factor which is considered. Stated supra vehicle is yellow board and not white board so as to contend that it is a private. All in Barala.
ಅದಕ್ಕೆ ಮುಕಂದ ದೇವಗನನ್ನು follow ಮಾಡಿ.
Making a classification vehicle issue driving license particular category of vehicles for rule, therefore class examination. Maxi cab.
Maxi cab 65% was a fine, my lord, liability was fixed. There is no difficulty, my lord. My lord, auto was 35%, the liability was fixed on the ground
Which
that
vehicle the driver was not holding?
auto, my lord.
Auto.
Para 60, it was stated driving license only for non-transport purpose. Therefore, my lord, on that ground, my lord, it was
Yes.
yes.
ಇನ್ನೊಂದು ಎಲ್ಲ 3 ಕೇಸು ಡೆತ್ತೇನಾ?
ಸರ್ 2 ಕೇಸ್ ಡೆತ್ ಇದೆ, ಇನ್ನು 45 ಇಂಜುರಿ ಇದೆ. ಇದರಲ್ಲಿ my lord, son of the appellant died and the connected 26 ಅಲ್ಲಿ daughter died, my lord.
Tali. So and so learned counsel appearing for the claimant has contended that at the time of the accident, idu MUC 1017 of 2014. Page number idu? Page miss ಆಯ್ತಲ್ಲ.
That is, my lord,
para ಯಾವ್ದು ನೀವು ಇದು ಹೇಳಿದ್ದು?
para 69, my lord, quantum.
69. Yes. As on the date of the accident, deceased was earning 15,000 per month. Tribunal has assessed notional income of the deceased was 6,000 per month is on lawyer side. Secondly, he has contended that in view of judgment of apex court in case of Pranay Sethi, 40% of the income of the deceased has to be added for future prospects. Lastly, he has contended that in view of judgment of apex court in case of Magma, the claimants are entitled 40,000 each. Hence, he sought for enhancement of compensation. Per contra, Sri Bestur Learned Counsel appearing for respondent number 2 and 4. As 4 ಗೆ Bestur is directed to take notice.
ಲಯಬಿಲಿಟಿ ಅಲ್ಲಿ ಒಂದು ಲೈನ್, ಲಯಬಿಲಿಟಿಗೆ ಆಟೋ ರಿಕ್ಷಾಕ್ಕೆ ಲಯಬಿಲಿಟಿ ಬರುತ್ತೆ ಅಂತ MACT ಅಲ್ಲಿ ಅಬ್ಸಾಲ್ವ್ ಮಾಡಿದ್ದಾರೆ ಆನ್ ದಿ ಗ್ರೌಂಡ್ ದಟ್ ದೇರ್ ಇಸ್ ನೋ ಟ್ರಾನ್ಸ್.
ಆಯ್ತು, ನಾವು ಕವರ್ಡ್ ಇನ್ನೊಂದು ಡಿಸಿಷನ್ ಇದೆಯಲ್ಲ, ವೈ ಶುಡ್ ಐ ಅಗೇನ್ ದಟ್. ಆಮೇಲೆ ಈ ಫರ್ದರ್ ಕಂಟೆಂಟೆಡ್ ದಟ್ in respect of liabilities is concerned in connected matter, this court in MFA 3979 of 2019 has held that insurance company is liable to pay that compensation. Disposed of on 6th August 2020. Shri Bestur Learned Council appearing for respondent number 2 and 4 has contended that even though claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed notional income as 6,000 per month. Secondly, has contended that since claimant has failed to establish his income, tribunal has rightly not awarded future prospects. Lastly, he has contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal just and reasonable. Interest awarded by the tribunal 9% is on higher side. In respect of liabilities is concerned, he has not disputed that this court has adbada. He further contended that the tribunal has rightly exonerated that insurance company from payment of compensation.
R4 insurance loss, R2
Therefore, rightly exonerated that respondent number 4 insurance company from the liability. Heard the learned counsel for the parties. Perose, judgment and award. It is not in dispute. Who is the name of the deceased?
Hassenar, my lord.
Hassan.
Hassenar.
Hassena died in road traffic accident occurred on
2010-2013.
2010-2013 due to rash and negligent driving of driver of auto rickshaw bearing registration number KA21 A8961 and maxi cab bearing registration number KA13 A4641. Even though claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Therefore, notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurring 2013, notional income has to be considered as 8,000. At the time of the accident, he was aged about
30 years.
30 years. The multiplier applicable to the age group is 17. The tribunal has rightly deducted 50% of the income of the deceased for personal expenses. In view of judgment of apex court in case of Pranay Sethi, 40% of the income of the deceased has to be added for future prospects. Accordingly, loss of dependency has been reassessed as follows.
8,000 plus 3,200 at the rate of 40%, 11,200 minus 5,600 at the rate of 50%, 5,600. 5,600 into 12 into 17, 11,42,400.
Yes. In addition, 15,000 for loss of estate, 15,000 for funeral expenses. In view of judgment of apex court in case of Magma 17. First claimant, her wife,
mother.
The first claimant is entitled 40,000 for filial consortium. Bakidara?
Major brother, sister, my lord. Claim was dismissed against them by MNC.
The enhanced compensation amount carries 6% interest.
And there is a delay, my lord.
In respect of liabilities is concerned, this court in connected matter arising out of the same accident in MFA 3979 of 2019 disposed of on 6th August 2024 has held that the insurance company of that
auto
rickshaw, the insurer of the auto rickshaw is liable to pay compensation of 35% liability fixed on them. Yes. 606 days is condoned, not entitled for the interest for enhanced compensation. What is that next matter?
My lord, enhanced interest loss maybe 6%. Enhanced compensation carries interest rate.
6% only. Yes.
Because MACT has awarded 9%, my lord.
No, now we have reduced that 6 for enhanced.
Yes. My lord,
What is that second matter?
MEC 1018 of 14, my lord.
018.
Please. Para 81, my lord, at page 72. My lord, similar order will come, my lord. Only thing is that deceased was Jainabi, daughter of appellant.
What is that income you have claimed?
My lord, I have same, my lord, 15,000.
15,000. Same order.
Same, my lord.
Madam. Same. Contention alla same ತಗೊಳ್ಳಿ. ಇದರಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿರ್ಲಿಲ್ಲಲ್ಲ?
ಇದರಲ್ಲಿ ಸರ್ R4 ಗೆ
What to do that will say served
R4 ಗೆ ಬೆಸ್ತೂರ್ ಅವರಿಗೆ ಕೊಡ್ಬೋದು ಸರ್.
ಅಲ್ಲ, is not there. ಯಾವ ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪನಿ?
ಸೇಮ್ ರಿಲಯನ್ಸ್ ಕಂಪನಿ. ಅದೇ ಕಂಪನಿ ಸರ್.
ರಿಲಯನ್ಸ್ ಯಾರಿದ್ದಾರೆ? ಇಲ್ಲಿ ಯಾರು ಇಲ್ಲ. ಇನ್ನೊಬ್ರಿಗೆ ಯಾರಿಗಾರು ಕೊಡ್ಬೋದು. somebody is
ಪ್ರದೀಪ್ ಅವರು ಇದ್ದಾರೆ.
somebody comes. Yes, Pradeep. It's connected matter. ಒಂದ್ರಲ್ಲಿ ಮುಕುಂದೇವ್ ಒಂದು ಲಯಬಿಲಿಟಿ
ಆಗಿದೆ.
we have disposed of.
ಅದರಲ್ಲಿ
ಇವರು
ಸಂಪ್ರತಿ ಅವರೇ.
Two insurance company, two vehicles, but same insurance company. We can appear. Ravi has appeared in that connected matter.
ಅವರೇ ಅವ್ರ ಪರವಾಗಿ ಅಪಿಯರ್ ಆಗ್ತಾನೆ, ಅವ್ರಿಗೆ ಡೈರೆಕ್ಷನ್
ಬೆಸ್ತೂರ್ ಅವರಿಗೆ.
ಬೆಟ್ಸೂರು
ಅಲ್ಲ 35
ಅದೇ ರಿಲಯನ್ಸ್ ಇಂದ ಬೆಟ್ಸೂರು ಅವರು ಅಪಿಯರ್ ಆಗಿದ್ರೆ ಅವ್ರ ಹೆಸರೇ ತೋರಿಸಿದ್ರೆ ಅವ್ರ ಪರವಾಗಿ ನಾನೇ
one case ಅಲ್ಲಿ he has appeared Bestor, that I have disposed of.
Please.
He has appeared in one matter, one insurance company. I said he will take notice for both. It is Reliance only liability.
ಬೆಟ್ಸೂರು ಅವ್ರಿಗೆ ತೋರಿಸಿ ನಾನು ಹೇಳ್ತೇನೆ.
Second matter ಅಲ್ಲಿ served unrepresented.
ಅದ್ರಲ್ಲ ಅವ್ರಿಗೆ
ಬೆಸ್ತೂರಿಗೆ ಕೊಡು. Yes, you can.
ನಾನು ಹೇಳ್ತೇನೆ.
Because tomorrow he should not come and say that.
ನಾನು ಹೇಳ್ತೇನೆ.
ನನಗೆ ನೋಟಿಸ್ ಹೀಗಾಗಿದೆ, ನನ್ನ ಕಾಪಿ ತಗೊಂಡಿರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. It is for the advantages of the insurance.
ಕೊಡ್ತೀನಿ ಸರ್.
Because liabilities is concerned, Ravi has argued in connected matter, we have already held. Because there are 8 to 10 connected matters are there. ಇದ್ರಲ್ಲಿ ಅವ್ರಿಗೆ ಹಂಗಾರೆ ರವಿ ಇವ್ರು ಅಲ್ಲ, ಬೆಸ್ತೂರ್ HC Bestur is directed to take notice 2 and 4 disposed of. Notice to 5 to 8 is dispensed. ಎಷ್ಟಿದೆ ಡಿಲೇ?
ಸಿಮಿಲರ್
ಇಲ್ವಾ? ಇದರಲ್ಲೂ 606 days.
Same. ಹೌದು. Condone not entitled for the enhanced compensation. ಇನ್ಯಾವ್ದು?
45 sir.
45 ಮೇಡಮ್ ಕೊಡಿ. MEC 7
ಎರಡು ವೆಹಿಕಲ್ ನಿಮ್ದು
ವೆಹಿಕಲ್ಸ್ ಇನ್ಶೂರ್ಡ್ one company.
ಎರಡಕ್ಕೂ ಒಂದೇ ರಿಲಯನ್ಸ್ ಇದೆ. ಒಂದ್ ಕೌನ್ಸಿಲ್ ಕ್ಯಾನ್ ಅಪಿಯರ್ ಅಲ್ಲ?
ಆಗ್ಬೋದು.
ಎಸ್. ಇದರಲ್ಲಿ ಅವರು ಬೆಸ್ತೂರ್ ಹ್ಯಾಸ್ ಫೈಲ್ಡ್ ಅನ್ ವಕಾಲತ್ ಫಾರ್ ಓನ್ಲಿ one. Will directed to take notice for other also. 2. Delay of 608 is condemned not entitled for. ಏನಿದೆ ಇದರಲ್ಲಿ?
ಇಂಜುರಿ ಕೇಸ್.
Injury, any disputes?
My lord, same similar, my lord, some enhancement will come, my lord.
Will dispose of or in this because that 2 cases are death
cases. On Monday
will pass it over. Is there?
ಇಲ್ಲ ಪಾಸ್ ಇಲ್ಲ ಸಿಕ್ಕಿಲ್ಲ ನನಗೆ ಒಂದು ಲಿಂಕ್.
ಇದನ್ನ ಮಂಡೆ ಹಾಕೋಣ ಬಿಡಿ. Same thing. Yes. Serial number 45. Delay of 608 is condoned not entitled for the interest. Bestur is directed to take notice for R2 ಬೇಡ ಇರ್ಲಿ, ಅವತ್ತೇ ಹೇಳೋಣ. ಮತ್ತೆ ಅವ ಮಾರನೇ ದಿನ ಬಂದು ನಂಗೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ, ಅಡ್ಜಸ್ಟ್ ಮಾಡಿ. If you want to say that, yes, I will take. Otherwise, it is already served. You can dispose of. Release this matter on Monday.
Another 2 appeals are there, my lord. If it could be posted along with
Yes, kodi.
3985 and
Post this matter along with that.
Decision.
Yes, ಅದ್ರಲ್ಲಿ ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ? ಆಯ್ತು. ಇದನ್ನ ಅದಕ್ಕೆ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಹಾಕೋಣ.
ಹೆಂಗೆ ಇರಲಿ. Serial number 27, Arvind H for appellant, HB Chandrasekhar, Arini Shivananda.
They appear for the respondent.
Ready?
Next week, madam.
Award satisfy ಮಾಡಿದ್ದೇವೆ ಸ್ವಾಮಿ.
Ready ಇದ್ದೀರಾ?
ಹೌದು
ಅವ್ರು
ಸ್ವಾಮಿ.
ready ಇದ್ದಾರೆ, ನೀವು ready ಇಲ್ಲ ಅಲ್ರಿ?
Taxi council, madam. Taxi council item.
Who is that Arvind? Yes. Learned council for, he wants time, madam.
ಆಯ್ತು ಸ್ವಾಮಿ.
Date may be fixed.
Yes, no date fixing. Today is the date. Learned council for, the appellant has filed a memo seeking dispensation of notice to R3. Memo is taken on record. Notice to R3 is dispensed
R1,
at
madam.
the request of,
R1.
R1. ನೋಡಿ R1, R3. R1.
R3 ನಾನು appear.
Yes, dispensed notice on R1. At the request of appellant, leaves this matter next week.
Cell number
Much.
28, H Maltesh for appellant.
Yes.
In the memo for dispensation, my lord, in respect of 1 and 2.
3 ಯಾರಿಗೆ?
3, my lord, is Bharati Exam.
ಯಾವ್ದು? Which insurance company? Bharati AXA.
Bharati Exam.
Pradeep is there, Bharati AXA. Yes. P. Pradeep is directed to take notice for respondent number 3. Notice to 1 and 2 is dispensed, please. Sir, one set of copies to Pradeep. Yes, next week.
Any date may be. There is neurological, my lord, problem is there, my lord. Any date may be.
Records necessary. If
No,
it is a
case
serious.
of injury, my lord.
Huh?
Case of injury. my
No,
lord.
if it is in a serious injuries, then we have to secure the records. We have to see that
25%, my lord, the whole body neurological disability is there.
ಟ್ರಿಬ್ಯುನಲ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
ಅದರಲ್ಲಿ 2 lakhs, my lord, 61,000.
ಡಿಸಬಿಲಿಟಿ ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ?
Disability, my lord, is considered, my lord, 25% of the whole body.
ಡಾಕ್ಟರ್ ಎಷ್ಟು ಹೇಳಿದ್ದಾರೆ?
ಡಾಕ್ಟರ್ ಹೇಳಿದ್ದಾರೆ.
ಡಾಕ್ಟರ್ ಹೇಳಷ್ಟೇ ಕೊಟ್ಟಾರಲ್ಲ, ಇನ್ನೇನ್ ಮತ್ತೆ?
Same disability has been considered.
What doctor said has been considered by the tribunal.
Yes, my lord.
ಮತ್ತೆ?
25% ಅದು, my lord, ಅದು ರಿಕವರ್ ಆಗಿಲ್ಲ, ಜಾಸ್ತಿ ಆಗಿದೆ ಅವರಿಗೆ. ಆಮೇಲೆ and then also, my lord, the income, my lord, 6,000 is considered.
ಅದ್ ನೋಡೋಣ.
First matter.
Disabilities, are you disputing that if the doctor said 25% and tribunal has taken 25%?
Yes.
Other head will discuss. If you want to dispute that, then records are necessary.
Not necessary, my lord.
Yes, we'll see next week, Pradeep. You serve a copy to him.
Yes, my lord. I will
Yes.
today, sir. Any date? my lord?
Yes, next Friday.
Please.
Yes.
Cell number 29, B Pradeep for appellant, Gopal Krishna N.
ಅದ್ರಲ್ಲಿ R1 ತೀರ್ಕೊಂಡಿರೋ ಸ್ವಾಮಿ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಒಂದು ಲೆಟರ್ ಕಳಿಸಿದೀನಿ. ಅದು ಮಾಹಿತಿ ಸಿಕ್ತಿಲ್ಲ, ಇನ್ವೆಸ್ಟಿಗೇಟರ್ ಕಳಿಸಿ ನೋಡಿದ್ವಿ.
Who is R1?
3 weeks ಕ್ಲೈಮೆಂಟ್
ಹೋಗಿದಾರಾ?
ಹೌದು.
Yes. At the request of counsel for the appellant, 3 weeks time is granted to
Cell
do
number
the needful.
30, Arsha R for appellant.
Appealing for appellant, my lordship, kindly give 1 week time for file a amended caste title.
ಏನ್ ಅಮೆಂಡ್ಮೆಂಟ್?
Caste title.
ತೀರ್ಕೊಂಡಿದ್ದಾರೆ ಅದ್ರಲ್ಲಿ ಇದ್ರಲ್ಲೂ
ಐ ಅಲೋ ಆಗಿದ್ಯಾ? then you amend it now.
Yeah, my 1 week, my lordship, that I'll.
ಅದ್ರಲ್ಲಿ ಜಾಸ್ತಿ ಜನ ಇದ್ರು, ಅದಕ್ಕೋಸ್ಕರ ಸಪರೇಟ್ ಆಗಿ ಅಮೆಂಡೆಡ್ ಕ್ಲಾಸ್
Amendment ಮಾಡಿದಾರಾ? ಎಷ್ಟು ಜನ?
ಅದ್ರಲ್ಲಿ ಕ್ಯಾರಿ ಔಟ್ ಮಾಡಿರೋ ಸ್ವಾಮಿ, ಅಮೆಂಡೆಡ್ ಅಪೀಲ್ ಮೆಮೊ ಹಾಕಿ ಅಂತ ಹೇಳಿದ್ರು.
Bill memo ಹಾಕಿ ಅಂತ ಹೇಳಿದ್ರು. ಸುಮಾರು ಜನ ಇದಾರಲ್ಲಪ್ಪ.
ಹೌದು.
Yes, you file an amended petition, mister.
1 week, my lordship, calendar.
Yes, at the request of appellant, week's time is granted to do the needful.
Much obliged.
Cell number 31, Bopana B for appellant, A Venkatesh.
I pay for the appellant. Connecting this.
ಫೈಲ್ಸ್ ವಕಾಲತ್ ವಿತೌಟ್ ಸಿಗ್ನೇಚರ್ ಕಂಪನಿ. ವಕಾಲತ್ ಬೇರೆ ಹಾಕ್ತೀವಿ.
You want time?
I want 1 week time.
Yes, at the request
Connecting
of.
this, they have filed another appeal, my lord. MFA 4710 of 2018.
Is it, mister?
ಹಾಕಿದ್ದಾರೆ.
Posted together, call for records.
Yes. Learned counsel for the appellant submits that this appeal may be called along with that
4710 of 2018, my lord.
2018. Call this matter along with the so and so.
In the
And also
meanwhile,
in the meantime, office is directed to secure original records.
in the meanwhile, I am permitted to file ವಕಾಲತ್.
Yes. No, you want to take back and file it. You file it fresh. ಹಾಕಿ ಇದು ಹೋಗುತ್ತೆ ಅಷ್ಟೇ.
ಅಷ್ಟೇ ಹೋಗು.
Cell number 32, Ravi SK for appellant, Muralidhar HM.
For the respondent, madam.
Yes. This court
by order dated 12th December 2023, directed the trial court to dispose of the suit not later than 6 months from the date of the receipt of the copy of this order. Registry has received that communication from Principal City Civil and Section Judge Bangalore dated 23/8/2024, enclosing that letter of presiding officer seeking for further extension of the time for a period of 6 months. For the reason stated in that communication dated 23/8/2024, the further period of 6 months has been granted from today.
Serial number 33, C.R. Gopalaswamy Associates, Bhargavji for petitioner,
I'm
N.
appearing.
Subhash Shastri.
I'm appearing for petition. 1 week time may be granted, my lord. Senior is
Yes.
not well.
At the request of counsel for appellant, read this matter after 2 weeks. Praise 2 weeks time to do the needful.
Serial number 34, R. Shama for petitioner, government advocate.
My lordship. Price for a week's time to file substitute service application, my lordship.
Non-furnishing of acknowledgement copies, issue notice to R4. At the request, week's time is granted to do the needful.
Much obliged, my lordship.
Serial number 35, Saravana S for petitioner.
In another week,
CH-
not I will comply with the office objection.
Yes, finally, week's time is granted to do
R3
the
is
needful.
diseased, huh?
Lord, I would like to submit that R3 is deceased, Jairamaya.
ಇಲ್ಲ, ಅದಕ್ಕೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀನಿ. I filed the application for bringing alerts of R3. There's some office objections, I will comply.
Yes, he has already filed.
Some office objection, I will comply.
Yes.
So interim order may be kindly.
Interim order granted earlier is extended till next date of hearing.
Serial number 36. Saravana.
Let's kindly seek short accommodation.
Not taking steps in respect of R4, Mr. How many times you have granted
I
it?
try to contact the petitioner, my lords.
Then you will dismiss it.
My lords, week's time.
No,
we
it will abate against R4, will make
My
it
lords will
abate.
file a necessary application, my lords. 3 days shorter.
Yes, finally, week's time is granted to do the needful.
Please.
Serial number 37,
Yes, ma'am.
Sri Rajshekhar for petitioner.
It's for the petitioner, my lords.
Son of VR.
Same, my lords. Is respondent 4, my lords, has died.
Serial number?
36/7.
Hmm.
Let's will take a steps regarding respondent number 4, my lords, for LR.
ಹಾಕಿದ್ದೀರಾ?
Hakila, one week,
7.
week's time. 7, my lords, R7. Sorry.
You are appearing in this matter also?
Yes, my lord.
Yes. R7, you have already granted time, mister.
My lords,
What
last 1 week.
ಅದೊಂದು ಕಾಪಿ.
ಹನುಮಯ್ಯ ಯಾವತ್ತು ಸತ್ತೋಗಿದ್ದಾರೆ ಮಿಸ್ಟರ್? ಸತ್ತೋಗಿರೋದು ಅವತ್ತೇನು? 4 ಅಂದ್ರೆ 5, 6, 7 ಆಯ್ತಲ್ರಿ? It's abate.
My lords
We'll
will
make
file
it
an application, my lords.
We file it, will treated this as an abated. ಎಷ್ಟನೇ ತಾರೀಕು ಆಗಿರೋದು?
18/4/24 ಅಲ್ಲಿ ಟ್ರ್ಯಾಕ್
18/4 ಅಂತ ಬರುತ್ತೆ. 4 ಇಂದ 5 ಏನಿದೆ? 5 ಇಂದ 6, 6 ಇಂದ 7, 18. ಈಗ 8 ಅಲ್ಲ? Yes. Yes. Respondent number 7 is dead. So far, no application for bringing LRs has been filed. Hence, petition against R7 is abated. Next time we will see if they are the contesting respondent, we'll dismiss the petition.
My lords will
because-
file a next.
Yes.
Serial number 38, T. Sheshagiri Rao for petitioner, government advocate.
38.
Since are there, I'll have to comply with it. I'll do the needful.
38 ಯಾರ್ದು?
T. Sheshagiri Rao.
Teshgir Rao, yes.
Some objections are there. sir. I
Yes.
think there are some objections which have been raised by the scrutiny branch. I'll look into it.
Week's time is granted to do the needful.
Please. The interim order granted on 2/5 be extended till the next.
Interim order granted earlier is extended till next date of it.
Great.
Serial number 39 urgent, serial number 40 Pawan Kumar.
Hearing for the petitioner, my lords.
Hmm.
The petition is before this court, my seeking in the writ of mandamus, my lords.
Non-compliance office
My lords,
objection.
compliance is, my lords, all parties are not made as a party in the writ
The
petition, my
nature
lords.
of mandamus not to implement that order passed in so and so. Petitioner is not challenging the order dated. We want to
Petitioner is
consider
only-
the representation of R5. Tahsildar is made as a party. What is that relief you have sought, mister?
My lords, so we are only sought for consideration of our representation, my lords.
Or
It is to implement the order passed by the deputy commissioner by directing the respondent number 5 to consider the order passed by the deputy commissioner, my lords.
ಮತ್ತೆ ಇವರು ಇದ್ರಲ್ಲಿ ಏನ್ ಹಾಕಿದ್ದಾರೆ? Seeking a writ in the nature of mandamus only to implement that order passed by
Respondent number,
not challenging the order of R3.
yes, my lords.
ಏನ್ order of R3 is an order.
Also,
Deputy
R3
commissioner order is in your favor.
yes, please, my lords.
Then why that has to be challenged?
That's the,
Why that office is raising such an objection?
that, no, my lords.
Council submission either. For the above objections, the implementation order, petitioner is not challenging that order.
Petitioner
What
is
that
only
office
seeking,
objection? The above, all the parties of annexure A are to be parties. You are seeking only implementation.
yes, please, my lords.
Yes, who are the petitioner?
Petitioner is the grandson of the
Original
Inamdar
grant-
grantee, my lords.
You are the original
Yes, please, my lord.
grantee. Original grant is LR.
Yes, yes, my lord.
What has happened to that before that?
My lords, in the year of 1963,
Hmm.
the suit scheduled property was granted to the one Mr. Tayappa, my lords.
Dayappa.
Yes, please, my lords. In case number 665 of 1963-64
Hmm.
by the special deputy commissioner, my lord.
Yes.
After that, my lords, in the year of 1965, through the registered sale deed,
Hmm.
it was purchased by the grandfather of the petitioner, my lords.
You are a purchaser.
Yes, please.
Hmm.
After, my lords, in the year of 1960, all the family members of the LRs, family members of the Inamdar, original Inamdar, has executed a release deed among in favor of the subsequent purchaser, my lords, in the year of 1960. Thereafter, my lords, in the year of 1985, the original landowner is died, my lords. After his demise, after 38 years later, my lords, in the year of 2003, the LRs were challenged filed the appeal before the assistant commissioner seeking for restitute the land record in their favor, my lords.
What is that order you want to be implemented?
My lords,
What is that you want to be implemented now?
now,
DC has passed an order in your
yes,
favor.
yes, my lords. So DC has set aside the past order passed by the assistant commissioner, my lord.
Assistant commissioner has restored the land.
Yes, yes, my lords.
Now we
Now,
have.
now, my lords, DC is directed in the, my lords, in the page number 16, my lords.
Hmm.
In sorry, my lords, page number 19, my lords.
Yes.
ಬೆಂಗಳೂರು ಪೂರ್ವ ತಾಲೂಕು ಬಿದರಹಳ್ಳಿ ಹೋಬಳಿಯ ಮಿಟ್ಟಿಗಾನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 33ರ 3 ಎಕರೆ 19 ಗುಂಟೆ ಬಗ್ಗೆ ಅರ್ಜಿದಾರರು ಸಲ್ಲಿಸಿದ ಮನವಿಯನ್ನು ಪುರಸ್ಕರಿಸಿದೆ. ಪ್ರಶ್ನಿತ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳ ಆದೇಶ ಸಂಖ್ಯೆ KSCST 50/2023 ದಿನಾಂಕ 10/6/2003 ಆದೇಶವನ್ನು ರದ್ದುಪಡಿಸಿದೆ. ಒಂದು ವೇಳೆ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಆದೇಶದಂತೆ ಕಂದಾಯ ದಾಖಲೆಗಳಲ್ಲಿ ನಮೂದು ಮಾಡಿದ್ದಲ್ಲಿ ಸದರಿ ನಮೂದುಗಳನ್ನು ತೆಗೆದುಹಾಕಿ ಪ್ರಶ್ನಿತ ಆದೇಶವನ್ನು ಹೊರಡಿಸುವ ಪೂರ್ವದಲ್ಲಿ ಇದ್ದಂತೆ ಕಂದಾಯ ನಮೂದು ಮಾಡಬೇಕಾಗಿ ಕಂದಾಯ ನಮೂದುಗಳನ್ನು ಇಂಡೀಕರಿಸಿ ತಹಶೀಲ್ದಾರರಿಗೆ ನಿರ್ದೇಶಿಸಲಾಗಿದೆ. ಸೊ ವಿ ಆರ್ ಪಿಟಿಷನರ್ ಇಸ್ ಓನ್ಲಿ ಟು ಸೀಕಿಂಗ್ ಟು.
ಎಲ್ಲಿದೆ ನಿಮ್ಮ ಹೆಸರು ಚೇಂಜ್ ಮಾಡಿದಾರಾ?
ಇಲ್ಲ, ಚೇಂಜ್ ಮಾಡ್ಲಿಲ್ಲ. ಅದಕ್ಕೋಸ್ಕರ ನಾವು ರೆಪ್ರೆಸೆಂಟೇಶನ್ ಕೊಟ್ಟಿದ್ದೇವೆ ಸ್ವಾಮಿ.
ಅಲ್ರಿ AC
ಹೌದು, AC ಅವರು ಚೇಂಜ್, AC ಅವರು ಬಿಫೋರ್ ಫೈಲಿಂಗ್ ದ ಅಪೀಲ್ ಬಿಫೋರ್ ದ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್,
Where is
ದ
that?
ಖಾತಾ ಇಸ್ ಇನ್ ದ ನೇಮ್ ಆಫ್ grandfather of the petitioner, my lords.
Where is that? ಅದ್ ದಾಖಲಾತಿ ಎಲ್ಲ ಐತ್ರಿ?
Was produced before the deputy commissioner, my lord. Sir,
Then
not-
I have to see that whether.
Yes, please, my lord. We will
You
furnish
produce
the
that.
same, my lord.
ಆಮೇಲೆ when the DC has passed an order,
DC has passed on 20th/4/2024, my lord.
20th/4/2024.
In this year.
That grantee has not filed any writ, Mr.
No, my lord.
How
allow ಮಾಡಿ
allow ಮಾಡಿದ್ದಾರೆ ಇವರು ಇದ್ರ ಮೇಲ್ಗಡೆ is there any petition filed by the grantee?
No, my lord. Not writ petition has filed, not.
ನಿಮಗೆ ನೋಟಿಸ್ ಬರೋದು ಲೇಟ್ ಇರ್ಬೋದು ಬಟ್ ಇಲ್ಲಿ ಕಂಡಿಡಿಯಕ್ಕಾಗತ್ತಾ?
Actually, it is a Inam land, Inam grant.
On what ground DC has dismissed, allowed? 15ರಂದು ಪೌತಿ
In
ಆಗಿತ್ತು.
page number 15, my lords. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಕ್ರಯಗೊಂಡ ತನ್ನ ತಾತನು ಸ್ವತ್ತಿನ ಸ್ವಾಧೀನ ಅನುಭವದಲ್ಲಿದ್ದು ಅವರು
ರೀಡಿಂಗ್
18, my lords.
15.
ತಾತ ಪಾಪಣ್ಣ ಬಿನ್ ಚಂದ
ಅವರು 1985 ಅಲ್ಲಿ ಡಿಸೀಸ್ ಆಗಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅವರನ್ನು ಪಾರ್ಟಿ ಮಾಡಿ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಮುಂದೆ ಆರ್ಡರ್ ತಗೊಂಡಿದ್ದಾರೆ.
ದಾಖಲಾಯಿತು. 60ರಂದು ಸದರಿ ಸ್ವತ್ತಿನ ಹಕ್ಕು ತನ್ನ ತಾತನ ಹೆಸರಿಗೆ ಖುಲಾಸೆ ಮಾಡಿಕೊಡೋದಕ್ಕೆ ಪತ್ರ ಕೊಟ್ಟಿರ್ತಾರೆ. ಜಮೀನ್ದಾರ್ ವಾರಸುದಾರರು ಸೋಂಸ ವಿಚಾರಣೆ ನಡೆಸಿದ ಉಪಾಧಿ ಕಂದಾಯ ಸೋಂಸ ಅಂತ ಇನಾಮ್ ಜಮೀನಾಗಿದ್ದು ಇದನ್ನು ಇನಾಮ್ ರದ್ದಾಯಿತಿ ಕಾಯ್ದೆ ಅಡಿಯಲ್ಲಿ ಇನಾಮ್ ಜಮೀನುದಾರಗಳು ಮಂಜೂರು ಮಾಡಿದ್ದು. ಇಂಥ ಪ್ರಕರಣಕ್ಕೆ ಪಿಟಿಷನ್. This is an Inam land, Mr.
Yes, please.
Petition Act is not applicable. ಕಾಯ್ದೆ ಆಕರ್ಷಿಸುವುದಿಲ್ಲ ಎಂದು ಮತ್ತು ಪಿಟಿಷನ್ ಕಾಯ್ದೆ ಅಡಿಯಲ್ಲಿ ಇನಾಮ್ ರದ್ದಾಯಿತಿಯ ಕಾಯ್ದೆ ಅಡಿಯಲ್ಲಿ ಮಂಜೂರಿ ಜಮೀನನ್ನು ಪರಿಗಣಿಸಲು ಅವಕಾಶ ಇಲ್ಲವೆಂದು ಈ ಬಗ್ಗೆ ಪಿಟಿಷನ್ ಸೋನ್ಸ್. Yes, you take notice and in the meantime you produce that this thing.
Tata number.
Change of entries after that order.
Please, my lord.
Government advocate is directed to take notice for 1 to 5. Counsel for the petitioner is directed to serve 5 set of copies. Leave this matter on 20th. In the meantime, you verify whether is there any writ petition is filed.
Acha, please.
ನೀವು ಅದನ್ನೊಂದು ಮೆಮೊ ಹಾಕ್ಕೊಡಿ.
Please.
Change ಆಗಿರೋದು. Then we'll dispose of.
Please, ma'am. Acha.
ಕೊಡಿ. Office objection is overruled. Yes. Submission of learned counsel for the petitioner is accepted. Office objection is overruled.
Acha.
Yes.
Hearing interlocutory application matter, serial number 41, Shripad V. Shastri for appellant, P.B. Raju.
My lord, there is a 111 days delay in filing the appeal. My lord, only question involved is, my lord, only liability. As far as quantum is concerned, my lord, I am not insisting. My lord, 2 lakhs, my lord, only on the ground that, my lord, the driver who committed the accident has charge sheeted for non-possession of driving license. My lord, it is found in page para number 31. My lord, insurance companies altogether exonerated. Pay and recovery order may be passed.
Not having driving license or
charge sheeted. Charge sheeted, and there are my lord, the charge sheet is filed actually non-production of driving license at the time of inspection or inquiry. Well, that is why pay and recovery order may be passed.
Where is Raju? P.B. Raju alladu. Kindly pass over. Pass over, Mr.
Yes.
Yes.
Serial number 42, A.M. Venkatesh for appellant. M.
But the
Gopal
appellant,
Krishna.
my lord.
Yes.
Filed the application for paper publication Vijayawani, Bangalore, madam. In respect of R3.
IA 1 of 2024 is filed for seeking permission to take out notice to respondent number 3 by substituted service by paper publication
Vijayawani, Bangalore.
in Prajavani,
Vijayawani, madam.
Vijayawani, na? That is not mentioned. Yes, Vijayawani daily newspaper published in Bangalore, circulated in Bangalore edition. For the reason stated in that accompanying affidavit, IA 1 of 24 is allowed. Appellant is permitted to take out notice to respondent number 3 by way of substituted service in Vijayawani daily newspaper published in Bangalore on or before
1st October,
hearing date.
30th October.
Yes.
Serial number 43, A in Krishnaswamy for appellant, A Venkategowda.
Here for first respondent. And file a memo for reporting the death of first respondent. The appellant has to take necessary steps, madam.
First respondent is dead,
Dead, madam.
Substituted service ಯಾರಿಗೆ? R2 ga? Yes. When he has dead, mister? Who is
8-3,
first
madam.
respondent?
During pendency of the appeal, 17/8/2023, madam. I filed a death certificate along with.
Who is he?
With the claimant, madam.
He is the claimant. Yes. IA 1 of 2024 is filed for substituted service of notice to R2 by way of paper publication in Vijayawani Kannada Daily Newspaper, Chikmagalur edition. For the reason stated in that accompanying affidavit, IA 1 of 2024 is allowed. The appellant is permitted to take out notice to respondent number 2 by way of paper publication in Vijayawani Kannada Daily Newspaper, Chikmagalur edition on or before
1st October,
hearing date.
30th October.
Yes. Learned counsel for the respondent number 1 has filed a memo reporting death of respondent number 1. Learned counsel for the appellate prays 2 weeks time to file necessary application to bring LRs of R1.
Serial number 44, B.C. Sitaram Rao for appellant.
Minutes for respondent number 1 and 2, minutes Samyukta Karnataka, Bangalore edition.
Yes. IA 1 of 2024 is filed by appellant seeking permission of this court to take out notice to respondent number 1 and 2 by way of paper publication in Samyukta Karnataka Kannada Daily Newspaper, Bangalore edition. For the reason stated in that accompanying affidavit, IA 1 of 24 is allowed, permitted to take out notice to respondent number 1 and 2 by way of paper publication in Samyukta Karnataka Kannada Daily Newspaper, Bangalore edition on or before
30th September.
hearing date.
29th October.
Yes.
Serial number 45 urgent. Serial number 46, CM Venkata Reddy for appellant, CV Manjunatha, Jwalakumar, Prakash HC.
Yes.
For 1 and 2, only application for release of the amount kept in FD, my lord.
Who is Venkat Reddy? He is appearing for whom?
For appellant, for the owner.
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 Owner's appeal.
That this honorable court, my lord, by the order dated 16/11/22, my lord, has ordered to release the amount in deposit. Out of the said amount, my lord, sum of rupees 1,29,000 was kept in FD in the name of first respondent by in the Karnataka Bank, my lord. That amount, my lord, may be ordered to be released.
FD ಎಷ್ಟು ವರ್ಷಕ್ಕೆ ಇಟ್ಟಿದ್ದಾರೆ?
FD for 3 years, my lord. As per the
ಮುಗಿತಾ 3 years?
22 ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಆಕ್ಸಿಡೆಂಟ್, my lord, ಇದು ಬಹಳ ಹಳೇದು.
23 ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿರೋದು ಮುಗ್ದಿಲ್ಲ ಅಲ್ರಿ? Honorable court by order dated
16/11/22 ಆರ್ಡರ್ ಆಗಿರೋದು ಸರ್.
respondent on the claimant to withdraw that amount deposited by pending vehicle of enforcement made by the tribunal after the respondent who has produced the document entity, the amount deposited by the appellant owner in terms of the enforcement.
ಕೇಸ್ ಆಫ್ ಡೆತ್ ಇದೆ ಸ್ವಾಮಿ, ವೈಫ್ ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇತ್ತು ವೈಫ್.
ಏನ ರಿಲೀಸಿಂಗ್ ಆಫ್ ಅಮೌಂಟ್ ರಿಜಿಸ್ಟರ್ ಮುಂದೆ ಹೋಗ್ತಾ ಇತ್ತ?
ಅಲ್ಲ, ಅದರಲ್ಲಿ ರಿಲೀಸ್ ಆಗಿದೆ ಸ್ವಾಮಿ, ಪೋರ್ಷನ್ ಆಫ್ ದಿ ಅಮೌಂಟ್. ಆಸ್ ಪರ್ ದಿ ಟ್ರಿಬ್ಯುನಲ್ ಡೈರೆಕ್ಷನ್, my lord, sum of rupees 1,29,000 was kept in FD in the name of the first respondent before in the Karnataka Bank. That, my lord, for the release of that amount, my lord, for the application, IA 1 of 24. 1,29,750.
ಎಲ್ಲಿ ಯಾರು who has directed to deposit in that bank?
By the tribunal, my lord. ಟ್ರಿಬ್ಯುನಲ್ ಅವರು ಹೇಳಿದ್ರು FD ಇಡ್ಲಿಕ್ಕೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು, ಅದ್ರ ಪ್ರಕಾರ FD ಇಟ್ಟು ಬಾಕಿದನ್ನ ರಿಲೀಸ್ ಮಾಡಿದ್ರು. Therefore, my lord, filed the application.
FD ಇಟ್ಟಿದಾರಲ್ಲ,
FD ಇಟ್ಟಿದ್ದಾರೆ.
3 years ಆಗ್ಲಿ. FD will not release.
From the date of the tribunal order ಅಂತ ಆದ್ರೆ 3 years ಆಗೋಗುತ್ತೆ ಸ್ವಾಮಿ. From the order of the tribunal.
ಡಿಪಾಸಿಟ್ ಇಟ್ಟಿರೋದ್ರಿಂದ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ 3 ವರ್ಷ ಆಗ್ಬೇಕ್ರಿ. ನಿಮ್ ಆರ್ಡರ್ ಆಗಿದ್ರೆ ದುಡ್ಡು ಹಿಡ್ದಾನೆ ಸುಮ್ನೆ ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ಏನ್ ಪ್ರಯೋಜನ? ಇಟ್ ವಿಲ್ ಬಿ ಇನ್ ದ FD, ಇಟ್ ವಿಲ್ ನಾಟ್ ಗೋ ಎನಿವೇರ್. ಈಗ ಅದನ್ನ FD ಹಾಕಿದಾರ?
FD ಗೆ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಒಟ್ಟು ಎಷ್ಟು ಕಟ್ಟಿದ್ದಾರೆ ಇಲ್ಲಿ?
ಒಟ್ಟಿಗೆ 6,70,000 ಕಟ್ಟಿದ್ದಾರೆ.
6,70,000 ಕಟ್ಟಿದ್ದಾರೆ.
ಹೌದು.
6,70,000 ಎಷ್ಟು ರಿಲೀಸ್ ಆಗಿದೆ ನಿಮಗೆ?
ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಮಲಾಡ್ ಸಮ್ ಆಫ್ ರುಪೀಸ್ 3 lakh.
ಒಟ್ಟು ಎಷ್ಟು ರಿಲೀಸ್ ಆಗಿದೆ ಹೇಳ್ರಿ? ಒಬ್ರೇ ಅಲ್ವಾ?
ಇಲ್ಲ, ಇಬ್ರು ಇದ್ದಾರೆ ಸ್ವಾಮಿ.
ಇನ್ನೊಬ್ರು ಯಾರು?
ಡಾಟರ್ ಮಲ. ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ 3,89,250 was ordered to be released. ಇನ್ನ ರಿಮೈನಿಂಗ್ 1,29,750 was in the FD.
ಅವರಿಗೆ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್
ಗೆ ಪೂರ್ತಿ ರಿಲೀಸ್ 1,41,000.
ಟೋಟಲ್ ಎಷ್ಟಾಯ್ತು ಈಗ?
ಈ 3, 4 it comes to about 5 lakhs ಮಲ.
5 lakhs ರಿಲೀಸ್ ಆಗಿದೆ. ಒಟ್ಟು ಅವಾರ್ಡ್ ಆಗಿರೋದು ಎಷ್ಟು?
ಅವಾರ್ಡ್ ಮಲಾಡ್ 10 lakh 12 lakh ಮಲಾಡ್ 12,70,000.
ಅಲ್ಲಿಗೆ
50% ಕಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
50% ಕಟ್ಟಿದ್ದಾರೆ. ಇಲ್ಲಿ ಇರೋದು ಪೂರ್ತಿ ರಿಲೀಸ್ ಆಗಿದೆ ಈಗ?
ಇಲ್ಲ, ಇದರಲ್ಲಿ ಇನ್ನೂ 1,29 ಇದೆ ಸ್ವಾಮಿ.
ಎಲ್ಲಿದೆ?
FD ಇದೆ.
ಅಲ್ಲಿ FD ಬಿಡ್ರಿ. ಡಿಪಾಸಿಟೆಡ್ ಇನ್ ದಟ್ ಟ್ರಿಬ್ಯುನಲ್ ಇಸ್ ನಾಟ್ ದೇರ್ ನೌ.
ಹೌದು.
FD ನ wait for 3 years, then we'll direct it to release. Now anyhow you have really withdrawn that 5 lakhs. Yes.
ಫ್ಯಾಮಿಲಿ ನೆಸಿಟಿ ಮಲಾಡ್.
ಆಯ್ತು, ಎಲ್ಲೂ ಹೋಗೋದಿಲ್ಲ. Where is that appellant? Why that owner has been held liable?
That just purchase in the goods vehicle. You have it, insurance company has been exonerated. ಇನ್ನೊಂದು ಕೇಸ್ ಪೆಟ್ಟು ಮಾಡ್ಕೊಂಡು ಬಿಫೋರ್ ಲೋಕದಲ್ಲ. ಇದೊಂದನ್ನ
ಒಟ್ಟು ಎಷ್ಟಿದಾವೆ? 2 ಇದಾವ?
ಒಂದು ಸೆಟ್ ಆಗಿದೆ. ಸಂಬಂಧ ಇರೋದು ಇದೊಂದು ಮಾಡಿ.
Yes, who is that counsel?
CM Venkatareddy. That FD malad was going to mature on 16/11/22 ಅಂತ ಹೇಳಿದ್ದಾರೆ affidavit ಅಲ್ಲಿ. 16/11/22 ಗೆ ಮೆಚೂರ್ ಆಗುತ್ತೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. That amount was malad deposited before this honorable court malad on 7/2/2020. 2020 ಲೇನೆ ಅವರು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ ಅದು ತೋರಿಸಿ.
ಅದು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇರುತ್ತೆ.
If it is matured, you can release. That ಯಾವ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದೆ?
7/2/2020 ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ. ಆರ್ಡರ್ ಶೀಟ್
ಅಲ್ರಿ, ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಯಾವತ್ತು ಇಟ್ಟಿದ್ದಾರ್ರಿ? ಫಿಕ್ಸೆಡ್
ಅದು that is not forthcoming here. But in affidavit ಅಲ್ಲಿ malad stated it is going to mature on 16.
You verify in that office when it is kept in that FD, then we will permit. If it is matured, we will permit you to withdraw.
Maybe call next week.
Next week. None appear for the appellant. Leave this matter next week.
47 VC Sitaramara for appellant.
Malads, in respect of respondent number 1, Malads, Samyukta Karnataka, Bangalore edition.
IA 1 of 2024 filed by the appellant seeking permission. Take out notice to respondent number 1 by way of paper publication in Samyukta Karnataka Kannada Daily Newspaper, Bangalore edition. For the reason stated in that accompanying affidavit, IA is allowed, permitted to take out notice to R1 by way of paper publication, Samyukta Karnataka Kannada Daily Newspaper, Bangalore edition, on or before
30th September,
hearing date
29th October. Serial number 48, Girish B. Baladare for appellant, R. Jaiprakash.
Appear for appellant, my lord. Substitute service for notice to R3 by way of paper publication, my lord. Hosadiganta Daily Newspaper, Chitradurga District Edition.
Notice to R3 by paper publication, Hosadiganta Daily Newspaper, Chitradurga District, on or before
1st October,
hearing date
30th October.
Yes.
Serial number 49, Girish B. Baladare for appellant, this is Shivanegowda.
Yes, I agree for the response.
Kindly TCR may be called for, my lord. It's a case of injury.
One TCR.
Petition dismiss ಆಗಿದೆ.
ಬೇಕಾ?
Petition dismiss ಆಗಿದೆ.
There is a delay of 19 days. Content 1 of 19 is allowed. How to admit?
Much of it.
TCR.
Admit ಆದರೆ TCR ಬರುತ್ತೆ.
Serial number 50, Nagaraja Reddy D for appellant, Vidya Rao S. Serial number 50,
Ready? Yes, pass on. Yes, Mr. Reddy.
84 days delay.
What is that matter?
Records ಬರ್ಲಿ ಸುಮ್ನೆ the medical bills not have been given for 2,53,000. ಅದ್ರಲ್ಲಿ 50,000 3,000 ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Delay of 84 days. Don't, one of 19 is.
ಡಿಸಬಿಲಿಟಿ ಕಡೆ ಬರೀ 18% ತಗೊಂಡಿದ್ದಾರೆ. 62% ಇದೆ ಸರ್. ಪ್ಲೀಸ್.
Number 51 adjourned, cell number 52, Geeta R for appellant.
51 ಅಲ್ಲಿ 51 ಅಲ್ಲಿ 48 days delay is there. Delay condoned.
Adjournment ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಇದೆ ಅಂತ ಹೇಳಿ.
ಇನ್ನೊಂದು ಕನೆಕ್ಟೆಡ್ ಇದೆ, ಅವ್ರದೊಂದು ಇದೆ ಅಂತ ಅದ್ರ ಜೊತೆಗೆ ಹಾಕಿದೆ.
ಇನ್ನೊಂದು ಅದೇ 50 of 2020 ಮಾಡೋದು.
Yes, next week.
Serial number 52, Geeta R for appellant.
Taking out paper publication.
Notice to R2 by way of paper publication, Vijayawani, Bangalore edition, Kannada daily newspaper. Hearing on
1st October.
On or before? On or before?
On or before 1st October.
Hearing date?
Date 30th October.
Yes.
53, PC Sitaram Rao for appellant.
In respect of respondent number 4 and 5 minutes, Samyukta Karnataka Chikmagalur edition.
Permission to take out notice to respondent number 4 and 5. Samyukta Karnataka Kannada daily newspaper Chikmagalur edition. On or before?
On or 30th September.
Hearing date?
29th October.
Yes.
Serial number 54, Nayak NR for petitioner.
I beg to appear for petitioner. I have filed review petition, my lord. This honorable court partly allowed the appeal, my lord. And my lord, I have approached the DRT, but DRT dismissed, my lord, the claim made by me because only you have to raise all the dispute before civil court. Therefore, my lord, instead of sending me to DRT, my lord, kindly maybe direct me to approach civil court, my lord. Page number 33 of the order, my lord. B. It is made clear if the plaintiff approach the debt recovery tribunal, the tribunal is directed to consider the case of the plaintiff in accordance with law without being influenced observation made in the order. Instead of debt recovery tribunal, my lord, because I have completely paid and discharged my loan, my lord, that, my lord, they are denying. Now they themselves issued the intimation to the authorities, my lord.
No, now that trial court has held that civil court has no jurisdiction.
That is, my lord, based on the Surface Act, my lord. But my case is entirely different, my lord. I have cleared the loan. They themselves informed to the banker authorities, stating that he has cleared the loan. But still now they are denying, my lord.
Where is that order passed by the DRT?
DRT, my lord, page number 135, my lord.
Only the 135 page.
Order copy this one. The order passed by the DRT, my lord.
Ellide?
135, my lord.
Irade 50 page 135 already.
Page number 16, my lord. Order passed in SA 263 2012, my lord.
SA?
SA 263/2012, my lord. They are denying their endorsement, my lord, which is communicated to my employer, my lord.
Ruling, I must examine measure taken by the bank in the case and receipt of the demand notice and the position or admitted fact, all the provisions of the act rules made under accompanied by the. Hence, I do not find any illegalities in the input notice by the respondent. Financial institution, as such, appeal is dismissed. No, it is dismissed on the merit.
Yes, madam. Pertaining to the my lord, therefore I have approached the civil court, my lord, because I have to sought for declaration. I have sought for declaration to prove that I have entire amount has been paid. Now subsequently, they have issued under Surface Act notice to take possession of the property, my lord. Therefore, I went to the DRT, my lord, and they are not considering my facts. I have to I have raised before the civil court, and once again it is dismissed as if Surface Act is not applicable.
See,
But my contention before the trial court, my lord, declare that I have cleared the loan.
No, you have to prove before the surface.
Because they are not considering their document itself, they are not
If they are
considering, my
not
lord.
considering, we are not responsible, mister. You go and file an appeal. If that order is wrong, you go and file an appeal before that appellate authority, DRT. You can't say that since they are not considering, you are no. Trial court has rightly passed an order. Your petition is not maintainable. It is hit by that DRT Act. Now DRT has decided on a merit. If it is wrong, you file an appeal. You can't say that for an order has to be recalled. Nothing wrong in that.
My humble request, my lord, the
no.
matter kindly may be remanded for to prove that whether I have paid money or not, my lord.
No,
Because
that is
Surface Act applied and dismissed my suit. Therefore, that particular observation, my lord, it is needed.
Mr. Nayak,
Please,
even if you are cleared the loan, then also if they are issued a notice under Surface Act,
yes,
you have to go and demonstrate before the tribunal saying that even after completion they have issued a notice, it is wrong. But tribunal has decided on merit. No,
yes.
Mr. Yes, nothing wrong in that. Yes, Mr. Naik. Yes.
That is appeal, my lord. Therefore, my lord, appeal. I
You
have
file
to
an
go.
appeal, Mr. This
Please,
DRT order is passed before I have passing
Yes,
that.
yes, my lord.
Yes, then yes. This is not any subsequent event. Yes. This revision delay na ridya. Yes. There is a delay of 42 days in filing the revision petition. Delay is controlled. This petitioner sought for reviewing that order passed by. This court in RFA number 1582 of 2016, dated 3 January 2024. There is no error apparent on the face of the, we have gone through the judgment. There is no infirmity nor error in the judgment, jurisdictional infirmity or error in the judgment dated 3rd January 2024. They have not made out any ground for recalling that order. Accordingly, review petition is dismissed. Yes.
Number 55, Satish TS for petitioner. Vinayak S. Pandit.
Kindly pass on, man.
For the respondent.
Pass over.
Pass on.
Short date then, my lords. I'm not going to, if I may, my lords, I would suggest that their only contention is that the parties have not been heard. Notice issue agilla LRs ge anta. If it is on that very short point, my lords, I may not have anything to object.
We'll send it back.
It may be remanded back to the DC. I will not argue on merits or anything.
Yes, what is that? You are a grantee or a purchaser, Mr.
He is a purchaser from me, my lords.
You are the purchaser.
He is a purchaser from me. My father was the original grantee.
You are the grantee.
Yes, my lords.
Yes. When it is granted?
1971, my lord. Sagoli chit is issued in 1982.
Grant is 1971.
Yes, ma'am.
When you have sold?
Just a minute, madam, I'm sorry. Just a minute, madam. 1961, my lords, is the grant. 1972 is the sale.
Sale.
Yes, my lords.
What is the order of the DC, AC?
AC rejected my application under section 5, my lords. DC, however, has allowed it based on the amendment to the section 5 which was brought in 2023, my lords. Limitation period ಯಾವುದು ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಅದನ್ನ observe ಮಾಡಿ. And also, he has also observed.
Who is that respondent before the DC?
He's the purchaser from me, man.
He has been made as a party.
Yes, my lord.
Then
he
he was
away.
dead.
He passed away. Thereafter, we did
Dead
not know
Ramaya
that-
is dead.
Yes, my lord.
Who is that Timmaya?
Timmaya is also dead. Timmaya is also dead. Ramaya is also dead.
Both of them as dead.
Yes.
When they have dead?
My lord, we have submitted in the order sheet. It is forthcoming that we have said we don't know the whereabouts of the LRs. Now the LRs are before this court, before my lord.
When he has dead, Mr. Timmaya and Ramaya?
My lordship, my senior has to come and hear them.
Yes, ask him, we will dispose of password.
Password, my
2:30 minutes.
2:30, yes.
Much obliged.
B group matter, serial number 56 urgent, serial number 57 Gangadharappa AV for petitioner.
In serial number 56, my lord, there is interim order, my lord. And my lord, in this case, actually, my lord, on last occasion, 6/8/2024, we requested and my lord was pleased to grant. But in the order sheet, we could not notice it. My lord.
No, that, see, your councils are seeking extension of interim order. Before signing, I will verify the records. Earlier occasion, 2-3 times, if it is not extended, we are not extending here, because when you are mentioning, we are not opening the file, you are granting, we are saying that interim order, if any, is extended. But we'll seeing that records, if it is not extended earlier, I can't extend it. If that would be the case, we are not extending that.
Here, one time it is not, my lord. From the beginning throughout it is, one time it is not.
That is that there is a break. Then I can't extend that interim order because there was no interim order earlier.
I'm sorry, my lord.
Only thing is that you have to file a first application.
Please,
Yes, then we'll consider that.
please, my lord.
Yes.
Serial number 57 Gangadharappa AV for petitioner.
Yes.
P. Ashwatthaya.
I may have to seek amendment of the writ petition.
Same, on the same ground. Yes. At the
Interim matter
request-
may kindly be extended.
At the request of counsel for the petitioner, leaves this matter after 2 weeks. Interim order, if any, extended till next date of it.
Yes.
Serial number 58 N. Vishwanatha for petitioner.
My lords,
Srinivasaya.
I seek for a week time, my lords. I'm the proxy counsel, my lords.
Why?
My lords, the advocate on record is unwell.
Unwell.
Unwell, my lords.
Yes, at the request of counsel for the petitioner, leaves this matter next week.
Obliged, my lords.
Serial number 5960 urgent, serial number 61 Madhusudan M.N. for appellant, connected petitioner, connected matter Prakash M.H.
Yes, my lord, in connected matter, they have not served the copy, my lord.
Only has drops.
Yes,
In
what
fact,
do you want? Ready?
No, connected matter, I want to see, my lord. This matter I am ready.
Next week.
Date may be fixed, my lord.
Yes, at the request of counsel for respondent in 22050 of 2024, is this matter next week.
My lord, date may be fixed.
Next week, another next week, Bharat.
But what happening in the last occasion also I have submitted, taking note of the interim order granted, wherein we were abstained from their allegation is that we are interfering insofar as their possession is concerned. They are cutting and removing the trees. In fact, the government advocate has also submitted to this extent.
Yes.
That
May-
let them not precipitate the things. That's my request, because it's only thing that the appellate authority has passed an order, though they have,
No, you are a grantee or a purchaser.
Yeah.
I am a purchaser, my lord.
You are the grantee.
My lord, in this
They are
case,
the grantees.
PTCL will not attract because it is, they have purchased for upset price, my
Lord,
as
in-
per BK Munraju case and my lordship judgments are also there. I'll produce those also, my lord.
Lord, this issue was arisen last date of hearing also, my lord. If it is a crop, my lord, that is no issue.
No, now that, is it a condition is applicable?
Lord,
What is the date of the grant, mister?
My lord,
date of the
grant
grant is
1955, my lord.
What is that 1955 condition?
ಹೇಳ್ತೀನಿ. And moreover, I am the ninth purchaser, my lord. In Assistant Commissioner's order, they have not even made the parties of 8 purchasers, my lord.
That is immaterial.
Oh, much.
1955 ಎಷ್ಟಿದೆ ರೀ?
15 years.
15 years. Upset price?
Upset price 5 rupees, my lord. Next,
10 ವರ್ಷ.
55 ವರೆಗೆ 20 years ಇದೆ. 55 ವರೆಗೆ.
No, 53 ಇಂದ 55 ವರೆಗೆ.
20 years.
No, 20 years.
ಹೌದು.
55 ಇಂದ
55 ಇಂದ ಕೆಳಗಡೆ ಅದು.
ಅದು ಇದು.
No, 53 ಇಂದ 55. ಇದು ಯಾವತ್ತು ರೀ?
ಇದು 55.
Date ಕೊಡ್ರಿ.
13/6/55, my lord.
13/6
Covered under that 20 years, my lord.
20 years.
ಹೌದು.
When it is sold?
6/4/1964.
61 ಇಂದ 61 grant
ಹೌದು.
Grant ಯಾವತ್ತು ರೀ?
Grant 55
grant.
Grant
And it was sold on 6/4/1964.
AC order
9 years.
21.
65 within the
52
time.
years delay ಬರುತ್ತೆ.
My lord, I am the ninth purchaser. My purchase is on
Lord.
99, my lord.
ಅದು ಬರೋದಿಲ್ಲ ಇಲ್ಲಿ ಪ್ರಶ್ನೆ.
And
Your
he
vendor
has
itself has
paid-
now better title.
He has paid the upset price, my lord.
Upset price 20 ವರ್ಷ ಇದೆ.
Lord, only one request is that, my lord, the tree it will be for like more than 20 years, 30 years,
What is the
50
date of
years.
filing in application?
Application file ಮಾಡಿದ date ಬಂದ್ಬಿಟ್ಟು
In
21 ಅಲ್ಲಿ AC
21,
decide ಮಾಡ್ತಾರೆ.
15, my lord.
There is a belated approach, 15/3,
Then we have to wait for
1921.
that
Sir,
constitutional
I
validity.
know it, sir. Till then, let them not perceive, insofar as this issue is concerned, let them not cut and remove the trees. That's all.
What is that, Mr.?
My lord, they have only cut the trees. We have not yet removed. For that, we have to file an IO because
In
now
fact,
ಅದೆಲ್ಲ ಗೆದ್ಲಿಡಿತಾ ಇದೆ. ಮಗ ಎಲ್ಲ ಕಟ್ ಮಾಡಿದ್ದಾರೆ.
Tahsildar himself has conducted the measure. Information can be secured by my learned
No,
friend.
now that tree is already cut.
Already cut, my
Some
lord.
of the, and
If it is cut trees, that can be, but he cannot cut further. That is
Please.
what.
Yeah, that I'm,
Please,
I'm,
Alan,
He will also undertaking, he will not do it.
even.
I
even
may- I
the
will
cut
undertake.
trees cannot be, even the trees which are the fell and cut cannot be subjected for any further
Why? He can, because he is the owner.
subsequent to passing of the orders by the authorities, my lord.
Now it is
there.
betting that, see,
It
when
is done.
when he says that he is entitled for taking the crop, this is also.
Let them take the crop.
No, this is also a crop which is grown
It's
by
not
them.
crop.
ಇಲ್ಲ ಅದು ಇಲ್ಲ ಕ್ರಾಪ್ ಬರೋದಿಲ್ಲ. ಯಾಕೆ ಅದೇ ಹೇಳ್ತಾ ಇರೋದು ನಾನು. Tree, it will be grown from
If that
60 years,
tree
20
which
years,
has been
10 years.
grown, which has matured,
ಹೌದು.
ready for cut, he can't wait because
ಇಲ್ಲ.
tomorrow if he succeed, who will give that loss?
ಇಲ್ಲ.
See, only thing is that to take an advantage, even though tree is not matured,
Yes,
if he is cut,
Tree
then he can't.
ಟ್ರೀಗೆ ಮೆಚುರಿಟಿ ಪ್ರಶ್ನೆ ಬರೋದಿಲ್ಲ. ಏನಕ್ಕಂತಂದ್ರೆ
There is a maturity, mister. You can't cut it.
no,
You have to
even
take in a
even
permission
after
from the
even
forest department
So
to
far
cut
as-
the trees for, if it is matured, they only
So
get.
far as Silver Oak is concerned, if it is a coffee estate, my lord, so there will
Silver
be a
Oak.
gradual.
ಬೇರೆ ಇದು
But
ಇವು
what they
ನಾರ್ಮಲ್
are
ಟ್ರೀಸ್
removing
ಇವೆಲ್ಲ.
is the, I mean, the forest wood.
Forest to take permission ತಗೊಂಡ್ಬೇಕು.
ಅದೆಲ್ಲ ಏನು ಮಾಡಿಲ್ಲ.
My lord,
Iಲ್ಲದ್ರೆ it's an illegal.
Anyhow, it is
My lord,
it is
Now
subjected
he
for
is
the
not doing that. Why do you-
anyhow, it is subjected for the outcome of the order.
Now
within
he
the-
is saying that he will not cut the tree.
Yes,
Yes,
that can be.
yes.
my lord, interim order may be extended
Interim order granted earlier is extended.
and permit me to lift the trees which have cut down, my lord.
ಇದನ್ನ
That is in accordance with law. You have to get a permission from that forest department.
My lord, that was not cut by me. That was cut by them. After the interim order, they have cut the trees.
No, if that is the case, there is a procedure. Forest department ಅಲ್ಲಿ permission ತಗೊಂಡು cut ಮಾಡಿ liftige, they have to take in a license. It is not like that, mister. It is in a 5 road, you can take it and all. There is a procedure for lifting that, this thing. You
Much
apply for the forest department and take that.
Much obliged.
Yes,
My lord, date may be fixed, my lord.
yes. Now that matter has to be heard only after that constitutional validity has to be
Yeah,
decided.
that's.
ಯಾವತ್ post ಆಗಿದೆ 13ಕ್ಕ?
ಇವತ್ತು ಪೋಸ್ಟ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಇಂಪ್ಲಿಮೆಂಟಿಂಗ್ 13ಕ್ಕೆ ಡಿಸಿಷನ್ ತಗೋದು. 13ಕ್ಕೆ.
Yes, leaves this matter. On 20th, let us see what will happen on this.
Much obliged.
Bill number 62, Chandan K for petitioner, M. Muni Krishna.
ರೆಕಾರ್ಡ್ ಬರ್ಬೇಕಿತ್ತು, ರೆಕಾರ್ಡ್ ಬಂದಿಲ್ಲ.
Report number 1 to 9.
Hmm.
Best time to file the objection.
My lord, in this case, the issue is with respect to the new amendment, 2023 amendment, based on which the land has been restored to the grantees. My lord, now it is covered by the judgment of this honorable court. I would like to place it on record, my lord. Lord, may be pleased to have it.
No, this we will see, because constitutional validity, no, petition itself is pending.
No, with respect to constitutional validity, the petition is pending. That is also observed in this particular judgment, my lord. But what the learned court says, my lord, I would like to take your lordship to
No, I
page
have
7.
seen that. I've seen that.
Yeah,
See,
basically they say that the amendment does not change the status of the law laid down by the apex court.
let us see that itself is pending for consideration. Even division bench matters pending before that first court is also not taking that.
Okay.
Since that matter is pending before the single judge, validity itself has been challenged. We have to wait for that. Now that you are also taking the ground on challenging the validity.
My lord, in this case, I have not challenged the validity
Is
of.
there any delay in filing an application?
Yes, my lord, 36 years, my lord.
Then we will wait for that judgment.
Because we can wait for the judgment, but what I'm saying is here the case is, let me say, my lord, the amendment is held as valid.
Otherwise, you see, nobody need not challenge the constitutional validity. If
In
it will
this
not
case,
take any
true.
changes now. Now, thousands of cases, advocates are challenged, senior counsel has argued. Now it is for that advocate general sits waiting. Therefore, we will wait for that.
My submission, just to make a submission, my lord.
Yes.
Let us say, my lord, the eventuality that it is held as valid.
Yes.
Let us say it is held as valid.
Yes.
Even then, my lord, reading at this judgment, that will not alter the fact that delay and latches has to be looked at in a different manner.
That would be the case. Why in 1,000 cases lawyer has challenged the constitutional validity? I am asking. One of your friends has challenging that.
Yes, my lord, I
Not
have challenged
not
it.
make any changes. Then why you are challenging and the matter has been pending for that?
Now, my lord, the division bench having said that it would
No, I have
not,
seen that.
it would not alter the law laid down by the honorable apex court
Now,
in the case of
see,
Nikanti.
yes.
That is what the division bench has held.
Bench validity was not been under the question.
No,
But their court has expressed that it will not make any changes.
it would not make any, because even if it is tomorrow, it is held as valid also. This judgment of the division bench would be applicable even in that case also, for
No,
the
it is
reason
not
that
binding on the learned single judge. Why?
single judge also
I
in
will
that
say, my
matter.
lord, why it is not
Because
binding?
even
my lord.
let us say, my lord, for the sake of argument, the learned single judge says that the amendment is valid. Even then, this division bench judgment would have to be upheld and would have to be taken into consideration for the reason that
Non-learned single judge may interpret and says that, yes, in view of this amendment, then all application which can be filed, there is no limitation, can be entertained. If it will be different things, we have to wait for that. How that advocate general will address the arguments and convince the court, we have to see that.
But why I have moved this based on.
Because they have, in the amendment, they have considered that Supreme Court judgment also.
That is also been observed here, my lord. That is also been observed by the division bench, my lord. At paragraph F at page 10, my lord, what the division.
Draftsman has not properly drafted that
My lord,
legislation.
for the sake of submissions, my lord, what the learned, the division bench has held is, it may be true that the legislative debates might have taken place about the observations of the apex court in Nikanti and other such cases while passing the amendment
What
bill.
the division bench held, even earlier also there was no limitation.
Yes.
Now also they said.
There is no limitation.
By legislation, they said that there is no limitation.
They have only confirmed what was their situation earlier.
Clear.
And my lord, the division bench has further gone ahead and said,
Let
the
us see.
reasoning why delay latches and because
Not that advocate general will address the arguments to convince the court. What is the purpose for amendment? Let them see that. If they're really taking out the judgment of the Supreme Court, that
the language should have been much better than this. But even otherwise, my lord, let us say
they
would have
said that there is no delay. That was also not there earlier. Supreme Court said that when there is no delay, this is the thing.
My lord, the Supreme Court had considered all those things in Nikanti's case and had said that if the statute prescribes, then there is a specific amount. If the statute doesn't prescribe, then we will have to look three aspects. One, delay, latches, and acquiescence. So
No,
the
ultimately,
relief was
Supreme
basically
Court
based
said,
on equity.
if the legislation has not said any limitation, it should be reasonable to approach. That is what that.
That is what. Now, my lord, a legislature cannot grant legal remedy to a person.
Now that how Advocate General says, if you are not fixed that limitation, then all judgment of the Supreme Court said if it is reasonable, how we will get over from that judgment? Let us see how we will learn.
Lord, what I would like to say is a legislature cannot grant a person legal remedy for eternity. You can come at any point of time, 100 years, 200 years afterwards also, you have a legal remedy. That cannot be possible even for the legislature to do that. You will have legal remedy for eternity. You can come at any point of time. That might not be an issue. That might be the issue that has to be considered.
That maybe they can say that, see, by operation of law, sale become void. That provision has been upheld by Supreme Court, constitutional validity. That means to say, the person who has purchaser is in unauthorized position.
Well, that's what, my lord. But a legal
land
remedy
is vested with the government. On the day by operation of the act, land is vested with the government. They are the unauthorized occupation. That's why they said that we can recover that position by at any time. But the way that legislation they have made it.
No, my lord, there are two aspects, my lord. One, land vesting with the government by operation of law, one aspect. Second, legal remedy provided to the grantee are their legal heirs to get the land restored to them. These are the two separate aspects. Now, the legal remedy for the land, for the grantees or the LRs of the grantees to get the land restored to them, can that legal remedy be for eternity? That is the question to be answered. That's in my opinion.
Other thing is, person who is in the possession has no title. You have no title because of operation of section 4 and 5.
Then it is for the
sale become void.
Sale might become void, and it is for the government to take action, take the land, attach the land.
They are saying that it's a government property. You are asking him to give it for legal heirs or LRs. If nobody is there, they said that it has to be distributed to that community of.
Probably for that, the language should have been much better.
Let us see, it's all for the state.
Well, one submission why I have moved this matter and come before your lordship is, even after there is an order of status quo by your lordship, there has been disturbance from the grantees and the LRs of the grantees, from the respondents.
Because admittedly, purchaser is in the position because their application itself is restoration.
What they did, my lord, recently a coordinate bench of this honorable court has said, though there is an order for restoration of land, revenue entries has to be mitigated under the provisions of 136, 128 itself. That is the order.
No. After that order, you see the rule, possession has to be taken under section 39 of the Land Revenue Act.
39 of the Land Revenue Act.
Procedure is that notice has to give.
Yes.
Measure has to be drawn, then possession.
Yes. Now in this case, my lord, they have gone ahead and got the revenue entries mutated in their name based on this order.
Yes.
Based on that mutation of revenue entries, they are disturbing us on a daily basis. That is the reason I am before this honorable court.
Now we have granted status quo.
Status quo is granted, but let there be further direction. Let them not interfere based on the revenue entries that they have in their name, my lord.
No, if your status quo is there, if they are interfering, they are committed a contempt of this court order.
I will proceed in accordance with.
I make my submission, my lord. They himself obtain the order of status quo. They continuously develop the farm layout.
They are in the possession.
My lord.
Admittedly, you sold the land to them.
No.
By filing an application.
I am not sold the original grantee, not sold this subsequent purchaser. They sold the earlier.
Ultimately, you sold the land. What is that application under section 4 and 5? Restore the land to me. That means to say you are not in the possession. Is it not?
Yes, my lord. Already revenue entries, revenue department carry out the names of the purchaser. Now revenue documents standing in the original grantee.
Revenue entry standing, but possession has been taken as per section 39.
Order the petition also obey the court order, my lord.
No, is there any order under section 39 to take the possession?
Because what is the
very same act which has given power to restore has said that how to take a position.
Yes.
Because
new contempt.
Petitioner is the
Much
developer,
obliged,
my
lord.
lord.
I will proceed and return.
Petitioner developer. Petitioner is a developer. Then the company sold out the property. What is the remedy for the original grantee?
Let us see that. Yes.
Much obliged.
Yes. Leave this matter 2 weeks.
Final hearing matter. Serial number six.
Section, my lord, the interim order to continue, my lord.
Interim order granted earlier is extended till next date of hearing.
Much of it.
Final hearing matter, serial number 63, Mastaq Ahmad for appellant.
The case of
Defend the
injury, my
following.
lord. The tribunal has awarded 50,000,
Yes.
51,610, my lord. The injuries suffered by the doctor has not been examined, my lord.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
51,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹಾ?
51,610.
ಏನು ಇಂಜುರೀಸ್ ಏನಿದೆ?
Injuries, my lord. Page 9 of the judgment, my lord.
Hmm.
Para 12.
Yes.
Third line.
Hmm.
Which is true copy of the wound certificate. It's mentioned that the petitioner has sustained tenderness over hip joint, swelling over the right foot, unable to lift right leg, and second, third, fourth metatarsal bones, right foot dislocated at transmitter, tarsal joints, exhibit P7, which is the discharge card. It has been mentioned that petitioner has sustained dislocation of right foot. These are all the injuries suffered by the claimant.
Right, left leg. Where is that Dabali used to come? ಆಯ್ತು, ಎಷ್ಟು ಕೊಡ್ಬೋದು? 51,000 ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ.
1,000. Pain and suffering 30,000 has given.
ಹ್ಮ್.
Traveling
20,000
attendant.
ಕೊಡ್ಬೋದು ಎಕ್ಸ್ಟ್ರಾ.
My lord.
ಇನ್ನೊಂದು 20,000 we can give that pain and suffering. Loss of immunities ಕೊಟ್ಟಿಲ್ಲ.
Yes.
Disabilities you have not examined the doctor.
Not yet.
50. ಇನ್ನೊಂದು 40,000 ಜಾಸ್ತಿ ಮಾಡ್ಬೋದು. Yes, where is that Dabali? ಪಾಸ್ವರ್. ಅವ್ರ ಯಾರಿದ್ದಾರೆ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ? ವೇರ್ ಇಸ್ ದಟ್? ಹ್ಯಾವ್ ಯು ಸೀನ್ ದಟ್ Dabali ಮೇಡಮ್? ಎಸ್, ತಗೊಳ್ಳಿ. So and so learned counsel appearing for. The claimant has contended that due to that accident, claimant has suffered grievous injury. ಎಷ್ಟು ದಿನ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಇದ್ರಿ?
6 days.
He was inpatient for a period of 6 days. He has spent medical expenses of rupees 1,50,000 rupees. The overall compensation awarded by the tribunal, 51,610, is on lawyer side. Sought for enhancement of compensation. Per contra, Sri Dabali Learned Counsel appearing for the corporation has contended that injuries suffered by the claimants are minor in nature. He has not examined the doctor. He has spent only 1,050 rupees for medical expenses. Considering that evidence of PW1 and medical records, the overall compensation awarded by the tribunal is just and reasonable. Heard the learned counsel for the parties. Peruse judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 14/8/2014 due to rash and negligent driving of driver of KSRTC bus bearing registration number KA18 F434. Due to that accident, claimant has suffered the following injury. He was inpatient for a period of 6 days. He was spent 1,050 rupees for medical expenses. Considering that injury suffered by the claimant and medical records, I am of the opinion that the compensation awarded, in addition to that compensation awarded by the tribunal, 40,000 has been awarded with 6% interest. Yes. In view of order dated 12/12/2022, claimant is not entitled for the interest for a period of 275 days for enhanced compensation amount.
Serial number 64, Raghavendra EP for appellant, A. Ravishankar.
I am for the appellant, my lord, in this case. It's a case of injury, my lord.
Yes.
The accident is of 2013
Yes.
between the canter as well as the bus.
Yes.
My lord, on 8/11/2013 at about 12 p.m.
ಏನು dispute ಇದೆಯಾ ಮೇಡಮ್?
ಇಲ್ಲ, liability in dispute.
Then you argue on that this thing, Mr.
My lord, he
Quantum.
was inpatient, see, he was inpatient for 42 days.
42 days.
How do, my lord? 3 times he was admitted in the hospital.
Now, what is that income assessed by the tribunal?
9,000 has
Income,
already been
income,
taken.
ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ?
9,000 ತಗೊಂಡಿದ್ದಾರೆ.
Yes.
Notional income 8,000 ಇದೆ ಚಾರ್ಟ್ ಪ್ರಕಾರ 9,000 ತಗೊಂಡಿದ್ದಾರೆ.
Yes. Then
My
what
lord,
is that
he-
disability?
He is a professionally, he is a driver, and we have produced a driving license at exhibit P9. And his income was 20,000 as per the documents available.
What is that documents you have produced?
The documents and the driving license ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ ಅಷ್ಟೇ.
Driving license, it's
He
okay.
is a driver. He was driving the vehicle. It was a transport vehicle. So that clearly proves that he was a driver.
No, he was working under somebody else.
No, the vehicle belongs to his wife. He was
Yes.
driving.
Yes.
So 20,000 was the income, and it was attached to a company called Bombay Rayon.
Where is that discussion of the tribunal regarding that income, madam?
It is at paragraph number 19, my lords.
Yes, read.
To prove and substantiate the same, he has not produced any documents except his driving license marked at exhibit P9. In his cross-examination, he deposed that the said canter was standing in the name of so-and-so. And on that day, he was going to so-and-so situated at Channaviranahalli Road near Dodbalapur. He further deposed that he was using said canter for hire to a company. He further deposed that he does not know the name of the said company. Whereas in his examination in chief, he deposed that said canter was attached to Bombay Dynamic Fashions Private Limited, Dodbalapur, on contract basis. He has not produced any document to show that the said canter is standing in the name of his wife, and also it was attached to the above company. He further deposed that in leisure time, he was transporting agricultural goods on hire basis, but no documents are produced, not any independent evidence led in this regard. He also deposed that he has sold said canter, but no documents are produced in this regard. So in the absence of proper documents to show the actual income of the petitioner, this tribunal has to assess the income of the petitioner notionally. So taking into consideration the age of the petitioner and the accident took place in the year 2030, this tribunal has assessed the income of the petitioner at 9,000.
What about that disability, madam?
Disability, doctor, as your lordship would find it at in page, paragraph number
27.
26, 27, before paragraph number 28, about 4 lines above, my lords.
Yes. Whole body disability is
Yes.
29%.
29%.
but,
Already
the-
tribunal has considered 18%, my lords.
No,
So
that
that is also in dispute,
29%,
madam.
what is that disability? Him disability has not been assessed. Doctor evidence. ಕೊಡಿ.
The discussion
Well,
is
you
at
suppose-
20, paragraph number 29, my lords.
Yes.
May I read, my lords?
Yes.
Therefore, considering the nature of the treatment taken by the petitioner for the injuries sustained by him, he underwent two surgeries 2 times. Admittedly, at the time of discharge from the hospital second time, he was stable. Further, as admitted by PW2 doctor, the fractures are united and removed external fixator at the time of admission to the hospital third time. So considering these circumstances, the whole body assessed by the doctor is on higher side. Hence, taking into consideration the difficulties of the petitioner and his age and avocation, this tribunal has assessed the disability of the petitioner at 18% to the whole body, and it would meet the ends of justice. Therefore, for the above reasons and discussions, the loss of future earning capacity due to permanent disability works out to 18%. This is what has been considered, my lords.
My lord, he suffered fractures for the both legs, and by profession he was a driver. And due to these injuries, he will not be in a position to continue his profession of driving, and that has to be considered by this court. And also, the disability is assessed by a competitive authority, doctor, which has to be taken into consideration by this honorable court, my lord. The income of a driver who was driving a canter should be considered as 20,000, because we have produced a driving license, and his avocation is proved.
Disability 48.5 for one limb and 38.5. Then he said 29% for 1/3. The doctor evidence he has specifically given
what are that disabilities, how that he has.
He had a fracture of femur in both the legs, my
Yes,
lords.
yes, considered, and he said 29% is whole body. 1/3 he has rightly done, third of total this thing. Yes. Then how many days he was in the hospital?
42 days, my lords.
Request ಆಗಿದ್ರೆ, pain and suffering ಬರೀ 50,000 ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. And attendant charges also it was meagerly awarded.
Future medical expenses, loss of earning during.
Because
the time of-
already external fixators have been removed, my lords.
Okay, amenities. Yes, what is that interest? 9%.
9%.
Yes, that's all. Yes, mister, that's all.
Please, my lord.
Yes, ma'am.
As far as the income is considered, my lords, he has not placed any material except producing his driving license.
Yes.
That's all. So tribunal has already considered more than the
Yes.
as state prescribed in the chart.
So and so learned counsel appearing for claimant has contended that at the time of the accident, deceased was earning 20,000 per month as a driver. He has produced driving license. The tribunal has assessed notional income as 9,000 is on lower side. Secondly, he has contended that due to that accident, claimant has suffered grievous injury. He has examined the doctor as PW2. In his evidence, he has deposed that claimant has suffered whole body disabilities 29%. Tribunal has assessed whole body disabilities 18% is on lower side. Lastly, he has contended that due to that accident, claimant has suffered grievous injury. He was inpatient for a period of 42 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Compensation awarded by the tribunal for pain and suffering, loss of amenities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. Per contra, so and so learned counsel appearing for the insurance company has contended that even though claimant has claimed that he was earning 20,000 per month as a driver, except producing the driving license, he has not produced any document to establish the same. Therefore, tribunal has rightly assessed the notional income as 9,000. She further contended that considering that evidence of doctor and injury suffered by the claimant, the whole body disability is assessed by the tribunal 18% is just and reasonable. Lastly, she has contended that considering that evidence of doctor and injury suffered by the claimant and medical records, compensation awarded by the tribunal for pain and suffering, loss of amenities, other incidental expenses, just and reasonable. The interest awarded by the tribunal, 9% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, peruse judgment and award and original records. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 8/11/2013 due to rash and negligent driving of driver of the bus bearing registration number KA06C6238. Even though claimant has claimed that he was earning 20,000 per month as a driver and he has produced the DL, except that he has not produced any document to establish that he was earning 20,000 per month. Considering that evidence of the parties and material available on records, the tribunal has rightly assessed monthly income of the claimant as 9,000 per month. Due to that accident, claimant has suffered the following injury. He has examined the doctor. Doctor has deposed that claimant has suffered 48.5% disability to right lower limb and 3.5%. Stability component, basic method. Left lower limb. And whole body disabilities he has assessed 29%. Considering that evidence of doctor and injury suffered by the claimant, I'm of the opinion that whole body disabilities has to be assessed 29%. The multiplier applicable to that age group
15, my lords.
15. Accordingly, loss of future earning has been reassessed as follows.
9,000 into 12 into 15 into 29%, 4,69,800.
Due to the accident, claimant has suffered the above said injury. He was inpatient for a period of 42 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 50,000 to 60,000. Loss of immunities from 30,000 to 45,000. Loss of income during the later period. Tribunal 4 months kotidralla, same 4 months. Other head compensation awarded by the tribunal is just and reasonable. Enhanced compensation amount carries 6% interest. Delay there.
Yes. Bill number 65, Mohammed Sharif for appellant, Arini Shivananda.
Appear for the appellant in this case. my lords.
Yes.
I appear for the respondent, my lord.
Yes, madam.
It's a case of injury, my lords. The petitioner, that is the appellant in this case, had suffered grievous injuries and he was admitted in hospital for a period of 10 days, my lords. The doctor who has assessed the disability has given a whole body disability of 24% and he is a income tax assessee, my lords. Though he has produced his income tax returns.
Where is that?
Page number 13 of the judgment, my lords.
Yes.
Under the heading of loss of earnings during laid down
Yes,
period.
read.
The petitioner has stated in his evidence that at the time of accident, he was doing scrap business in the name and style of classic auto electrical works and earning an income of 22,000 per month. Now, due to the accident, he is unable to do the scrap dealer business and he incurred loss. In support of his evidence, though he has not produced any document with regard to his shop premises, he had produced his PAN card income tax returns for the year 2014 and 15, which are marked as Exhibit P15 and 16. These documents make out that he is an income tax assessee and his income for the previous financial year as Exhibit P16 is 2,43,632, my lords. As it is within taxable limit, he had paid tax only 2,890. He has not produced his income tax returns for the previous year or subsequent year. So his annual income can be considered as 2,40,000 and his income being bifurcated into 12 months, his monthly income is at 12,000 per month, my lords. So at the rate of 12,000 per month, the tribunal has assessed his loss of future income at 24%, my lords.
12 per month ತಗೊಂಡಿದಾರಲ್ಲ.
My lords, loss of future prospects has not been added. That
Why?
is,
What is the disability?
the disability is 24%, my lords.
Where
And
is
the doctor
that
has told that he requires to undergo revision, totally replacement, which will cost him 4 lakhs. And then also,
One by one we come that. Now that what is the disability assessed by the doctor?
doctor has assessed 24%, my lords.
Tribunal ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
The tribunal has taken 24%. There
What
is no
was he?
He was doing a scrap dealing business, my lords.
What was that injury?
Injury was, I'll tell you. Fracture dislocation of the right hip. Page number 11 of the judgment, my lords.
It's soft fracture.
Mid-shaft fracture right tibia, lateral malleolus fracture comminuted right ankle, bicolumn fracture right
Fracture
acetabular.
has been united, madam.
My lords, but the
United
disability,
ಆದ್ಮೇಲೆ ಎಲ್ಲ ನಾರ್ಮಲ್ ಆಗ್ತಾರೆ. ಇನ್ನೇನ್ ಅದ್ರಲ್ಲಿ ಏನಿದೆ?
my lords,
There is no
the-
future loss of income due to that.
no, there is not only that, my
The
lords,
loss of income they have given.
that has already been given. What I'm asking,
Future prospects, how it will be lost to that future prospects?
Because-
doing his work.
no, as a scrap dealing business, he has to run around a lot, my lords, for getting the business also. And then he has to sit and do the work also. Lot of bending work also will be there. With the disability, what he is suffering due to the right hip injury, what he has suffered extensively. And there is also other fracture of the tibia and all.
4% for the loss which is occurred, they have given. Prospects, future prospects, how it will affect?
Because-
You want to establish that any industry, because of this disability, he can't do it. That is all his future prospects are affected, then we can be added.
Yes, my
But
lords.
that is no evidence and document to show that.
With this medical evidence, what you have already produced, my lord, the doctor has
24%
already
they have
told.
considered.
The doctor
Income they
has
have
to-
rightly considered.
Yes, my lords.
Hmm.
The doctor has already told that who assessed the
Hey,
disability,
evidence, putting
page number 19 of the judgment, my lords.
evidence.
It is,
Doctor has said anything about that?
yes, my lords.
So it is submit the right.
The doctor was assessed the disability as stated.
That he
He has to undergo one more surgery.
totally unable to work, he has unable to knees, so and so.
Removal of implant 60,000 and then he has to
Not a
undergo,
treated doctor.
my lords.
He has not treated doctor.
He is one of the team of doctors, my lords.
I have not
Dr. Krishna
personally
Prasad.
treated the petitioner. I have not issued the wound certificate.
Yeah, he is from the same hospital, my lords.
I do not have the personal knowledge of the occupation of the petitioner.
Yes, my lords.
There are 7 of my evidence affidavit stated by the patient has been noted by me. Calculation sheets, so and so, even with regard to the assessment of stability appointment has not been, I have produced that. It is not correct to suggest that so as to help the petitioner, so and so. It is correct to say expense required for the future treatment hospital, it is not correct.
He has to undergo hip replacement surgery, my lords. And then revision hip replacement has to be done after a period of 15 to
Not done
20
any
years.
surgery for replacement of it, it is not correct to suggest that he has not undergone for the, this can't be. So need to be revised after 50 years, it's correct to suggest that fractures are now united. Correct to suggest that fractures are united, now he become normal, it is not correct to suggest that. Day of the petitioner, as he has scrap dealer, the injury sustained by me will not come in the way of his application. Petitioner has not come to the hospital for the assessment. How many days he is in that hospital?
10 days, 10 days, my lords. And he has to undergo
Suffering, they have
revision.
given 1 lakh.
Yes, my lords.
During the later period, they have given
60,000.
60,000.
5 months.
Medical expenses,
3,88,000.
3,88,000. Loss of future earning rightly given. Attendance charges, 15,000. Surgery cost 1 lakh they have given.
Yes, my lords. But he has to undergo revision hip replacement also. That will cost him, after 15 to 20 years, he may have to undergo one more revision hip replacement, my lords, which is narrated in the judgment, my lords.
Where is that? Has he stated what is the cost?
Yes, my lords.
Then estimation? Has he given
He has also
estimation?
needs to totally replacement on his right side, which will cost 4 lakhs. And he will
Finding
need a
mentioned in the disability assessment.
Yes, my lords.
So that removal of the right leg which will cost 60,000.
60,000, yes, my lords.
He has need total hip replacement on his right side, which will cost 4 lakhs. Will need a revision total hip replacement after 15 to 20 years, which will cost. Need a revision.
Revision, yes, my
ಅವಾಗ
lords. After
decide
15
ಮಾಡ್ತಾರೆ.
after 15 to 20 years.
ಮಾಡ್ಲೇಬೇಕಂತ ಏನಿಲ್ಲ, then they will decide whether it required for.
But because
hip
it is an artificial thing, definitely it requires a replacement, my lords. After 15, 20 years, they say.
Now he is using the artificial limb.
Not artificial limb, my lords. It is hip replacement.
Yes.
And with this kind of injuries, definitely he will not be able to work like before, my lords. My humble submission is his future prospects may kindly be considered.
Hmm.
His future prospects may kindly be considered. His age was only 29 years, my lords.
Yes.
An addition of 30% may kindly be
No, no,
awarded
no,
is my
no,
humble
no,
prayer,
no.
my lords.
All fractures are united
Only,
and 24% disability.
my lords, it is the fracture which is united is with regard to the right leg tibia, my lord.
Yes, madam. Yes, madam. You want to submit anything?
ಏನಿಲ್ಲ ಸ್ವಾಮಿ ಲಾಸ್ ಆಫ್ ಅಮ್ಯುನಿಟೀಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅವ್ರು ಕೇಳ್ತಾ ಇಲ್ಲ ಅದನ್ನಷ್ಟೇ
Yes. So
ಇದು
and
ಎಷ್ಟು
so
ಸತಿ
learned counsel appearing for the claimant has contended that due to the accident, claimant has suffered 71% disability to lower limb. The whole body disability is assessed by the tribunal is on lower side. She further contended that due to that accident, claimant has suffered grievous injury. He was unable to do his day-to-day work. And the tribunal has not granted future prospects. She further contended that due to that accident, claimant has suffered grievous injury, was inpatient for a period of 10 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Compensation awarded by the tribunal, pain and suffering, and other incidental expenses is on lower side. Tribunal has not granted any compensation for loss of immunities. For future medical expenses, she contended that doctor has deposed that he required 5 lakhs rupees for hip replacement after 15 to 20 years. The tribunal has granted only 1 lakh is on lower side. Hence, he sought for enhancement of compensation. For contra, so and so learned counsel appearing for insurance company has contended that even though the claimant has suffered 24% whole body disabilities, the fractures are united. It will not affect his day-to-day activities. Therefore, tribunal has rightly not granted future prospects. She further contended that considering that evidence of doctor and injury suffered by the claimant, overall compensation awarded by the tribunal is just and reasonable, sought for dismissal of the appeal. Heard the learned counsel for the parties, Perose, judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 17/8/2015 due to rash and negligent driving of driver of the car bearing registration number AP03PL1640. Considering that income tax return, the tribunal has rightly assessed the monthly income of the claimant as 12,000 per month. The claimant has examined the doctor as PW2. In his evidence, he has deposed that he has suffered lower limb disability of 71% and whole body is 24%. Considering that evidence of doctor, the tribunal has rightly assessed whole body disability is 24%. In respect of future prospect is concerned, at the time of the accident, he was aged about
29 years.
29 years. As per the evidence of the doctor, the injury, the fractures are united and it will not affect his day-to-day activities. Therefore, the tribunal rightly has not awarded future prospects. The compensation awarded by the tribunal for loss of future earning is just and reasonable. Due to that accident, claimant has suffered grievous injury. He was inpatient for a period of 10 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor, I am of the opinion that the claimant is entitled
Loss of immunities, 75,000. And conveniences, nourishment and food and attendance charges has to be enhanced from 10,000 to 25,000. Future medical expenses is concerned. Due to that accident, claimant has undergone surgery. Doctor has been examined as PW2. In his evidence, he has deposed that the claimant has suffered 24% whole body disabilities and require replacement of the hip after 15 to 20 years. It costs sum of rupees 5 lakhs. Considering that evidence of claimant and evidence of the doctor and medical records, injuries suffered by the claimant, I am of the opinion that the future surgery cost awarded by the tribunal, 1 lakh has to be extended to 2 lakhs. It will not carry any interest. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal modified as follows. In view of order dated 7/12/2023, not entitled for the interest for a period of 258 days for enhanced compensation.
Much obliged.
Much obliged.
Serial number 66, my lord. Serial number 66.
66.
Yes,
After 2 weeks, my lord.
66. Yes, madam. Where is she? At the request of counsel for the appellant in MFA 3786 of 2018, leaves this matter after 3 weeks.
Much.
Yes, Mr.
My lord, serial number 67, requested 2 weeks time.
67.
House.
ಏನಿದು ಚಂದ್ರಶೇಖರ್ how you have come in that motor vehicles
ಅಲ್ಲ
matter?
ಅವ್ರಿಗೆ ಕೇಳಿದೆ
ಓನರ್ ಈಗ
ಮುಗಿದೋಗಿದೆ
Claimant is
ದುಡ್ಡು ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಇನ್ನು ಅರ್ಧ ಕೊಡ್ಬೇಕಷ್ಟ ಮುಗ್ದ ಹೋಗ್ತದೆ ಏನಿಲ್ಲ ಅದು
ಸೆಟಲ್ ಮಾಡ್ಕೊಂತೀರಾ?
ಅಲ್ಲ ಒಂದು 2 weeks ಟೈಮ್ ಕೊಟ್ರೆ ಅದು ನೋಡಿ ಕರ್ಸಿ ಪಾರ್ಟೀಸ್ ಕರ್ಸಿ.
ಎಸ್. ನೀವೇನ್ ಕ್ಲೈಮೇಟ್ ಈಗ?
ಹೌದೌದು ಕ್ಲೈಮ್.
ನೀವು ಓನರ್ ಎಷ್ಟು ಅವಾರ್ಡ್ ಮಾಡಿದ್ದಾರೆ?
2,40,000 ಕೊಟ್ಟಿದ್ದಾರೆ. 1,22 ಆಲ್ರೆಡಿ ರಿಪಾರ್ಟ್ ಮಾಡಿದಾರೆ. ಇನ್ನು 1,22 ಕೊಟ್ಬಿಟ್ಟು
ಅದನ್ನ
ಇಂಟ್ರೆಸ್ಟ್
ಪಾರ್ಟೀಸ್ ಕನ್ಸಲ್ಟ್ ಮಾಡಿ ಅದನ್ನ ಒಂದು 2 weeks ಟೈಮ್ ಕೊಟ್ರೆ
ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ನೆಕ್ಸ್ಟ್
ವೀಕ್ at the request of counsel for the appellant, leave this matter next week.
ಮಚ್ಚು
ನೆಕ್ಸ್ಟ್ ನಂಬರ್
ಮಾಡಿಸ್ಬೋದು ಅದಕ್ಕೆ. ಆಶ್ಚರ್ಯ ಆಯ್ತು ಅವ್ರಿಗೆ.
ಇವ್ರ ಹತ್ರ ರಿಲೀಸ್ ಮಾಡಿದ್ರೆ ಸೇವಿಂಗ್ಸ್ ಕೊಟ್ಬಿಟ್ಟೆಲ್ಲ ಮಾಡಿ ಸರ್
ಅಲ್ಲೇ ಹೋಗಿ ಹೇಳಪ್ಪ ಹಿಂದೆ ಮುಂದೆ ಬರುತ್ತೆ, ಡೇಟ್ ಅಲ್ವಲ್ಲ ಅದು, ಹಿಂದೆ ಮುಂದೆ ಬರುತ್ತೆ.
Thank you.
ಎರಡು ಪುಸ್ತಕ ಆರ್ಥಿಕ ಇಚ್ಛೆ ಇಲ್ಲ ಕನೆಕ್ಟ್ ಬೇರೆ ಬೇರೆನೆ ಇಚ್ಛೆ ಎರಡು ಡಿಸ್ಪೋಸಲ್ ಡಿ.ಎಂ ಡಿಸ್ಪೋಸಲ್ ಇದೆ ಫಸ್ಟ್ ಎರಡು ಸೀಟ್ ಡಿಸ್ಪೋಸಲ್ ಇವ್ರಿಗೂ ಎರಡು ಡಿಸ್ಪೋಸಲ್.
ಮುದ್ದೆ ಮುದ್ದೆ ಅಸೋಸಿಯೇಷನ್ ಕಾರ್ಯಕ್ರಮ ಮುನೇಶ್ವರ ದೇವಸ್ಥಾನ ಇದೆಯಾ? ಮುದ್ದೆ ಒಂದ್ ಗೋಡೆಗೆ ಹೌದು, ಬಾರ್ ಕೌನ್ಸಿಲ್ ಎದುರುಗಡೆ ಗ್ಯಾಸ್ ಗೀಸ್ ಆಗಲ್ಲ.
ಎಷ್ಟು ಸೀರಿಯಲ್ ನಂಬರ್ ಅದು? ಫಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ಅನ್ಸುತ್ತಲ್ವಾ? 63 ಹೇಳ್ಬಿಡ್ತೀನಿ, ಅವ್ರು ಇರ್ಲಿಲ್ಲಪ್ಪ. ಹೇಳಿ ಸರ್.
Sir, 56,
ಹಾ.
ಅದು ರೆಸ್ಪಾಂಡೆಂಟ್ 3 ತಗೊಂಡ್ರೆ ಸರ್ ಟೈಮ್? ಅದೇನಂತೂ ಸುಮ್ಮನೆ ಜಸ್ಟ್ ಲೈಕ್.
ಹೌದು.
ಓಕೆ, 2 weeks.
ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಎಲ್ಲ ಮಿಸ್ ಆಗಿದೆ, ಬರ್ಕೊಂಡೇ ಇಲ್ವಲ್ಲ. ಹಾ, ಡಿಸ್ಪೋಸ್ ಅಂತೂ ಆಗಿದೆ. ಫಿಗರ್ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ, ಎಲ್ಲ ಬೇರೆ ಕಡೆ ಸಿಕ್. ಓಕೆ ಸರ್. ಇನ್ನ ಪಾಸ್ವರ್ಡ್ ಹೋಗಿಲ್ಲ ನಾವು. ಅವ್ರು ಯಾರು ಅನ್ನೋದೇ ಗೊತ್ತಿಲ್ಲ. ಇಲ್ಲೇ ಅವೇ ಪಾಸ್ವರ್ಡ್ ಎರಡು ಮಿನಿಮಮ್ ಮಾಡಿ.
Sir, 48 ಫೈಲ್ ಹೋಗ್ಬಿಟ್ಟಿದೆ. ಸಾರಿ 16 ಸೀರಿಯಲ್ ನಂಬರ್ 16 ಸರ್ ಹೋಗ್ಬಿಟ್ಟಿದೆ ಸರ್. ಯಾಕಂದ್ರೆ ಅದೇನೋ ಬೆಳಿಗ್ಗೆ ಸಾಹೇಬ್ರು ನೀವು ಅದು 16 ಬೆಳಿಗ್ಗೆ ಸಾಹೇಬ್ರು ನೀವು ಮೀಡಿಯೇಷನ್ ಅಟೆಂಡ್ ಆಗಿಲ್ಲ ಅದೇನು ಅಂದ್ರಲ್ಲ ಸರ್, ಅದು ಯಾರು ಕಳಿಸಿದೆ ಸರ್ ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ಅಲ್ಲಿ ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟಿದೆ.
ಬಂದಿತ್ತು.
ಹಾ
ಡಿವಿಷನ್ ಬೆಂಚ್ ಸಿಂಗಲ್ ಬೆಂಚ್ ಆರ್ಡರ್ ಮಾಡಿದ್ರು. ಸಿಂಗಲ್ ಬೆಂಚ್ ಇಂದ ಮೀಡಿಯೇಷನ್ ರೆಫರ್ಡ್ ಆಯ್ತು, ಯಾವ್ದೋ ಅಮೌಂಟ್ ಸೆಟ್ಲ್ ಆಯ್ತು. ಆಮೇಲೆ ಈಗ ಹೇಳಿದ್ರೆ ಅಮೌಂಟ್ ನಮ್ಗೆ ಇಷ್ಟ ಇಲ್ಲ, ರೆಫರ್ ಬ್ಯಾಕ್ ಟು ಕೋರ್ಟ್ ಆಯ್ತು. ತಿರ್ಗಾ ರೆಫರ್ ಬ್ಯಾಕ್ ಟು ಕೋರ್ಟ್ ಆಯ್ತು. ಇವಾಗ ನಮ್ಮ ಮುಂದೆ ಬಂದಿದೆ, ಇವತ್ತು ನೋಟಿಸ್ ಆಗಿದೆ.
ಅದೇ ಸರ್ ನಾನಿದೆ, ಬಟ್ ಅಟೆಂಡ್ ಆಗಿಲ್ಲ, ನನಗೆ ಅದೇ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ, ತಲೆ ಕೆಟ್ಟು
ಬರುತ್ತೆ ಬನ್ನಿ.
ಸೈನ್ ಹಾಕಿದೀವ ಸರ್ ನಾವು? ಸೈನ್ ಹಾಕಿದೀವ ನಾವು?
ಸಾಹೇಬ್ರುಗಳೆಲ್ಲ ಸೈನ್ ಮಾಡಿದ್ದಾರೆ.
ಸರ್ ನಾವು ಸೈನ್ ಮಾಡಿದೀವಿ, ಅಡ್ವೊಕೇಟ್ಸ್ ಸೈನ್ ಮಾಡಿದಾರೆ. ಫೈಲ್ ಹೋಗ್ಬಿಟ್ಟಿದೆ ಅಲ್ಲಿಗೆ.
Serial number 68, B. Pradeep for appellant, connected matter, Bojaraja, N. Gopal Krishna.
I appear for claimants, this Bojaraj. These three appeals, my lord, challenging the liability on the ground that, my lord, they were proceeding in a goods vehicle as a gratuitous passengers.
Yes.
As per the complaint, my lord, and one driver, Rohit, who was driving the vehicle as on the date of accident.
Yes.
Let's if exhibit P1, but P2 complaint may kindly be seen. Complaint given by one Subhash Chandra, who is also inmate of the goods vehicle,
Yes.
who has clearly stated that, my lord, ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ನಾನು ವಾಸವಾಗಿದ್ದು ಹೀಗೆ ಸುಮಾರು 4 ತಿಂಗಳಿಂದ ಕರ್ನಾಟಕ ಮೈಸೂರಿಂದ ಗುಂಡ್ಲಪೇಟೆ ಹೆದ್ದಾರಿಯಲ್ಲಿ ವಿದ್ಯುತ್ ಕಂಬಗಳನ್ನು ಹಾಕುವ ಎಲೆಕ್ಟ್ರಿಕಲ್ ಕೆಲಸ ಆಗಿ ಕರ್ತವ್ಯ ಮಾಡಿಕೊಂಡಿರುತ್ತೇನೆ. ಈ ದಿನಾಂಕ 8/12/2016 ಸುಮಾರು 1:30 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ನಂಜನಗೂಡಿನ ಸಿಂಧುವಳ್ಳಿಯಿಂದ KA 55-269 ಮಹೇಂದ್ರ ಪಿಕಪ್ ವಾಹನದಲ್ಲಿ ಚಾಲಕನಾಗಿ ರೋಹಿತ್ ಇದ್ದು ಅವನ ಜೊತೆ ಕ್ಯಾಬಿನ್ ನಲ್ಲಿ ನಿತೀಶ್ ಕುಮಾರ್ ಇದ್ದು, ಹಿಂದಿನ ಕ್ಯಾಬಿನ್ ನಲ್ಲಿ ಎಲೆಕ್ಟ್ರಿಕಲ್ ಕೆಲಸ, ಕೇಬಲ್ ಕೆಲಸ ಮಾಡಲು ನಾನು, ಪ್ರಭು, ರಾಕೇಶ್ ಮಣಿಕುಮಾರ್, ಮಹೇಶ್ ಆರ್ಯ, ಜೈರಾಮ್ ಕಿಶನ್, ದುರ್ಗೇಶ್, ದೀಪಕ್ ರವರುಗಳು ಸಿಂಧುವಳ್ಳಿಯ ಬಳಿ ಕೆಲಸ ಮುಗಿಸಿ ಕೇಬಲ್ ಕೆಲಸಕ್ಕಾಗಿ ನಂಜನಗೂಡಿನ ಕಡೆಗೆ ಬರುವಾಗ ಕಳಲೆ ಗೇಟ್ ಹತ್ತಿರ ಸುಮಾರು 1:35 ಗಂಟೆಯಲ್ಲಿ ನಾವು ಹೋಗುತ್ತಿದ್ದ ಪಿಕಪ್ ವಾಹನ ಚಾಲಕ ರೋಹಿತ್ ಅತಿವೇಗ ಮತ್ತು ಅಜಾಗರೂಕತೆಯಿಂದ ವಾಹನ ಚಲಾಯಿಸಿ ಪಿಕಪ್ ವಾಹನ ರಸ್ತೆಯ ಎಡಭಾಗದ ಡ್ರೈನೇಜ್ಗೆ ಡಿಕ್ಕಿ ಮಾಡಿದ್ದು ವಾಹನವು ಪಲ್ಟಿ ಹೊಡೆದಿತು. ಆಗ ವಾಹನದಲ್ಲಿದ್ದ ನಿತೀಶ್ಗೆ ಒಂದು ಕೈ ಕಟ್ಟಾಗಿದ್ದು ಮುಖಕ್ಕೆ ಪೆಟ್ಟು ಬಿದ್ದು ತೀವ್ರ ರಕ್ತಸ್ರಾವ ಸ್ಥಳದಲ್ಲೇ ಮೃತಪಟ್ಟು ಪ್ರಭುವಿಗೆ ತಲೆಗೆ ರಕ್ತಗಾಯವಾಗಿ ಅವರು ಸ್ಥಳದಲ್ಲಿಯೇ ಮೃತಪಟ್ಟಿದ್ದು. ಉಳಿದ ರಾಕೇಶ್ ಕುಮಾರ್, ಮಹೇಶ್, ಜಯರಾಮ್, ರೋಹಿತ್, ಕಿಶನ್, ದುರ್ಗೇಶ್, ದೀಪಕ್ ಇವರೆಲ್ಲರಿಗೂ ರಕ್ತಗಾಯಗಳಾಗಿದ್ದು ನನಗೂ ಹಣೆಗೆ ಏಟು ಬಿದ್ದು ರಕ್ತಗಾಯವಾಗಿರುತ್ತದೆ. ಮೃತ ನಿತೇಶ್ ಕುಮಾರ್ ಮತ್ತು ಪ್ರಭುರವನ್ನು ಯಾವುದೋ ಆಟದಲ್ಲಿ ನಂಜನಗೂಡಿನ ಆಸ್ಪತ್ರೆಗೆ ಸಾಗಿಸಿದ್ದು ಶವಗಾರದ ಮತ್ತೆ ಗಾಯಗೊಂಡ 108 ಆಂಬುಲೆನ್ಸ್ ನಂಜನಗೂಡು ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಚಿಕಿತ್ಸೆ ಕೊಡಿಸಿದೆ. They are all belongs to
Yes, they are all inmates of that.
Inmates of the goods vehicle. They are not the authorized representative of the goods, or they are not the employees of the insured owner.
Yes.
It is the fact complaint given by one of the inmate, which is very clear, Mila. Therefore, the apex court has held that in the Premlata Shukla case, the contents of the FIR should be looked into. The complaint lodged, which would clearly narrated that, my lord, they are all electrical workers.
Going
They
along with
boarded.
the goods.
No, my lord, they have not stated that, my lord, along with goods they are proceeding.
Deepak ಅವರು
ಕೇವಲ ಕೆಲಸಕ್ಕಾಗಿ ಹೋಗ್ತಾ ಇದ್ರು, ಅಲಾಂಗ್ ವಿತ್ ಗೂಡ್ಸ್ ಹೋಗ್ತಾ ಇದ್ರು ಅಂತ ಕಂಪ್ಲೇಂಟ್ ಇಲ್ಲ ಸರ್.
Yes.
Lord, this is regarding para 2, my lord, the contents of the FIR should be looked into. The first information,
Paragraph.
para 2, my lord, para 2.
Yes.
The decision of Shivanand Prasad Shukla was traveling in the tempo tracks and going to Allahabad from Bhopal. It collided with the truck. Registration number so and so truck could not be noticed. The truck also could be not be traced. A first information report was lodged one occupant of the tempo tracks. An investigation that on the basis of the said first information report for the commission of an offence under section 304A of the Indian Penal Code in 1860 was registered against the driver of the said truck. As during the investigation, the truck could not be traced out, the case was closed. A claim petition was filed before the Motor Accident Claims Tribunal against the driver, owner and insurer of company with the tempo tracks was insured. The tribunal, upon analyzing the material brought on record by the parties, including first information report, arrived at the finding of fact that the driver of the tempo tracks was not driving the vehicle rashly and negligently. It therefore dismissed the claim petition. Opening on the basis of the complaint ಅಲ್ಲಿ ಏನ್ ನರೇಶನ್ ಇತ್ತು ಸ್ವಾಮಿ, that is the real truth that should be looked into.
ಎಲ್ಲಿ
As per
where is that finding of the?
ಇದ್ರಲ್ಲೇ ಹೇಳ್ತಾರೆ ಸರ್.
ಆತರ ಏನಿಲ್ಲ, ಫ್ಯಾಕ್ಟ್ಸ್ ಹೇಳಿರೋದು ಅಷ್ಟೇ.
ಹೌದು ಸರ್, ಅದು ದಟ್ ಇಸ್ ರಿಯಲ್ ಟ್ರೂತ್ ಅಂತ ಇದು ಫ್ಯಾಕ್ಟ್ಸ್ ಮೈ ಲಾರ್ಡ್. ಕನ್ಕ್ಲೂಷನ್ is
Truck is also cannot be traced. First information lodged by the occupant so and so on the basis of the report for the commissioner of the offence. No, it is only facts they have extracted.
please my lord, the conclusion is my lord.
Yes, conclusion where is it?
Please my lord. Conclusion is para 13, 14 and 15.
Factum of the accident could be proved.
However, the factum of the accident, first information report, it is also be noted that one part of the contents of the documents admitted in evidence. The party bringing the same on record cannot be permitted to turn round and contend that the other contents of contained in the rest part thereof had not been proved. Both the parties have relied thereupon. It was marked as an exhibit as both the parties intended to rely upon them. When they are relied upon them, my lord, the contents of the FIR, it is all part of the evidence, my lord. Once the part of it is relied upon by both the parties, the learned tribunal cannot be said that have committed an illegal in relying upon the other part, irrespective of the contents of.
Contents, they cannot say no.
Please, my lord, the contents of the FIR.
Contents which is not there It cannot be substituted by that other evidence ಅಂತ ಹೇಳಿಲ್ಲ. ಈಗ ಆಕ್ಸಿಡೆಂಟ್ ಆಯ್ತು, ಡ್ರೈವಿಂಗು ರೋಹಿತ್ ಮಾಡ್ತಾ ಇದ್ದ ಅಂತ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಇದೆ. ಅವರು ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿರೋದು ಮಾತ್ರ FIR ಇರೋದು ಕರೆಕ್ಟ್, ಡ್ರೈವಿಂಗ್ ರೋಹಿತ್ ಅಲ್ಲ ಅಂತ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಂಗ್ ಬರಲ್ಲ.
ಅದನ್ನೇ ಸರ್ ಅದಕ್ಕೆ
Here, here that in the FIR, it is not mentioned that they are traveling along with the goods. If they prove by other evidence, you can't say that.
Please, my lord, they may do so, my lord. Now, why I am referring this one, Rohit has
That is
clearly
admitted
mentioned.
facts.
Please, my lord,
When that one document which is admitted,
please,
you can't say that part is applicable, part cannot be applicable.
It's a documentary evidence, my lord.
Yes.
The prima facie complaint itself is
Say
clear.
that in the FIR, there is no disclosure of any goods.
Please. One thing, my lord. Another thing, my lord, is when Rohit was the driver, as on the
that
date
is-
of, they were categorically stated twice, my lord.
There, yes. Now they are not saying that Rohit is not driver.
No, my lord. The charge sheet on some other person has been charge sheeted. Because he doesn't have driving license, my lord. One Kesar Khan, who is in the complaint also, his name is not there. Kesar Khan, who was the driver, has been charge sheeted by the police, my lord. That has been concocted, my lord.
Your case is that driver has been implicated.
Implicated, and the all three persons who are traveling as a unauthorized passenger, they are not related to the employees of the insured or the representative of the goods.
Yes. Yes.
For implanting driver is concerned, my lord, the Sanva Court Division Bench, my lord. ILR 2014 KR subclass 3336, page number, my lord. ಅದನ್ನೊಂದು ತಾಂಬರಕ್ಕೆ ಹೋಗಿದ್ದಾರೆ, ಬರ್ತಾ ಇದೆ. ಕಳಿಸಿದ್ದೆ, ಅದು ಜೆರಾಕ್ಸ್ ಹತ್ರ ತುಂಬಾ ರಶ್ ಇತ್ತು.
What is that this court said?
ಅದೇ ಡ್ರೈವರ್ ಇಂಪ್ಲಾಂಟ್ ಆದಾಗ the owner is held responsible for the.
If it is proved that owner is.
Please.
See, if it is proved that it has been implanted.
Please.
We can't say that driver has to be this thing.
Please.
There is no dispute that. Yes. That's all your contention. Yes, Mr.
Yes. Insofar as the contention of the insurance company that driver is substituted, we have nothing to say.
No,
Because in
that is for the owners.
Yes. So far as we are concerned, if it is held that driver is replaced by the owner, pay and recovery order will have to be passed. Because we are third parties, we have been honestly, we have disclosed who was the driver.
Yes.
That there ends the matter. That is one aspect. So far as the
To-
owner of the goods or
To
not,
claim that,
we were
compensation, the owner has replaced or substitute the driver, that is nothing to do with
yes,
that claimant.
we are not hand in glove with him.
Yes. For
Number
that, compensation cannot be denied.
Yes. Number two, so far as we have, all the three have pleaded that we were proceeding along with the goods. Because we had obtained subcontract
No,
of
that,
laying
who is
cables,
the complainant?
electrical cables.
Chandrakant. Who is
Subhash
the
Chandra.
Huh?
Subhash Chandra.
He is also claimant.
No, my lord, he has not claimed compensation. He has also sustained injuries, my lord.
He has not claimed.
Not claimed.
Only one death and two grievous injuries we have claimed.
Yes. 62,
ಅವನೇನಾಯ್ತು?
that one appeal is filed for cross objection.
Yes.
That is filed by claimant.
Yes.
Yes.
That is MVC 541.
Now that, but you have to prove you are traveling along with the
Along
goods.
with goods.
That
So
is
far
only
as-
your,
yes.
then they have to prove that
Yes.
he is the driver.
FIR discloses that they were proceeding in connection with the electrical laying.
Laying, yes.
They had completed at one portion, and for further laying, they were proceeding. Number two, in our pleading, we had pleaded that they were proceeding along with the goods, having obtained subcontract from so. In the
ಮಾಜೂರಲ್ಲಿ ಏನಾರು ಇದೆಯಾ good?
cross examination ದಲ್ಲಿ ಅವ್ರದಿದೆ. In the cross examination by insurance company,
Yes.
of PW 1, 2, and 3. In the claim, in the in para 4 of the examination chief, we had stated that we are.
PW 1
ಎಲ್ಲ ಮೂರಲ್ಲೂ ಹೇಳಿದ್ದಾರೆ. The PW 1, 2, and 3. They had stated in the examination chief that they were proceeding along with electrical goods. Cables ತಗೊಂಡು ಹೋಗ್ತಾ ಇದ್ವಿ ಅಂತ. And in the cross examination, PW 1, your honor may kindly first PW 1.
Yes.
Party ಸವಾಲು. Second, and the page 5.
Yes.
Second line.
Yes.
ನಾವು ಆ ದಿನ ಪ್ರಯಾಣಿಕರಾಗಿ ಸ್ವತಃ I think you got that.
ಐದರಲ್ಲಿ
Page 5.
page 5
ಹೌದು.
ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ
ಎಲ್ಲ ಟಾಪ್ ದಿಂದನೇ ಸೆಕೆಂಡ್ ಲೈನ್.
ಸೆಕೆಂಡ್ ಲೈನ್. Yes.
ನಾವು ಆ ದಿನ
Yes.
ಪ್ರಯಾಣಿಕರಾಗಿ ಸ್ವತಃ
ನಾವು ಇದೆ.
ನಾವು ಆ ದಿನ ಪ್ರಯಾಣಿಕರಾಗಿ ಸ್ವತಃ ಬೊಲೆರೋ ವಾಹನದಲ್ಲಿ ಕೇಬಲ್ಗಳ ಮೇಲೆ ಕುಳಿತುಕೊಂಡು ಬರುತ್ತಿದ್ದಾಗ ನಮ್ಮ ಅಜಾಗರೂಕತೆ ನಾವು ಕೆಳಗೆ ಬಿದ್ದು ಗಾಯಗೊಂಡಿದ್ದೇವೆ ಅಂದ್ರೆ ಸರಿಯಲ್ಲ.
That is their suggestion.
Their suggestion is that we were
Traveling with the
sitting on the cable.
Yes.
And this itself indicates that cables were there. Our contention that we were proceeding along with goods stands proved by this suggestive cross-examination. Their contention is because we were sitting on this one, it is a negligent act, so they have fallen. That is first. PW 2, next.
Same question.
Same question.
Same way. Any other documents?
Yes. No other positive documents are there.
Mazur and Tran ಆಗಿದೆಯಾ?
ಹಜಾರಲ್ಲಿ ಇಲ್ಲ
ಮಾಜರದಲ್ಲಿ ಇಲ್ಲ.
Yes.
So under these circumstances, we have proved that they were proceeding along with the goods. The only question that arises for consideration is
Driver, substitution of driver.
that we are not arguing.
Yes. You are only.
ಪ್ರಯಾಣಿಕರಾಗಿ
On the
ನಾವು
earlier
ಸಜೆಸ್ಟ್
occasion.
ಮಾಡಿರೋದು ಅಲಾಂಗ್ ವಿತ್ ಗೂಡ್ಸ್ ಅಂತ ನಾವು ಸಜೆಸ್ಟ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. ಪ್ರಯಾಣಿಕರಾಗಿ ಗೂಡ್ಸ್ ಮೇಲೆ ಕುತ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದ್ರಿ ಅಂತ ನಮ್ ಸಜೆಷನ್.
ನಾವು ಆ ದಿನ
ಪ್ರಯಾಣಿಕರಾಗಿ
electrical goods ಮೇಲೆ
ಗೂಡ್ಸ್ ಇತ್ತು ಅಂತ ಅಲ್ಲಿ.
ಅಲ್ಲ ಗೂಡ್ಸ್ ಮೇಲೆ ಕುತ್ಕೊಂಡು ಹೋಗ್ತಿದ್ರಿ ಅಂತ ಕೇಳಿದೀವಿ. ಪ್ರಯಾಣಿಕರಾಗಿ ನಾಟ್ ಫಾರ್ ದ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ ಆಫ್ ದ ಗೂಡ್ಸ್.
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಗೂಡ್ಸ್ ಇಲ್ಲ, ಇಲ್ಲಿ ನೀವು ಒಪ್ಕೊಂಡ್ರಿ ಗೂಡ್ಸ್ ಇದೆ ಅಂತ. ಗೂಡ್ಸ್ ಅವ್ರದ್ದು ಅಲ್ಲೋ ಅನ್ನೋದು ಪ್ರಶ್ನೆ.
Whether they
have pleaded and we have
there are not,
stated
they are
on
not hirer millard or representatives.
No, have you stated that goods is not belongs to you?
ಅವರೇ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ, ಎಲೆಕ್ಟ್ರಿಕಲ್ ಬೇರೆಯವರು ಇವ್ರನ್ನ ಕೂಲಿ ಕೆಲ್ಸಕ್ಕೆ ಕಳ್ಸಿದ್ದು ಇಲ್ಲಿ ಅದ್ರಲ್ಲಿ ಅದೇ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ.
ಎಸ್.
ನೆಕ್ಸ್ಟ್ ಅಲ್ಲಿ ಮಿಲಾಡ್ ಬೊಲೆರೋ ಪಿಕಪ್ ಗಾಡಿಯ ಬರುವಾಗ ಅಪಘಾತವಾಗಿತ್ತು ಅಂತ ಹೇಳಿದ್ದು. ನಾನು ಮತ್ತು ಜಯರಾಮು ಪ್ರಭು ಮಹಾರಾಷ್ಟ್ರದ 3 ಜನ ಕೂಡಿ ಒಟ್ಟು 7 ಜನ ಹೋಗುತ್ತಿದ್ದೆವು. ಅದು ಸರಕು ಸಾಗಣೆ ವಾಹನ ಎಲ್ಲ ಅಂದ್ರೆ ಗೊತ್ತಿಲ್ಲ. ಅದರಲ್ಲಿ PW 1 ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್.
ಯಾವ ಪ್ಯಾರಾ?
ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ ಮಿಲಾಡ್ ಪಾರ್ಟಿ ಸವಾಲು BKC ವಕೀಲರಿಂದ ಅಂತ 539 ಅಲ್ಲಿ.
ಎಸ್, BKC. ನಾವು 19
ಅದು ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿ. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿ ಬೊಲೆರೋ ಪಿಕಪ್ ಗಾಡಿಯಲ್ಲಿ ಬರುವಾಗ ಅಪಘಾತ ಆಗಿದ್ದು ಎಂದು ಹೇಳಿದ್ದು. ಅದರಲ್ಲಿ ನಾನು ಜಯರಾಮ ಪ್ರಭು ಮಹಾರಾಷ್ಟ್ರದ 3 ಜನ ಕೂಡಿ ಒಟ್ಟು ನಾವು 7 ಜನ ಹೋಗುತ್ತಿದ್ದೆವು. ಅದು ಸರಕು ಸಾಗಣೆ ವಾಹನ ಅಂದರೆ ಗೊತ್ತಿಲ್ಲ. ನಾವು ಅದರಲ್ಲಿ ಪ್ರಯಾಣಿಕರಾಗಿ ಹೋಗುತ್ತಿದ್ದೇವೆ ಅಂದ್ರೆ ಸರಿಯಿಲ್ಲ. ನಾವು ಆ ದಿನ ಪ್ರಯಾಣಿಕರಾಗಿ ಸ್ವತಃ ಬೊಲೆರೋ ವಾಹನದಲ್ಲಿ ಕೇಬಲ್ಗಳ ಮೇಲೆ ಕುಳಿತುಕೊಂಡು ಬರುತ್ತಿದ್ದಾಗ ನಮ್ಮ ಅಜಾಗರೂಕತೆಯಿಂದ ನಾವು ಕೆಳಗೆ ಬಿದ್ದು ಗಾಯಗೊಂಡಿದ್ದೇವೆ ಅಂದ್ರೆ ಸರಿಯಿಲ್ಲ. ಸದರಿ ವಾಹನ ಲಗೇಜ್ ತುಂಬಿಕೊಂಡು ಬರುವಂತ ವಾಹನ ಆಗಿದ್ದು ಅದರಲ್ಲಿ ಪ್ರಯಾಣಿಕರಿಗೆ ಕೂರಿಸಿಕೊಂಡು ಬರುತ್ತಿರುವಾಗ ನಾವು ಸ್ವತಃ ಬಿದ್ದಿದ್ದೇವೆ ಅಂದ್ರೆ ಸರಿಯಲ್ಲ. ಅಪಘಾತಕ್ಕೂ ಆ ವಾಹನಕ್ಕೂ ಮತ್ತು ಅದರ ಚಾಲಕನು ನಮಗೆ ಆದಂತಹ ಯಾವುದೇ ಸಂಬಂಧ ಇಲ್ಲ ಅಂದ್ರೆ ಸರಿಯಲ್ಲ. ಅಪಘಾತದ ಬಗ್ಗೆ ವೈದ್ಯರ ಮುಂದೆ ಪೊಲೀಸರ ಮುಂದೆ ನಾನು ಹೇಳಿಕೆ ನೀಡಿಲ್ಲ. ಪೊಲೀಸರಿಗೆ ಯಾರು ದುಡ್ಡು ಕೊಟ್ಟರೆ ಗೊತ್ತಿಲ್ಲ. ನಮಗೆ ಆದಂತಹ ಗಾಯಗಳು ವಾಹನದ ಚಾಲಕನ ಅಜಾಗರೂಕತೆ ಅದು ಮುಂದೆ ಇದೆ ಸಮಯದ ಆಸ್ಪತ್ರೆದು. ನನಗೆ ಕೂಲಿ ಕೆಲಸ ಮತ್ತು ವ್ಯವಸಾಯದಿಂದ ತಿಂಗಳಿಗೆ 15,000 ಆದಾಯ ಇತ್ತು ಎಂದ್ರೆ ಸುಳ್ಳು ಹೇಳ್ತಿದ್ದೇನೆ ಸರಿಯಲ್ಲ. ಅವ್ರು ದೇವ್ ಕಂಟೆಂಡೆಡ್ ದಟ್ ಮೇಲೆ ದೇರ್ ಕೂಲಿ ವರ್ಕರ್ಸ್. The contention itself is their ಕೂಲಿ ವರ್ಕರ್.
ನಾನು ಆ ಕಂಪನಿ ಸೇರಿದ ವಾಹನದಲ್ಲಿ ಕೂಲಿ ಕಾರ್ಮಿಕನಾಗಿ ಪ್ರಯಾಣ ಮಾಡ್ತಿದ್ದು ಸುಳ್ಳು ಹೇಳ್ತಿದ್ದೇನೆ ಅಂದ್ರೆ ಸರಿಯಲ್ಲ.
ಅದೇ ಆ ಕಂಪನಿಯಲ್ಲಿ ಕೂಲಿ ಕೆಲಸ ಮಾಡೋಂಥವ್ರು ಇವರು.
ಕೂಲಿ ಕೆಲಸ ಮಾಡ್ತಿದ್ದೆ ಅಂದ್ರೆ ಸರಿಯಲ್ಲ.
ಅದೇ ಅದು ಸಜೆಷನ್ ಅವ್ರು ಹೇಳ್ಕೊಂಡಿದ್ದು.
ವರ್ಕಿಂಗ್ ಅಂಡರ್ ದ ಕಂಪನಿ, ಇಫ್ ದೇ ಆರ್ ಗೋಯಿಂಗ್ ಅಲಾಂಗ್ ವಿತ್ ದಟ್ cable of the company, then also they are entitled representative.
They are the workers. They are coolies. They doesn't say that well anywhere. I am the representative of that goods. We are traveling. In the evidence also, chief examination
ನಾವು
also, they have
electric
not
cable
quoted.
company ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೆ
ಕೂಲಿ
ಅಂತ
ಕೆಲಸ ಅಂತಾನೆ
ಹೇಳಿದ್ದಾರೆ. ಆ
ಹೇಳ್ಕೊತಾರೆ.
ಕಂಪನಿಗೆ ಯಾರಿಗೂ ಸೇರಿತ್ತೆ ಅಂತ ನನಗೆ ಗೊತ್ತಿಲ್ಲ.
ಗೊತ್ತಿಲ್ಲ.
ನಾನು ಆ ಕಂಪನಿಗೆ ಸೇರಿದ್ದ ವಾಹನದಲ್ಲಿ ಕೂಲಿ ಕಾರ್ಮಿಕನಾಗಿ ಪ್ರಯಾಣಿಸುತ್ತಿದ್ದೆ ಎಂದು ಸುಳ್ಳು ಹೇಳ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನನಗೆ 40 ವರ್ಷ ವಯಸ್ಸಾಗಿದೆ, ಆದರೆ ಸರಿಯಲ್ಲ. You said that your
We are proceeding along with the goods.
goods belongs to that company.
Modus operandi of executing work of this cable work is the main contractor is having the cables,
Yes.
large quantity of cables and other equipments for laying of cables on the highway. One contractor digs the road,
Yes.
another lays the pipe. These persons in turn bring in according to their capacity, along with the other co-workers, the cables. Say for example, in this case, 3 or 4 persons might be bringing that cables with, so it is their responsibility to return the cable or lay it. So other persons are also required for the reason, one person alone cannot lay the, because labor manually they have to be pushed.
Yes.
So in that way, they were in all 7 persons. But 3 persons we have claimed that we were proceeding along with the goods. And I have already on the last occasion shown before your lordship that rule 100.
Yes.
Rule 100 permits 3 persons in this case.
Co-workers are coming towards the Nagara. Therefore, proceeding.
ಏನು?
Yes.
Lord, regarding the
Rule
owner
100.
or representative is concerned, my lordship kindly see 147 of the Motor Vehicles Act.
What is that?
My lord, owner or his representative, not owners, my lord, or representatives. One person, my lord. It's a single word, single
That's
word, my
right.
lord, has been mentioned, 147 of the Motor Vehicles Act.
Hmm.
ಈಗ 4-5 ಜನ ಓನರ್ಸ್ ಆರ್ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ಸ್ ಆಗಕ್ ಚಾನ್ಸ್ ಇಲ್ಲ. ಓನರ್ ಆಫ್ ದ ಗೂಡ್ಸ್ ಆರ್ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ ಆಫ್ ದ ಗೂಡ್ಸ್.
On that aspect, rule 100 comes in my help, my. Rule 100, 1 as well as 4.
Against any liability which may be incurred by him in respect of the death or bodily injury to any person, including that owner of the goods or his authorized representative carrying the vehicle, or damage to any parties to the third party.
Yes.
Or his authorized representative.
Or owner of the
If
goods.
representative-
Either of one.
If for example,
see.
for example, my lord, if the owner himself is proceeding with the goods, then his representative will not be covered. This is the law of the Supreme Court.
See, or his authorized representative, how many is, it is not mentioned.
My lord, representatives
on
is a
that
concern, well, plural, my lord. Representatives, representate. Only one person can represent, my lord.
That on that aspect, I am reading rule 100 clause 4.
Yes.
Sub rule 4. I have already brought to your rule 100 says how many numbers of persons can proceed along with the goods.
Yes.
Rule 100 says, clause 1, how many numbers can proceed in a goods vehicle?
Yes.
It depends on the weight of the vehicle.
104.
Clause 1, proviso. Clause 1. Light goods vehicle, I think your honor is
Light transport goods.
Transport
vehicle,
goods
not
vehicle.
more than 3. You are covered under which?
I am covered under 2. In any other light transport goods vehicle, not more than 3.
ನೀವು ಎಷ್ಟು ಜನ ಹೋಗ್ತಾ ಇದ್ರಿ?
Idral, we 3 only are covered, others are not covered. If, for example, if all were making a claim, then highest 3 will be liable to be satisfied.
The provisions of this rule, no person shall be carried in a goods vehicle provided that owner.
Regarding that, my lord, last occasion, lordship stated
Yeah, on
whether
this-
they are bona fide employees or not, that has to be proved by the
Which one there?
This is regarding rule 100.
Hmm.
Last occasion, my lordship said, whether the bona fide employees.
Then this rule, no person shall be carried, provide further that owner
or hirer of the vehicle.
bona fide employee of the owner.
Houdu.
Or that, see.
Or hirer.
Hirer. Your case is that.
We have hired the vehicle.
Huh?
We have hired the vehicle in piecemeal. It is permissible. I will rely on that judgment also.
No, is it your case that you are the employee of that company?
No, no. We
What
were
is-
on subcontract basis.
Where is that you are pleading? Where is the pleading that
Para 22.
of
ಎಲ್ಲ ಕ್ಲೈಮ್ ಪಿಟಿಷನ್ ದಲ್ಲೂ ಬರುತ್ತೆ.
chief examination, PW?
ಅಲ್ಲಲ್ಲ ಕ್ಲೇಮ್ ಪಿಟಿಷನ್
petition.
ಪ್ಯಾರಾ 22 ಕಾಲಮ್ 22.
Yes. Yes.
Para 22 sub para 2.
Yes.
Further it is submitted
Hmm.
on 8/12/16 at about 1:30 p.m. Aforesaid petitioner and other co-workers were coming towards Nanjanagudu for electrical cable work along with electrical goods after completion of their work at Sindhuvalli village through Bolero pickup vehicle bearing so and so. While they were so proceeding, Kalele Gate, the vehicle has turned. So our work is fully work. We take subcontract work from the, that is why we are interested with the cables, laying of.
That is not the pleading that you are subcontractor and all.
No, it is the rural sector, my lord. Rustic villagers and other things. They
Because
will
your
not make
pleading
any
is not-
specific pleading, but the fact remains that they were they were in the proceeding.
But you see that your PW1
PW.
Yes. Worker had been Nanjangud for labor work for digging that. You are saying that for a labor work for digging the trench for installation of that electric pole in the middle of the portion of Nanjangud by so. About 3 p.m. myself and other co-owners were coming towards Nanjangud for electric cable work along with electric goods after completion of the work. Village through the so. You are so proceeding near the Kala gate. So with speed, rash and negligent manner. So immediately I brought to the hospital, submitted that discharge of St. Joseph, which was taken for treatment. ನಾವು ಸುಳ್ಳಾಗಿ ಬರೆಸಿಕೊಂಡಿದ್ದೇವೆ ಅಂತ ಸರಿಯಲ್ಲ. ಕಂಪನಿ ನನ್ನ ಪರವಾಗಿ ಬಿಲ್ ಅನ್ನು ಹಣ ಪಾವತಿ ಮಾಡುತ್ತಿದ್ದಾರೆ ಎಂದು ನಾನು ಸುಳ್ಳು ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಸರಿಯಲ್ಲ. ಈ ಕಂಪನಿಗೂ ನನಗೂ ಯಾವುದೇ ಸಂಬಂಧ ಇಲ್ಲ ಅಂದರೆ ಸರಿಯಲ್ಲ ಅಂತ ಹೇಳ್ತೀರಾ?
So one thing is clear that they were coolies having taken contract work of laying cables, they were required to carry the cable. So it is their responsibility to return it if it is not laid. So
No,
at
but-
one place they had completed. So
No,
next place they were going along with the cables. That is found in the FIR also. And in the cross examination, it is shown by
No,
their.
you examine that by any person from the company.
With great respect, we have not.
You are not examined. Because that will be the truth will come.
We have not, because they have suggested in the cross examination that we were proceeding on the goods. And we were contending that we were proceeding along with the goods.
No, whether you are proceeding along with these goods as a representative.
No, we are.
Or that you are the owner of the goods.
Until it is returned, we are the persons who had borrowed it for laying.
There is
That
no
is
such
not
pleading.
forthcoming in the evidence.
Strictly, there will be no.
Not, my lord,
ಯಾಕೆಂದ್ರೆ
a single line they have stated like that.
ಕಂಪನಿ ನನ್ನ ಪರವಾಗಿ ಬಿಲ್ಲಿನ ಹಣವನ್ನು ಪಾವತಿ ಮಾಡಿದ್ದೆ ಎಂದು ನಾನು ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇನೆ ಅಂದ್ರೆ ಸರಿಯಲ್ಲ. ಆ ಕಂಪನಿಗೂ ಮತ್ತು ನನಗೆ ಯಾವುದೇ ಸಂಬಂಧ ಇಲ್ಲ ಅಂದ್ರೆ ಸರಿಯಲ್ಲ. ನಾನು ಆ ವಾಹನದಲ್ಲಿ ಪ್ರಯಾಣ ಮಾಡ್ತಿದ್ದರಿಂದ ಕಂಪನಿಯವರು ಸ್ವಂತ ಬಿಲ್ ಅನ್ನು ಕಟ್ಟಿದ್ದಾರೆ ಅಂದ್ರೆ ಸರಿಯಲ್ಲ. ಆದರೂ ಸಹ ನಾನು ಪರಿಹಾರ ಪಡೆಯುತ್ತಿದ್ದೇನೆ. ಸೊ ನಾನು ಅಲ್ಟಿಮೇಟ್ಲಿ ಯು ಆರ್ ಸೇಯಿಂಗ್ ದಟ್ ಕಂಪನಿ ಈಸ್ ಯುವರ್ ಬಾಸ್.
Yes.
Oh,
You examine that the employer. Will send it back and also for the driver,
ಈಗ ಆ
there is a
company
dispute.
ಈಗ ಇದೆಯೇನ ಆ ಕಂಪನಿ ಇದೆಲ್ಲ wound up ಆಗ್ಬಿಟ್ಟಿರ್ತಾರೆ. These are temporary companies, my lord. ಅಷ್ಟೇ. Whereabouts of those companies will never be known to us. This is all rustic villagers who have come here for doing electrical work and labor work. The fact remains that
7 ಜನರು ಹೋಗುತ್ತಿದ್ದೆವು. ಅದು ಸರಕು ಸಾಗಣೆ ವಾಹನ ಅಂದ್ರೆ ಗೊತ್ತಿಲ್ಲ. ನಾವು ಅದರಲ್ಲಿ ಪ್ರಯಾಣಿಕರು ಹೋಗುತ್ತಿದ್ದ. What is the finding of the tribunal?
finding is
on this aspect, judgment eligible.
there are 30 minutes.
MEC judgment.
The learned counsel for the second respondent has argued that deceased and injured persons
Sarah?
were
30.
traveling in the said vehicle as a coolie, and they are under the employment of the first respondent. Therefore, the respondent number 1 is not liable to pay compensation in this regard. He has canvassed the judgment of High Court of Karnataka reported in so and so that is extracted. It is an admitted fact that petitioner were working as a laborers, but is no material before this court to say that they were working under the respondent number 1. Either the evidence of the petitioner or the case papers on record do not disclose that they were employees under the respondent number 1. The learned counsel for the second respondent has also not at all elicited regarding this aspect, and therefore the arguments of the learned counsel for the second respondent is not acceptable. And also the fact and circumstances of the reported judgment of the and fact of the circumstances of the present case on hand are entirely different. The proposition of law laid down about the reported judgment is not applicable to the present case on hand. That is the only, my lord, they're finding. Last occasion, my lordship, this one also has been observed. Nam grounds, nam iduna enno pleadings idu ಮಾಡೇ ಇಲ್ಲ ಅಂತ ಹೇಳಿಬಿಟ್ಟು ತಾವು.
They are saying that
We
you
were
have not
saying-
proved that
Yes.
they are
Employees of the
employees of so.
insurance.
That is what they are.
But we have contended
They
that
are
sir,
not
they were
employees of
gratuitous
you.
passenger.
You can't take that benefit of their evidence and saying that.
No, my lord, this argument not at all addressed by me, my lord, and in the written statement also, we have not taken such a contention. We
That,
have taken a contention that, that's what my lord, last occasion, my lordship has observed.
Yes, what is your
They were
contention?
gratuitous passenger traveling in the goods vehicle. We have not at all contended that there are the coolies are working under respondent or not. That's what my lord observed by this
Yes.
last occasion. Written statement to ಓದಿದ್ವಿ.
For this court to say that they were working under that. Has stated that deceased and injured person were traveling the said vehicle as a coolie. They are under that employment of the respondent.
This is not our case, my lordship.
Yes.
Written
Your case
statement-
is that they are not
They were proceeding in a
Our
goods
case is
vehicle as a
also not
gratuitous
that they are
passenger.
employees of owner, vehicle owner.
Gratuitous passenger, your
case is
written statement.
gratuitous
ಹೌದು,
passenger, but
ನಾವು
you
evidence
have put in a
ಕೊಟ್ಟಿದ್ದೆ.
suggestion saying that they are going along with that goods.
ನಾವು ಇದನ್ನ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇಲ್ಲ ಸುಮ್ಮನೆ.
Yes.
So they
Even-
have
Even
Total
if you
finding-
remove that, your case is that they are a gratuitous passenger, but you have suggested them that traveling along with that goods
Along with
itself
the
is.
Lord, we have not suggested that, Lord, you are ಪ್ರಯಾಣಿಕರಾಗಿ ಗೂಡ್ಸ್ ಮೇಲೆ ಕೂತ್ಕೊಂಡಿದ್ದೀರಿ ಅಂತ ಹೇಳಿರೋದು ನಾವು.
That means to say there is a goods.
ಪ್ರಯಾಣಿಕರಾಗಿ ಮಿಲಾಡ್ ಗ್ರಾಚ್ಯುಟಸ್ ಪ್ಯಾಸೆಂಜರ್ ಆಗಿ.
ಪ್ರಯಾಣಿಕರಿಗೆ ಸ್ವಂತ ಬಲವರ ವಾಹನದಲ್ಲಿ ಕೇಬಲ್ಗಳ ಮೇಲೆ ಕುಳಿತುಕೊಂಡು.
ಹೌದು, ಪ್ರಯಾಣಿಕರಾಗಿ ಸಜೆಸ್ಟ್ ಮಾಡಿರೋದು ನಾವು.
ಆ ದಿನ ಪ್ರಯಾಣಿಕರಾಗಿ ಸ್ವಂತ ಬಲವರ ವಾಹನದಲ್ಲಿ ಕೇಬಲ್ಗಳ ಮೇಲೆ ಕುಳಿತುಕೊಂಡು ಬರುತ್ತಿದ್ದಾಗ ನಿಮ್ಮ ಅಜಾಗರೂಕತೆಯಿಂದ ನಾವು ಕೆಳಗೆ ಬಿದ್ದು. That means to say there was a cable.
cables were
Cable is there, my lord, but they are not the.
Now question is that whether it is
FIR
belongs to them or not.
FIR
Their
indicates.
pleading is that it is belongs to them.
Yes. FIR indicates that they, after laying of cables in some place, they were proceeding to another place. So under these circumstances, our contention that we are proceeding along with goods is to be held as proof. Number one. Number two, in the WP judgment which I had already produced, I think 15% sala, 11. Writ petition, 11 persons were proceeding. What is?
Justice Mohammed Anwar
Yes,
judgment.
yes, yes. Seven claims. 11 claimants were there. They were all contending that they were proceeding along with their goods. And it appears, it was also held that they were proceeding along with the goods.
Yes.
And out of them, since it was a heavy goods vehicle, because of Rule 100, which permitted 7 persons are permitted to be carried along with goods. So 7 highest awards were satisfied by the tribunal. So the in the writ petitions
Their
filed,
liability can be extended only 3.
only in this case 3. In that case, reported judgment 7.
7 means there is a heavy.
Heavy goods vehicle, yes. So that is one aspect. Whether more than one persons could hire the same vehicle is, I am fortified by one more judge is told.
No, hiring the vehicle can be clubbed together, so many
Yes,
persons can be hired.
because
But
Rule
it's
4
not the-
itself says. Yes.
He's saying that for one goods, for one owner, representative
That,
is only.
that I concede, only one.
Your case is that you are not the representative of the owner. You are
Yeah,
saying
no,
that you
we-
yourself
yes,
is the owner
yes.
of the goods.
Yes. ಈಗ ನಮ್ಮ ಹತ್ರ ಗೂಡ್ಸ್ ಇಂಡಿಪೆಂಡೆಂಟ್ ಆಗಿ ಕೊಟ್ಬಿಡ್ತಾರೆ.
Yes, which is that,
So it is.
yes. Which is the paragraph you want to read?
Para 6, rule 5, sorry, para 5, then 6.
Yes. Very poor. Age.
It was with,
Yes, read para 5.
5, at that time it was 5. With reference to the judgment accident date. 5 plus 1,
Yes.
2 plus 1 for light vehicle.
You read that para.
Then para 6, I think may be relevant. In the rural lifestyle of India, with very poor inadequate transport infrastructure, the agriculturists often jointly engage goods vehicle for transportation of their agricultural produce. In such a situation, the owners or representatives of the goods are eligible to travel along with their goods. The number of such owners, representatives should not exceed permitted seating capacity as stated in Rule 100.
Even owner can represent so many representatives.
That is why in the another reported judgment, 7 highest awards were settled. In present case, I have demonstrated that the weight vehicle, as per the vehicle weight, 3 persons are permitted.
Quantum, you have any submission, Mr.
Regarding that,
Quantum ಒಂದು enhancement ಆಗಬೇಕು ಮತ್ತು ಅವರದ್ದು ಇನ್ನೊಂದರಲ್ಲೂ enhancement ಆಗುತ್ತೆ. ನಾವು ಕೇಳಿಲ್ಲ.
Rule 100 is concerned, my lord. I am relying upon the judgment of the Samba court.
ಯಾವುದು? ಏನಂತ?
Para 11, other owner of the goods or representative, so. From Rule 100, place to place over.
Yes, para.
Para 11 onwards, there is a discussion regarding that owner of the goods or representative of the goods is concerned. Para 11, my lord.
ಅದೇ 47 extract ಮಾಡ್ತಾರೆ.
ಹೌದು, 47
100 extract ಮಾಡ್ತಾರೆ. ಆಮೇಲೆ
ಮಾಡ್ತಾರೆ.
finding
ಫೈಂಡಿಂಗ್ my lord, ಇದರಲ್ಲಿ ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪನಿ ಅಪೀಲ್ ಅಲೋ ಆಗುತ್ತೆ ಸ್ವಾಮಿ. Rule 100 cannot be applicable to the fact of the case is concerned, my lord. He cannot travel one city to another city. If he is become a loader and unloader, in the city only, my lord, they have to operate. ಇದರಲ್ಲಿ ಅಮಲಿಯಾಗಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ ಈ ಕೇಸಲ್ಲಿ. ಅದಕ್ಕೆ my lord, Rule 100 ಯಾವಾಗ ಅಪ್ಲಿಕೇಬಲ್ ಆಗುತ್ತೆ, ಯಾವಾಗ ಆಗಲ್ಲ ಅಂತ ಹೇಳಿ ಡಿಸ್ಕಷನ್ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ. ಎಲಾಬ್ರೇಟ್ ಡಿಸ್ಕಷನ್ my lord. Para 17 onwards.
ಅದ್ರ ಮೇಲೆ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ.
Yes.
This case, the present case is also, my lord, the laden and weight of the vehicle is 2,750 kilograms. Para 10 ನಲ್ಲಿ ಅದನ್ನ ಹೇಳಿದ್ದಾರೆ ಎಷ್ಟು ತೂಕ ಅನ್ನೋದ್ರ ಬಗ್ಗೆ. Para 17, my lord, the Rule 100 has been extracted in all the pages, 16 and 17.
Provision upon perusal of executive insurance policy, it is date of the accident, but there was no extra premium paid to that as per the certificate. Where is the discussion? Because where they have said
Para 15 ಅಲ್ಲಿ Rule 100 ಬಗ್ಗೆ ಸ್ಟಾರ್ಟ್ ಆಗ್ತದೆ ಸ್ವಾಮಿ. Para 15 ಇಂದ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದ್ರು. Next, my lord, Para 16, my lord, the present case admittedly the registered laden weight 2,750 kgs. Therefore, as per the class 2 of sub rule 1, Rule 100 of KME rules 1989, only 3 persons who are the employees are permitted to travel, but where the vehicle is traveling from one city to another city, then this provision is not applicable.
Why?
In the present case, the rule 100 says like this, my lord.
Where is that?
Please, my lord. Rule 100, previously, my lord, it has been extracted.
Second proviso. That
In any other
there is
light
a
transport
judgment on
vehicle,
this. It is not mandatory ಅಂತ. Directory ಅಂತ ನಮ್ಮ ಹೈಕೋರ್ಟ್ judgment ಇದೆ.
ಏನಿದೆ? Subject to the provisions of this one, please carry the vehicle provided. Where is that? Not
Second
from
class 2, my lord.
Class 1 ದಲ್ಲಿ second proviso.
Hmm.
Provided
Sub rule
that
1.
Provision so and so of the above
Subsection
provision shall not be
2 and
applicable to the
3
vehicle plying on interstate routes or
or the
vehicle
vehicles
carrying a goods from one city to
another
city.
city.
Yes. What do you say about
So,
that?
on
He
this
is traveling
aspect-
from where to where?
My lord, ನಂಜನಗೂಡಿಂದ ಬೇರೆ
No, no, no. Not from Nanjanagud.
ನಂಜನಗೂಡಿನಲ್ಲಿ ಪ್ರಯಾಣ ಸ್ಟಾರ್ಟ್
One
ಮಾಡಿದ್ದು.
village ಇಂದ next place ಗೆ ಹೋಗ್ತಾ ಇದ್ದದ್ದು.
Which is that place?
FIR ದಲ್ಲಿ
ಕೇಳಿ.
ಅಲ್ಲ.
My lord, ಗುಂಡ್ಲುಪೇಟೆ they have started, my lord. ಗುಂಡ್ಲುಪೇಟೆಯಿಂದ ಹೆದ್ದಾರಿಯಲ್ಲಿ ವಿದ್ಯುತ್ ಕಂಬಗಳು ಸಾಗುವ ಎಲೆಕ್ಟ್ರಿಷಿಯನ್ ಆಗಿ ಕರ್ತವ್ಯ ಮಾಡಿಕೊಂಡಿದ್ದು ಸುಮಾರು ಮಧ್ಯಾಹ್ನ 1:30 ಸಮಯದಲ್ಲಿ ನಂಜನಗೂಡಿನ ಸಿಂಧುವಳ್ಳಿಯಿಂದ
ಅಲ್ಲಿಗೆ ಬಂದು ಕ್ಲೋಸ್ ಮುಗಿತು.
ಬಂದು ಪಿಕಪ್.
Only it is not too.
ಸಿಂಧುವಳ್ಳಿ is not a city.
ಗುಂಡ್ಲುಪೇಟೆಯಿಂದ ಟ್ರಾವೆಲ್ ಮಾಡಿರೋದು. ಗುಂಡ್ಲುಪೇಟೆಯಿಂದ.
FIR ತೆಗಿರಿ. Yes.
ಪ್ಲೀಸ್ ಮೇಡಮ್. ಅವರು ಕರ್ನಾಟಕ ಮೈಸೂರಿನಿಂದ ಗುಂಡ್ಲುಪೇಟೆ ಅಂದ್ರೆ ಪ್ಲೇಸ್ ಟು ಪ್ಲೇಸ್ ಟ್ರಾವೆಲ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅದರಲ್ಲಿ.
ಈಗ ಅಲ್ಲಿ ಹೋಗ್ತಾ ಇದ್ದಿದ್ರನ್ನ ಎಲ್ಲಿಗೆ ಅಂತ ನೋಡೋಣ ಏನ್ ಹೇಳಿ.
ಪ್ಲೀಸ್ ಮೇಡಮ್, ನಂಜನಗೂಡಿನ ಸಿಂಧುವಳ್ಳಿಯಿಂದ ಮಹೇಂದ್ರ ಪಿಕಪ್ ವಾಹನದಲ್ಲಿ ಚಾಲಕನಾಗಿ ರೋಹಿತ್ ಇದ್ದು ಅವನ ಜೊತೆ ಕ್ಯಾಬಿನಲ್ಲಿ ನಿತೀಶ್ ಕುಮಾರ್ ಇವರೆಲ್ಲರೂ ಇದ್ದು ಮುಗಿಸಿಕೊಂಡು ನಂಜನಗೂಡಿನ ಕಡೆಗೆ ಬರುವಾಗ ಕಳಲೆ ಗೇಟ್ ಹತ್ತಿರ
ಕಂಪ್ಲೇಂಟ್ ಇಲ್ಲ.
ಅದೇ ಸಿಂಧುವಳ್ಳಿ ಹತ್ರ ಕೆಲಸ ಮುಗಿಸಿ
ವಿಷಯಕ್ಕೆ ಈ ಸುಮಾರು ತಿಂಗಳು ಕರ್ನಾಟಕ ಮೈಸೂರು ವಿದ್ಯುತ್ ಕಂಬಗಳು ಹಾಕುವ ಎಲೆಕ್ಟ್ರಿಕ್ ಆಗಿ ಕರ್ತವ್ಯ ಮಾಡುತ್ತಿದ್ದು ದಿನಾಂಕ 1 ಸುಮಾರು ಮಧ್ಯಾಹ್ನ 1:30 ಸಮಯದಲ್ಲಿ ನಂಜನಗೂಡಿನ ಸಿಂಧುವಳ್ಳಿ ಮಹೇಂದ್ರ ಪಿಕಪ್ ವಾಹನದಲ್ಲಿ ಚಾಲಕ ರೋಹಿತ್ ಸೋ ಹಿಂದಿನ ಕ್ಯಾಬಿನೆಟ್ ಸೋ ಕೆಲಸ ಮಾಡ್ತಾ ನಾವುಗಳು ಸೋ ಕೆಲಸ ಮುಗಿಸಿ ಕೇಬಲ್ ಕೆಲಸಕ್ಕೆ ನಂಜನಗೂಡು ಕಡೆಗೆ ಬರುವಾಗ ಸಿಂಧುವಳ್ಳಿಯಿಂದ ನಂಜನಗೂಡು ಅಷ್ಟೇ.
ಸಿಂಧುವಳ್ಳಿ ಇಸ್ ಎ ವಿಲೇಜ್.
ಸಿಂಧುವಳ್ಳಿಯಿಂದ ನಂಜನಗೂಡು ಅಷ್ಟೇ.
ಗೇಟ್ ಹತ್ರ ಆಗಿದೆ ಇನ್ಸಿಡೆಂಟ್.
And so far as
that taluk only they are traveling here.
That is one aspect, madam. And so far as this proviso is concerned, their lordships, Justice Dikshit, as he then was sitting in single judge, has held, I think in 2019, that this proviso, which restricts flying of vehicle, that is carrying of goods from one city to another is prohibited, is not mandatory, but it is directory. The reason is this, my lord. In between also, some persons will have to carry the goods.
Yes, I read somewhere else his judgment.
Yes. ನಮ್ಮ compilation ದಲ್ಲಿ ಇದ್ದಿರಬಹುದು.
No, we see yours is within that.
I think otherwise it is in my book also.
No, see somewhere I have read that judgment.
It is
your case
compilation
is that, Mr. But I will tell you, your case is that from Sindhuvalli to Nanjangud, it is not from one city.
Not even Nanjangud side. Next place.
If it is one city to one city, if you are relied on that judgment, then I have to refer because there is a two different.
Yes.
Now your case is not that.
Yes.
Why should I go all these things?
Yes. Here, this rule is not applicable.
That is, I said, I have read that, I think 2-3 years back itself.
Yes.
It is said that it is not mandatory.
It is only directory ಅಂತ ಹೇಳಿದ್ದಾರೆ. Therein actually I represented for mostly insurance company, most probably.
Yes.
ಯಾಕಂದ್ರೆ ಆವಾಗ ನಾನು ಕಂಪನಿ ಇನ್ನು ಬಿಟ್ಟಿರ್ಲಿಲ್ಲ.
Yes. Now that what is about this thing, Mr. Enhancement?
Cross objection ದಲ್ಲಿ ನಮ್ದ್ರಲ್ಲಿ
ಅವ್ರದ್ದು ಮುಗಿಲಿ ಅವ್ರು they have filed appeal against all three.
ನಮ್ದ್ರಲ್ಲಿ ಕ್ವಾಂಟಮ್ ಇಲ್ಲ, ಓನ್ಲಿ ಲಯಬಿಲಿಟಿ ಇಶ್ಯೂ.
ಲಯಬಿಲಿಟೀಸ್ ಮೇಲೆ. ನಿಮ್ದು ಕ್ವಾಂಟಮ್ ಯಾವ್ದ್ರಲ್ಲಿ
541 of 17
ಕೇಸಲ್ಲಿ ಇನ್ಕಮ್ 500 rupees ಜಾಸ್ತಿ ಆಗ್ಬೇಕು, ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ತಗೊಳ್ಬೇಕು ಅಷ್ಟೇ.
Yes, so what about that, madam, you driver?
Regarding substitution of driver connection.
Yes, driver substituted complaint itself is clearly said.
Prima facie document.
What is the tribunal said regarding that?
ಏನು ಫೈಂಡಿಂಗ್ ಕೊಟ್ಟಿಲ್ಲ, ಅದಕ್ಕೆ ಸಮೇತ ಲಾಸ್ಟ್ ಅಕೇಶನ್ ನೋಟಿಸ್ ಮಾಡಿದ್ರು, ಅದ್ರ ಬಗ್ಗೆ ಏನು ಫೈಂಡಿಂಗ್.
Send it back for the driver is concerned. Let them, this thing, reconsider that. Yes.
So liability aspect payment ಮಾಡಿಸಿ ಹೋಗ್ಬೋದು.
Yes, pay and recovery, that subject to that, see, since there is no issue on that point.
ನೋ ಇಶ್ಯೂ.
And there is no discussion.
No
Say that tribunals to reconsider that. If the insurance companies succeed, they are liberty to recover from the owner of the offending vehicle.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಪ್ರೈಮಾ ಫೇಸಿ ಡ್ರೈವರ್ ಹೆಸರೇ ಬಂದಿದೆ ಸ್ವಾಮಿ, ಪೇನ್ ರಿಕವರಿನೇ ಮಾಡ್ಬಿಟ್ಟು ಇಲ್ಲೇ ಕ್ಲೋಸ್ ಮಾಡಿದ್ರೆ
ಮಾಡಿಸಿ ಸಾಕು.
ಮತ್ತೆ ಅನ್ನೆಸೆಸರಿ ಅಲ್ಲೋರು ಮತ್ತೆ ಇನ್ನೊಂದು ಎವಿಡೆನ್ಸ್ ಕೊಟ್ಟು ಫರ್ದರ್ ಇನ್ನೇನು ಆಗುತ್ತೆ, ಯಾಕಂದ್ರೆ ಕೆಪ್ಟಪ್ಪನ್ ಅಂತ ಹೇಳ್ತೀರಾ ಮತ್ತೆ ಕಡೆಗೆ.
ಅಲ್ಲಿ ಹೋದ್ರು ಇನ್ನೇನ್ ಫರ್ದರ್ ಇಂಪ್ರೂವ್ಮೆಂಟ್ ಏನು
ಏನು ಇಲ್ಲಿ ಏನ್ ಟ್ರಿಬ್ಯುನಲ್ ಅವ್ರು ಏನ್ ಹೇಳಿದ್ದಾರೆ?
ಅದೇ ಸ್ವಾಮಿ, ಅವ್ರ ಫೈಂಡಿಂಗೇ ಬೇರೆ ಕೊಟ್ಟಿದ್ದಾರೆ, ನಮ್ ಕೇಸೇ ಬೇರೆ, ಅವ್ರ ಫೈಂಡಿಂಗ್ ಕೊಟ್ಟಿರೋದೇ ಬೇರೆ.
ಅಲ್ಲ, ಈ ಡ್ರೈವರ್ ಬಗ್ಗೆ ಏನು ಹೇಳಿಲ್ಲ.
ಇಲ್ಲ ಬಿಕಾಸ್ ದೇರ್ ವಾಸ್ ನೋ ಪ್ಲೀಡಿಂಗ್,
Yes.
ಸ್ಪೆಸಿಫಿಕ್ ಇಶ್ಯೂ ಇರ್ಲಿಲ್ಲ. ಸೊ
ಅಲ್ಲಿ ಓನರ್ ಅಪಿಯರ್ ಆಗಿದ್ರ?
ಓನರ್ ಅಲ್ಲಿ
ಹೌದು
ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಏನು? What is his defense?
Respond number appear
So, written
counsel my lord
statement
and denied the
document-
entire petition averments and further contended the
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಅವನ ಹೆಸರು ಬಂದಿದೆ.
ಕೇಸರ್ ಖಾನ್ ಅಂತ ಇದೆ.
Then investigation officer has to be examined how he has. Then in respect of that will kept open. Because their defense is he may given a false complaint, but he don't know that who is the driver.
ಬಟ್ ಅದ್ರಲ್ಲಿ ಏನು ಹೆಸರುಗಳು ಎಲ್ಲರದ ಹೆಸರು ಹೇಳ್ತಾರಲ್ಲ, ಆ ಎಲ್ಲ ಇಷ್ಟ ಜನ ಹೋಗ್ತಾ ಇದ್ವಿ ಇನ್ಕ್ಲೂಡಿಂಗ್ ಡ್ರೈವರ್ ನೇಮ್ ಅಲ್ಲಿ, ಅಟ್ಲೀಸ್ಟ್ ಆ ಕೇಸರ್ ಖಾನ್ ಹೆಸರು ಇದ್ದಿದ್ರೆ ಮಿಲಾಡ್ಶಿಪ್ ವುಡ್ ಹ್ಯಾವ್ ಸಸ್ಪೆಕ್ಟೆಡ್ ದಟ್.
ಅಲ್ಲ, ಅವನಿಗೆ ಡ್ರೈವರ್ ಹೆಸರು ಗೊತ್ತಿದ್ಯೋ ಇಲ್ಲೋ ಗೊತ್ತಿಲ್ಲ, ಅವ್ನು ಯಾವನೋ ಒಬ್ಬ ಟ್ರಾವೆಲ್ ಮಾಡೋನು ಯಾವ್ದೋ ಬಸ್ಸಿಗೆ ಹತ್ಕೊಂಡ್ಬಿಟ್ಟು ಬಸ್ ಡ್ರೈವರ್ ಯಾರು ಅಂತ ನಂಗೆ ಕೇಳಿದ್ರೆ ಏನ್ ಗೊತ್ತಾಗುತ್ತೆ?
ಅವರೆಲ್ಲರೂ
ಕಂಪ್ಲೇಂಟ್ ಸುಮ್ಮನೆ ಯಾವ್ದೋ ಹೆಸರು ಕೊಟ್ಟಿದ್ದೀನಿ. But owner has appeared, denied. He has taken a contention that so and so driver, but burden is on them to prove. That has not been discussed. That will go to that, and the investigation officer by charge sheet said that so and so is driver. Let them also examine.
Please.
Yes. She P. Pradeep, learned counsel appearing for. Insurance company has contended that.
ಪೇಮೆಂಟ್ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ ಈಗ. ಲಯಬಿಲಿಟಿ ಆಸ್ಪೆಕ್ಟ್
The climates.
Liability is hoisted on insurer.
And that deceased, who is deceased?
Deceased is Prabhakar.
Climates and the deceased Prabhakar were traveling in that offending vehicle as a passenger.
Along with electrical goods.
No, their case is that they are the passenger.
Gratuitous person, our contention.
Yes, gratuitous passenger. Therefore, insurance company is not liable to pay that compensation. Gratuitous passenger, since offending vehicle is a goods vehicle, the insurance company is not liable to pay the compensation. He further contended that in the complaint and FIR, it is not stated that they are traveling along with the goods. Only in the pleading first time they have taken the contention that they are traveling along with the goods.
ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಲ್ಲೂ ಅಲಾಂಗ್ ವಿತ್ ಗುಡ್ಸ್ ಇಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರ ಲೇಬರರ್ಸ್ ಅಂತ ಗುಡ್ಸ್ ಇಲ್ಲ.
Pleadings ಅಲ್ಲಿ ಇದೆ.
ದೇ ಆರ್ ನಾಟ್ ಟ್ರಾವೆಲಿಂಗ್ ಅಲಾಂಗ್ ವಿತ್ ಗುಡ್ಸ್ ಮಿಲಾಡ್, ಅವರ ಮೇರೆಗೆ ನಾನು ಕೂಲಿ ಕೆಲಸ ಮಾಡಿಕೊಂಡು ಹೋಗ್ತಾ ಇದ್ದೆ.
ಈ ತರ in the FIR and the complaint, it is not mentioned that they are traveling along with the goods. There is no pleading to that effect. Tribunal, beyond the pleading, has held that the claimants are traveling along with the goods and the insurance company is liable to pay the compensation.
Secondly, he has contended that even assuming that for the sake of the arguments, they are traveling along with the goods as per section 147. Motor Vehicles Act. The owner of the goods or one of his representative entitled for compensation. In this case, there are three claim petition. Therefore, they are not entitled for the compensation. He further contended that even under Rule 100 of Karnataka Motor Vehicles Act, in any other light transport goods vehicle, three persons can travel if it is vehicle is playing between, if the vehicle is playing between two cities, then the rule 100 is not applicable. Without considering all these aspects, tribunal has error in held that in this support he has relied on judgment of this court in MFA 9192 of 2018, disposed of on 28th November 2022. He further contended that in the complaint, it is specifically stated that one Rohit was driving that vehicle. FIR is also registered that Rohit was the driver. First time in the charge sheet, it is mentioned that what is the Khan?
Kesar Khan.
Kesar.
Kesar Khan.
KESAR.
KESAR. Initial alla.
KAIS.
Kaisar Khan. Kaisar Khan was the driver of the offending vehicle. Since to make a false claim, they have implicated the driver. Even though the owner of the offending vehicle has examined Madidara, Madilla, appeared and filed a written statement.
Written statement accurate.
But he has not entered in a witness box, or they have not examined that investigation officer to prove that Kaisar Khan was driving that vehicle. Therefore, he contended that liability fixed on the insurance company by the tribunal is contrary to the material available on record, hence sought for allowing that appeal. Per contra, so and so learned counsel appearing for the claimant has contended that the specific case of the claimants that they are the electric cable laying workers. They are working on a peace contract basis.
all the claimants are traveling, claimants and deceased so and so was traveling along with their electric goods belongs to them. Even in the cross-examination, the insurance company has suggested that they were traveling, they were sitting on the, they were traveling as a passenger, sitting on the electric goods. Therefore, it is admitted fact that there was a goods in the offending vehicle when the claimants were traveling. Secondly, he has contended that even though under section 147, the owner of the goods or his authorized representative is entitled for a compensation. But in Karnataka motor vehicles rules, Rule 100, in respect of light transport vehicle, it is permitted to travel not more than 3 persons. Since there are 3 claimants, they are entitled for compensation. In support of his contention, he has relied on judgment of this court in 2001 ACJ 208 and ILR 2006 Karnataka 947. So and so learned counsel appearing for the owner of the offending vehicle has contended that they have filed in a written statement, has taken a specific contention. The offending vehicle was, where is that written statement? He is RW, respondent number 1. ಅವ್ರೇನ್ ಪ್ಲೀಡಿಂಗ್ ಅಲ್ಲಿ ಹೇಳೇ ಇಲ್ಲ ಅಲ್ರಿ. He has not said that.
It is formal denial. It's a formal denial.
No,
of all
he is
claims.
denied all other things, but he has not said knowledge the respondent Kumar and that co-owner so ಅದನ್ನ ಹೇಳ್ತಾರೆ. ಡ್ರೈವರ್ ಇವನು ಅವನು ಅಂತ ಹೇಳಲ್ಲ.
ಇಲ್ಲ, ಏನೂ ಇಲ್ಲ.
Yes, madam.
ಅದೇ ಇಲ್ಲೇ ಮುಗಿಸ್ಬೋದು.
Where is that you have said that he is not the driver?
There is no. There is no contention, my lord. There is no contention with regard to the driver, my lord.
That is the only a ground you have urged. Body one co-owner by name Prabhakar who died in the spot. ಅಷ್ಟೇ ಹೇಳ್ತೀರಾ implementation, driving so and so. Use financial crisis. But tribunal has not discussed that. See, if they have not taken a contention, if they have taken a contention that they have implicated, there should be an answer for that. Yes. So and so learned counsel appearing for the owner of the offending vehicle has contended that as per the charge sheet, Khair Khana
Kaisar
was driving that offending vehicle. He was holding effective driving license. The offending vehicle is covered by insurance policy. The tribunal has rightly held that insurance company is liable to pay the compensation. Or in respect of MEC ಯಾವ್ದದು?
541.
541 2017.
541 ಅದ್ರಲ್ಲಿ ಏನು ಇನ್ಕಮ್ ಎಷ್ಟು ಆಗಬೇಕು?
500 rupees ಜಾಸ್ತಿ ಆಗಿ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ತಗೋಬೇಕು.
500 rupees ಜಾಸ್ತಿ ಆಗ್ಬೇಕಾ?
ಹೌದು.
6 ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
9000 ತಗೊಂಡು.
9500 ಆಗ್ಬೇಕು.
ಹೌದು.
9000 ಅದೊಂದು ಇದ್ರದ್ದು ಹಾಕಳಿ. In cross objection, so and so contended that at the time of the accident, deceased was earning 15,000. Tribunal has assessed 9,000 is on lower side. Future prospects ಕೊಟ್ಟಿಲ್ವಾ?
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ.
Future prospects is not awarded. And in view of the judgment of so and so, claimants are entitled for. ಅದನ್ನ ಇವ್ರದ್ರಲ್ಲಿ ಡಿನೈ ಮಾಡಿರೋದು ಹಾಕಿ. Heard the learned counsel for the parties. Peros, judgment and award and original records. The case of the claimants that on 8/12/2016 at about 1:30 p.m. when the petitioner in MEC 539-17 MEC 540 of 17 and husband of the petitioner number 1 of MEC 541 of 2017 were proceeding from Sindhavali village to Nanjangud in Bolero pickup van bearing registration number KA 55-0269. When they came near Kaleli gate, at that time, driver of the said vehicle was drawn the same in rash and negligent manner, dashed against the drainage, which was situated left side of the road. Due to that, the vehicle toppled. Result of it, the husband of the petitioner number 1 in MEC 541 of 2017 sustained grievous injury, succumbed to that injury. The claimants in that other claim petition was suffered an injury. After recovering from the injury, the claimant has filed a claim petition. They have taken a specific contention in the claim petition, para 22, subclass 2 extract ಮಾಡಿ. The specific case of the claimants that they were traveling in that offending vehicle towards Nanjangud for electric cable works along with the electrical goods. After completion of their work at Sindhuvalli village through Bolero pickup, in ಅಲ್ಲ ಅದನ್ನ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡ in claim petition they have specifically stated that ನಾನು ಹೇಳಿದ್ದನ್ನೇ ಅಷ್ಟು ಸರ್. in their evidence. PW1 ಅನ್ನಿದ್ರೆ. PW1 evidence.
Para 3, we have stated.
In para 3, they have stated extract ಮಾಡಿ. In the cross-examination of claimants by the insurance company, they have suggested that they are traveling on the goods vehicle as a passenger sitting on the electric cable. Therefore, it is very clear that there was a electric cable in the offending vehicle. It is also not disputed that they were traveling in that goods vehicle. The specific case of the claimants that they are the laborer work for digging the trench for installation of the electric pole. And they are doing that work on a piece contract basis. Each workers traveling along with the electric goods belongs to them. From the evidence of PW1 to PW3, who is for Karthik TY?
For Karthik TY.
It is very clear that they are traveling along with the goods. Next para. Therefore, the contention of the appellant that the claimants are traveling as in a gratuitous passenger cannot be accepted. The second contention of the appellant that even under section 147 of Motor Vehicles Act, either the owner or one of the representatives of the owner as entitled for compensation. Under the Motor Vehicles Act, the Karnataka Motor Vehicles rules has been framed under section 100. Under rule 100, rule 1, subclass 2. Rule 100, subclass 1 extract ಮಾಡಿ provisory, subclass 2 ಬೇಡ 1 extract.
The offending vehicle is a light transport goods vehicle. As per rule 100, 3 persons can be traveled. Even this code in 2001 ACJ 208, which is the relevant paragraph. But in this code that said the offending lorry is so and so. Employees of the owner, bearer of the vehicle or what that matter. Para 5. And 2006 Karnataka 947.
ILR 2006.
ILR, para 5 and 6. In view of the above, since there is only a 3 claim petition, the claimants are entitled for the compensation. In respect of implication of substitution of the driver is concerned, the insurance company has taken a specific contention that in the FIR, it is specifically stated that one Rohit was a driver driving that offending vehicle. The owner of the offending vehicle has filed in a written statement. He has not denied that. In the charge sheet, the name of one Kais Khan has been mentioned. Kaisar Khan has been mentioned. Since Rohit has no driving license to make a false claim, they have implicated the driver, they have substituted the driver. Tribunal has not framed any issue in these aspects. Neither of the parties has not examined that investigation officer. Therefore, only in respect of this issue is concerned, matter requires to be remitted back to the tribunal. In respect of payment of compensation is concerned, since offending vehicle is covered with valid insurance policy, the insurance company has to pay that compensation amount with liberty to recover from owner of the offending vehicle in case it is proved that driver has been substituted. In respect of MEC
141.
MFA crab
28.
arising out of MEC 541 of 2016.
17.
2016. N17. MEC yaudri? 2017. Yes. 539 of 2017. I am mentioning that MEC, Mr. Yes. The claim petition is filed by legal representatives of deceased Prabhakar.
5 and 1 year child.
Even though they have claimed that deceased was earning 15,000 per month, they have not produced any document to establish the same. Therefore, notional income has to be assessed as per the guidelines for the accident occurring 2015, 2016, the notional income has to be considered as 9,500. In view of judgment of apex court in case of Pranay Sethi, what is his age?
32 years.
32. 40%.
40% of the income of the deceased has to be added for future prospects. 1/3 of the income of the deceased has to be deducted for personal expenses. The multiplier applicable to that age group is 16. Accordingly, loss of dependency has been reassessed as follows.
9,500 plus 3,800 at the rate of 40%, 13,300 minus 4,433 at the rate of 1/3, 8,867. 8,867 into 12 into 16, 17 lakhs, 2,464.
In addition, 15,000 for loss of estate, 15,000 for funeral expenses. The first claimant is entitled 40,000 for spousal consortium. Claimant number 2 is entitled 40,000 for parental consortium. Interest ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
Interest 6%.
6%. Accordingly, the appeals are disposed of. One, that matter is remitted back to the tribunal only in respect of
One submission. In so far as interest aspect is concerned, there is 350 days, 350 delay in filing cross objection.
Yes, not entitled for that interest. Not entitled for the interest for a period of 360 days.
350
350
in filing
for
cross
enhanced
objection.
compensation amount. Matter was remitted back to the tribunal only in respect of whether the driver has been substituted by the owner to make a false claim. If it is proved that driver has been substituted, the Rohit, a driver is substituted, then insurance company is at liberty to recover from owner of the offending vehicle. Mood matter banta.
Amount in deposit, maybe
Amount in deposit is transferred to the tribunal.
for disbursement in favor of petitioners.
Adu as per that,
set
you
aside.
have to apply in the tribunal.
ಅವ್ರಿಗೆ direction, deposit direction ಕೊಡ್ಬೇಕಲ್ಲ.
Directed to deposit with liberty to recover if they succeed on. Yes.
230 mood matter. Hearing matter, serial number 1, Umashankar MN. Government advocate.
Yes, Mr.
In this matter,
Hmm.
application of for resumption was filed after lapse of 54 years.
54 years. You are the
54 years, my lord.
the purchaser. Date of the grant?
Date of grant is 25/8/1960.
60.
Yes, my lord.
Sale?
Sale is 69.
Application file ಮಾಡಿರೋದು?
Application file ಮಾಡಿದ್ರೆ 2014.
14. Yes, ತಳಿ.
My lord, very importantly, my lord, that should kindly say, my lord, page 21, my lord. ಒಳಗಡೆ ಲಾಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಹಾಸನ ವಿಭಾಗ ಹಾಸನ ಅವರ ಆದೇಶ ಸಂಖ್ಯೆಯನ್ನು ರದ್ದುಪಡಿಸಿದೆ. ಮೇಲ್ಕಂಡ ಎಲ್ಲಾ ವಹಿವಾಟುಗಳನ್ನು ಅಸಿಂಧು ಘೋಷಿಸಿದೆ. ಪ್ರಸ್ತಾಪಿತ ಜಮೀನನ್ನು ಎಲ್ಲಾ ಋಣಗಳಿಂದ ಮುಕ್ತಗೊಳಿಸಿ ಮೂಲದಾರರಾದ ಕಾನೂನುಬದ್ಧ ವಾರಸುದಾರರಿಗೆ ಮರು ಮಂಜೂರಾತಿ ನೀಡಿ ಹಕ್ಕು ದಾಖಲೆ ಸ್ವಾಧೀನವನ್ನು ಬಿಡಿಸಿಕೊಡಲು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಹೌದೌದು. ಅದು ಡೈರೆಕ್ಷನ್ಸ್ ಅದು ಇರೋದೇ ಹಂಗೆ ಆಕ್ಟ್ ಅಲ್ಲಿ. ಆಮೇಲೆ ಆಕ್ಟ್ ಸೇಸ್ ಅಂಡರ್ ಸೆಕ್ಷನ್ 39 ಆಫ್ ದ ಲ್ಯಾಂಡ್ ರೆವೆನ್ಯೂ ಆಕ್ಟ್ ಪೊಸಿಷನ್ ಎಷ್ಟು ಬಿಟ್ಟೇಕಾರೆ ನೋಟಿಸ್ ಕೊಟ್ಟು ಮಾಡ್ಬೇಕು. ಇವರು AC ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಡ್ತಾರೆ, AC DC ಕೊಡ್ತಾರೆ, ತಹಸೀಲ್ದಾರ್ ಕೊಡ್ತಾರೆ, ತಹಸೀಲ್ದಾರ್ ಅಷ್ಟು ಡೂ ಇಟ್.
ಅದರಲ್ಲಿ 34 ಅಲ್ಲಿ ತೆಂಗಿನ ಮರ ಇದೆ ನಮ್ದು 30 ವರ್ಷದಿಂದ. 34 ಅಲ್ಲಿ RTC ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀವಿ ಸರ್. ಎಂಟೈರ್ ಲ್ಯಾಂಡ್ ಈಸ್
Now your name has been continued.
Continued.
Issue notice.
ಅದು ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 529 my lord, 5 to 11 my lord. They're all my lord, my previous purchasers, 5 ಜನ ಇದ್ದಾರೆ.
No, only grantee you have to.
Grantee my lord.
Yes.
Both respondent is relevant.
1, 2, 3. Government advocate is directed to take notice. Counsel for the petitioner is directed to serve 3 sets of copies. Issue emergent notice to respondent number 4. Learned counsel for the petitioner has filed a memo seeking dispensation of notice to 5 to 11. Memo is taken on record. Notice to 5 to 11 is dispensed. Stay of annexure.
A my lord.
Stay of annexure A till next date of hearing. Yes.
Please. and delivery of the copy.
Serial number 69, O Mahesh for appellant, connected matter, B Pramod.
Well, I appear for the appellant.
Yes, Mr. Mahesh.
Well, maybe taken up next week, but the file has been misplaced and could not be traced.
Yes, next week. Normally, Mahesh will not ask the time unless
Well,
he has some difficulties.
Last time ಹಂಗೆ ಆಗಿತ್ತು
ಅದೇ, ಅದೇ.
ಆಗಿತ್ತು ಆದ್ರೆ ಇದಾಗಿರ್ಲಿಲ್ಲ.
Yes, Mahesh, next week.
Maybe bundle with some other case, I think.
Yes.
Serial number 70.
ಯಾವ್ದೋ ಒಂದು ಡೇಟ್ ಕೊಡ್ಬೋದಾ ಸರ್? Any date you want, Mahesh, particular date?
ಯಾವ್ದಾದ್ರು?
Find the file.
Next week ಅಲ್ಲಿ ನಾನು ಸಿಕ್ಕರೆ ಇದ್ ಮಾಡ್ತೀನಿ.
ಯಾವತ್ತಾದ್ರೂ? On 18th. Longer date I have given, Mahesh.
Yes.
Yes, 18th.
Serial number 70, G Balakrishna Shastri for petitioner, Bhoja Raja SV, government advocate.
Yes. Yes, madam, what is this?
Mr. Lord, this is with respect to a PTCL Act
Purchaser or a grantee?
and LRs of grantee, my lord.
LRs of grantee. Yes,
R5 is the purchaser, my lord.
R5 is the purchaser. What is the date of grant?
My lord, if your lordships may permit, I'll go according to the,
Huh?
I'll go serial,
You want type?
chronological. No, my lord, I'll go chronologically for.
Yes.
This is with respect to 2 acres, 20 guntas in survey number 29/37, my lords.
Yes.
Situated at Kenchamanahalli village, Anugodu Hobli, Davangere Taluk and district.
Yes.
So, 31/11/1961 is the Darkhast was granted in favor of one Mr. Siddappa alias Bade Siddappa.
Who is he?
He is the original granting here.
How he is related to you?
Our petitioner number 1 to 4 are the LRs of Bade Siddappa. my lord.
Siddhappa, yes. Yes, your father.
Yes, my lord. Husband, R1, P1's husband and father of.
Yes,
2 to 4.
yes, yes.
On 10/1/1963, Sagoli cheat was issued with a
Yes.
non-alienation of 15 years. Condition was granted.
Yes.
2/4/1970, the land was sold to one G. Kotrappa bin Jambigi Panchaksharappa Gudal for a consideration of rupees 400 million. Which was in turn sold to his brother, which he in turn sold to his brother KG Sharanappa bin Gaudar Channappa.
Yes.
After which the land was restored, my lord.
No, the
Lord
thing
ordered-
is, 1970 is the first sale.
Yes, my lord.
Your application for restoration is filed in the year 2012.
My lord,
Delay of 40 years.
no, my lord, there are two sets of transactions that have taken place.
No, first sale, when you have sold,
Yes, my lord.
then 1978 Act came into the force.
Yes, my lord.
After that, you have applied 10 plus 22 years. Now that issue is pending before that other bench. The constitutional validity has been challenged.
Yes,
We'll
my
wait for that. If that, what is the outcome of the judgment?
My lord, in the meantime, if interim prior may be granted and a stay may be.
No, that is 2018 matter, madam. What is that interim prior? Admittedly, you have sold that land, you are not in the possession.
No, my lord, it was restored in 2002 and further it was challenged again in a writ petition and matter was remanded back for reconsideration on merits.
But what is the document to show that you have restored the position? Let us see, 2018 wills. 13th is the matter is posted.
Yes, my lord.
We'll have it on 20th. Yes, read this matter on 20th.
Pastor matter. Serial number 7, O Mahesh for appellant, connected matter, TP Vivekananda.
Yes, Mr. Mahesh. Yes, Mahesh.
Serial number 7, O Mahesh for appellant.
He is not there.
Yes, there is a delay of 535 days in filing an appeal. IA 1 of 2023 is filed for condonation of delay. Respondent has filed an objection. Peruse that affidavit for the reason stated in that accompanying affidavit. Delay of 535 days in filing an appeal is condoned. IA 1 of 2023 is allowed subject to not entitled for the interest for enhanced compensation. Entitled for the interest in case if we succeed for enhanced compensation amount. Please this matter.
Some short date, my lord,
We'll give the date. He may thought that today for condonation of delay. Therefore, he might have not come. Yes. We'll have it on 9th or 10th.
10th, my lord.
Yes, 10th. Yes.
Obliged.
Serial number 12, HC Rushabhendraya for appellant, connected matter, Suma K.
Yes. Yes, Mr. Rusulban.
This is an appeal by the insurance company, my lord, on 3 grounds. My lord, first ground is that the disability assessed by the doctor MEC 991, my lord. At
ಏನು
page
ಕ್ವಾಂಟಮ್ ಚಾಲೆಂಜ್ ಮಾಡಿದಿರಾ?
quantum, quantum, my lord.
No, that your appeal is also on
The
that.
tribunal has taken
Yes, MEC 991.
991, my lord.
Which is the
990.
page, Mr. Paragraph 991, para 21. Yes.
Para 21, my lord.
Yes, yes.
My lord,
What is
accident is of the year 2015, my lord.
2015?
Yes, sir. As
Yes.
per the chart, the tribunal has to take 9,000, my lord.
9,000. ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
10,500 has been taken. And they are not proved that. But one more point, my lord, is a driver by profession. As per the evidence. So, my lord, my humble submission, my lord, he is continuing this job of the driver.
Yes.
And if at all for this disability of 8%, 15%, so he is not disabled from the doing work of a driver.
What is that injury?
Injury, my lord. Able to
Lordship, there are 2 injuries major.
What are that injury?
Undisplaced fracture upper end tibia. Second is X-ray shows fracture nasal bone.
nasal bone fracture, my lord.
Tibia fracture also.
Tibia fracture, he's a driver.
Fracture, my lord. According to the evidence itself, the treated doctor has not been examined in this case. First important point, my lord.
Yes.
Secondly, he has assessed the disability of 24%. 1/3 has to be taken as per the Supreme judgment of the Supreme Court. Latest judgment, my lord.
ಇದೆ ಡಾಕ್ಟರ್ ಡಿಸ್ಕಷನ್ ಡಾಕ್ಟರ್ Uma orthopedic.
Para 26, my lord.
But in the cross examinatory, he has not examined the petitioner. Tribunal ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
My lord, tribunal has taken 15%. That is bad in law because 1/3 has to be taken. He admitted that the fractures are united. Secondly, he is a driver. He has not surrendered the driving license.
Yes.
Thirdly, my lord, the interest awarded is 7%, my lord. That has to be scaled down. This honorable court.
Yes. Yes, madam.
Your Lordship, in this case, if you see the evidence of the doctor, what the doctor, I'll just read the evidence of the doctor. Doctor is PW4.
Yes. CW4.
PW4.
Yes, PW2.
PW4.
PW4, my lord. Umesh.
PW4, Umesh.
Dr. Umesh, my lord.
Yes.
Your Lordship, I'll just read the relevant part.
Yes.
The patient was admitted with the above mentioned history attended by general surgeon, orthopedic and ENT surgeon. Case evaluated, all relevant investigation done, reports enclosed, diagnosed as above. ENT opinion was taken in view of nasal bone X-ray done, revealed fractured nasal bone, no surgical intervention required, treated. Ortho opinion taken X-ray right knee done and undisplaced. Fracture upper and tibia, PDP applied. The patient was discharged on 17/7/15. He came for regular follow-up. Last I have examined him on 2/3/17. X-ray was taken. X-ray shows good union of the fracture of tibia. On the basis of 2007 Government of India Disabilities Assessment Guidelines, disability assessment was done. He's a car driver who's unable to carry the job, right lower limb and right knee, the movements, flexion. So doctor has told that since he is total loss of function due to loss of movements is 24%, which is permanent and to the part. Now, as a driver, he cannot work like before because of the tibia fracture. Now, tibia is the main thing because he has to put brakes because most of the vehicles will not be automatic. So the trial court has not even taken, they have not taken.
As he surrender his driving license to show that he will not drive it.
Your Lordship, it is not, see.
There is no evidence.
Now, I am just telling that whenever they take 24%, if they have taken 100% disability, he will surrender. But here they have not taken 100. What it says is 24% disability, he is disabled up to 24% in his work.
No, that means to say he can drive.
Your Lordship, I'm not saying that completely he cannot drive.
No,
but
no, in the driving license, complete and incomplete will not come.
Yes.
Either he has to capable of driving or he can't drive.
That is important.
Very.
Even 24%, it will not come in the way of his driving.
Not like
Therefore, he has not surrendered. Or you can't say that he can drive only in that highway, he can't drive in that.
Not that he cannot drive. I'm saying that when he drives for long hours, there will be pain in the leg. That shows that 24%.
There is that evidence to show that if he drive long hour, that it will get pain and all. As he stated in this evidence.
He says that paragraph 6.
PW1.
PW1.
Yes.
5th paragraph.
Yes.
ಸುಮಾರು 20,000 ಹೆಚ್ಚು ಸುಮಾರು ಮಾಡುತ್ತೇನೆ.
Para 6 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ. ಬಟ್ ಅಂದ್ರೆ
ಸರಿ, ನನ್ನ ಮಗನು ಅಪಘಾತ ಪೂರ್ವದಲ್ಲಿ ಆರೋಗ್ಯವಾಗಿದ್ದಾನೆ. No, is it he has not been examined?
He's PW2.
PW2 na.
So he's examined PW2.
Yes, PW1 is his wife.
PW1 is in another accident. PW2 is the injured.
PW2 is in this case.
Yes, in this case. Paragraph 5.
PW2, my lord. Cross examination of the petitioner is very clear, my lord. He is admitted for only 1 day, my lord.
Yes.
In the cross examination, he admitted for only 1 day, my lord.
Yes.
First, secondly, my lord, in the cross examination of the doctor.
Cross examination, the last, the end can be just taken into consideration, page 7.
ಹೋಗ್ಲಿ ಕೆಲಸ ಮಾಡಲ್ಲ ಅಂತ ಹೇಳ್ತಾನೆ ಸ್ವಾಮಿ.
ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ ಅವರು. ಆಯ್ತು.
ನಾನು ಎಂದಿನಂತೆ ಈಗಾಗಲೇ ಕೂಡ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೇನೆ ಅಂತ ಹೇಳುವುದು ಸರಿ ಅಲ್ಲ.
ಆಯ್ತು, ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
3 ಲಕ್ಷ. ಅಲ್ಲ 9,000 ತಗೋಬೇಕು ಸ್ವಾಮಿ, 9,000, 10,500 ತಗೊಂಡಿದ್ದಾರೆ. ಟೋಟಲ್ ಅವಾರ್ಡ್ ಅಮೌಂಟ್ ಇಸ್
ಎಷ್ಟು 3 lakhs ಕೊಟ್ಟಿದ್ದಾರಾ?
3 lakh,
Towards
3,74,000, my lord. And 1/3 has to be taken as per the guidelines. And he is not a treated doctor.
Your lordship, if you see the loss of future income, they have just multiplied 18,900 into 15. What is the per month income is not, if you see loss of future income paragraph
wages 350 ಮಾಡಿದ್ದಾರೆ.
ಮಾಡಿದ್ದಾರೆ, but if you see loss of future income, if you take 10,500 into 15%,
350 per day ಆದರೆ
50% ಅಲ್ಲ.
ದಿನ ಎಷ್ಟಾಯ್ತು?
that doesn't come to,
10,500 ಆಗಿತ್ತು ಮೇಡಮ್. 350 ರೂಪಾಯಿ ಒಂದ್ ದಿನಕ್ಕಾದ್ರೆ.
yes, 10,500.
9,000 rupees.
ಆಯ್ತು, 10,500 since he is a driver.
Yes,
That is not dispute.
that is not dispute. 10,500 into 12 into his,
Because it is admitted that he is a driver.
Yes, I'm not denying.
your lordship, loss of future income is not taken
1/3 has
correctly.
to be taken, my lord.
Loss of future income is not taken correctly.
Why?
Your lordship, 10,500 into 12 into the percentage of disability, even if it is taken as 15/100,
My lord, 24% disability has been assessed by the doctor, but 1/3 has to be taken, my lord.
ಆಯ್ತು ಹೇಳಿದ್ರಲ್ಲ, ನಾನು ನೋಡ್ತಾ ಇದ್ದೀನಿ. ಅವ್ರೇನೋ ಇದ್ರನ್ನ
ಅದೇ
ಕ್ಯಾಲ್ಕುಲೇಷನ್
ಬೇರೆ ಏನು ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ? ಹೇಳಿ.
ಎಷ್ಟಾಗುತ್ತೆ ನೋಡ್ರಿ ಅದು.
10,500, they have taken 15%.
ಮಲ್ಟಿಪ್ಲೇಯರ್
15.
15
multiplier, my lord.
15 disability ಎಷ್ಟಾಯ್ತು?
2,83,000, yes, 500.
10,500.
It comes to 2,83,000.
2,83,500.
ಅಲ್ಲ,
Yes.
ಇದನ್ನ higher side ಅಂತ 7% interest, my lord.
7% interest will reduce.
That
Income 25. Loss of
also there is negligence on the part of the driver also. As per the document itself, contributory. He was also contributed. I am not pressing that matter. He also contributed, my lord. How the accident has happened.
ಎಷ್ಟಾಗುತ್ತೆ? ಕಡಿಮೆ. 1 ಲಕ್ಷ ಕಡಿಮೆ. 25. ಎಷ್ಟು? 1330.
And no surgery, my lord, according to the class examination itself. The doctor himself admitted there is no surgery at all.
Yes, even recalculate reducing that this thing also.
Yes, my lord.
Overall, it will comes to same thing. Only interest can be reduced.
ಅಲ್ಲ, 8% ತಗೋಬೇಕು ಸ್ವಾಮಿ interest.
8 ಅಲ್ಲ, 10% ತಗೊಂಡ್ರು we have to enhance in the other head.
ಅಲ್ಲ, they have not filed appeal, my lord. They filed crab. After 3 years.
I filed crop.
Yes.
Yes.
My lord,
crab
as
has
per the
filed.
decision of this court, my lord.
Yes. No,
I have
your
filed-
appeal is not yet admitted.
That's all.
Limitation will start from the day it is admitted. It is not yet admitted.
ಅವ್ರ ಕೇಸ್ ಸ್ವಾಮಿ, ಅಲ್ಲ ಕ್ರಾಬ್.
ಕ್ರಾಬಿಗ್ ಲಿಮಿಟೇಷನ್ ಬರೋದು ಮೈನ್ ಅಪೀಲ್ ಅಡ್ಮಿಟ್ ಆದಲಿಂದ. ಎಸ್. ಕ್ರಾಬಲ್ ಡಿಲೇ ಇದೆಯಾ? ತೋರಿಸಿಲ್ಲ ಲೈಕ್.
ಇಲ್ಲ, ಕಂಡೋನ್ ಆಗಿರ್ಬೋದು ಸರ್.
8%. ಅಲ್ಲ, ಪಾಪ my lord, fractures were inherited. My lord, in this case, fractures were inherited. Firstly, secondly, 1/3 has to be taken, my lord.
We'll consider that.
Please.
So and so learned counsel appearing for climate insurance company has contended that even though climate has claimed that he was earning daily 400 rupees and bata of rupees 150, but he has not produced any document to establish the same. The tribunal error in considering that monthly income of the claimant was 10,500. He further contended that the claimant has examined the doctor as PW4. He is not an treated doctor. And he has deposed that fractures has reunited. And whole body disability is 24%. Tribunal has assessed whole body disability is 15% is on higher side. Secondly, lastly, he has contended that considering that evidence of doctor and injury suffered by the claimant, compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side, on higher side, hence is under sought for reduction of compensation. Lastly, he has contended that in view of judgment of this court, interest awarded by the tribunal 7% is on higher side. Per contra, so and so learned counsel appearing for the insurance claimant has contended that at the time of the accident, the claimant was working as a driver, earning 400 rupees as a daily wages, 400 rupees per day as a wages, and bought of rupees 150. The monthly income assessed by the tribunal, 10,500 is on lower side. She further contended that by avocation he was a driver, by occupation he was a driver. Due to that injury, he was unable to drive that vehicle. That whole body disability is assessed by the tribunal, 15% is on lower side. Lastly, she has contended that considering that injury suffered by the claimant and his age and avocation and medical records, the compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side, sought for enhancement of compensation. Heard the learned counsel for the parties, peruse judgment and award. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 16/7/2015 due to rash and negligent driving of driver of, what is that vehicle? Tata Ace, Tata Ace bearing registration number KA45 A4959. Due to that accident, claimant has suffered the following injury. He has examined the doctor Umesh as PW4. In his evidence, he has deposed that claimant has suffered 24% disability to particular limb, and he has also admitted that fractures are united. Considering that evidence of the doctor and injury suffered by the claimant, I am of the opinion that whole body disabilities has to be assessed 10%. At the time of the accident, claimant was working as a driver. Even though he claimed that he was earning 400 rupees daily wages per day and 150 bata, but he has not produced any document to establish the same. Since he was a driver and they have produced the DL, the tribunal has rightly assessed notional income as 10,500. The multiplier applicable to that age group is 15. Accordingly, loss of future earning has been reassessed as follows.
10,500 into 12 into 15 into 10%, 1,89,000.
90,000 per 25. What are the injuries?
Fracture to nasal bone and fracture to tibia.
Yes.
No surgery is conducted in this case, my lord. Very clear. ಶಸ್ತ್ರಚಿಕಿತ್ಸೆನೇ ಮಾಡಿಲ್ಲ.
Yes.
Correct.
Due to that accident, claimant has suffered the aforesaid injury. He was inpatient for a period of 1 day. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 25,000 to 60,000. Loss of amenities from 30,000 to 50,000. Loss of income during the later period has to be granted for 3 months. ಇದು ಕೊಟ್ಟಿಲ್ವಾ?
Medical expenses they have given.
60, 25, 35, 45, 65. ಅಟೆಂಡೆನ್ಸ್ ಚಾರ್ಜಸ್ ಇದು ಕೊಟ್ಟಿಲ್ವಾ?
ಅದು medical expenses was 12,141.
Medical expenses
Medical expenses,
and
what they have put,
nourishment.
that has been given.
Medical
The
expense,
compensation awarded by the tribunal, medical expenses and nourishment. Medical ಎಷ್ಟ?
12,141.
3,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
15,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes.
Medical
Medical
expenses,
expenses and nourishment has to be enhanced from 15,000 to 25,000. 10,000 ಆಗುತ್ತೆ. ಸರಿ.
medical expenses 15,000 has been given, my lord.
50,000 including nourishment.
Yes, my lord.
Nourishment 3,000 ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ. Yes.
They are not produced any medical expenses.
Medical bill ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ.
ಅದೇ.
Yes. In view of judgment of this court, the interest has to be reduced to 6% from 7%. Accordingly, the appeal is allowed in part. MFA CRAB is dismissed. Yes. Amount in deposit is transferred.
Amount in.
Bill number 17, Shripad Shastri for
Well,
appellant.
I am for appellant. Actually, three of my matters has been passed over. 17, 18 and 41. 41 very short, my lord. If PV Raju present, it is better to take that matter. Only liability is to be shifted. Compensation idil. 41.
Now, why that liability is
The driving license, so charge sheeted. Driver is charge sheeted. That is why they.
Inconvenience ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು. Afternoon I had some inconvenience ಅಂತ ಹೇಳಿದ್ರು PV ರಾಜ್ ಅವರು.
ಬೆಳಿಗ್ಗೆನೂ ಬರಲಿಲ್ಲ ಅವರು. ಸಿಂಪಲ್ ಈ ಸೇಯಿಂಗ್ ದಟ್ ಸಿಂಪಲ್ ಟುಮಾರೋ.
Aye.
Tomorrow ಆಗ್ಬೋದಾ?
17 and 18 ready, my lord, if time permits.
List is already issued. We'll have it on Monday, Mr.
ಆಯ್ತು sir. Monday ರಜಾ ಇರ್ಬೇಕು sir. ಇಲ್ಲ.
Monday ರಜಾ ಇಲ್ಲ. Friday ರಜಾ.
Friday.
ಹಂಗಾಗಿ
ಅಡ್ಡಿಲ್ಲ.
ಇಲ್ಲ ಅಂದ್ರೆ Friday ಹಾಕೊಂತಾ ಇದ್ದು.
My lord, as far as first 17 is concerned.
ಏನು it will take time.
ಇದರಲ್ಲಿ ಮೆಡಿಕಲ್ ಬಿಲ್ಲು ಮತ್ತು ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಎನ್ IA ಫಾರ್ ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಸ್ಯಾಲರಿ ಸರ್ಟಿಫಿಕೇಟ್.
Where is that IA?
IA is heard and post for it is to be heard at final hearing ಅಂತ ತಮ್ಮದೇ ಆರ್ಡರ್ ಇದೆ 6/12/23. IA ಅದು ಸ್ಯಾಲರಿ ಸರ್ಟಿಫಿಕೇಟ್ ಮತ್ತು ಲೀವ್ ಸರ್ಟಿಫಿಕೇಟ್. ಇಸ್ ಎ ಗವರ್ಮೆಂಟ್ ಟೀಚರ್, ಫ್ಯೂಚರ್ ಲಾಸ್ ಬರೋದಿಲ್ಲ. ಗವರ್ಮೆಂಟ್ ಇಸ್ ಎ ಗವರ್ಮೆಂಟ್ ಟೀಚರ್, ಫ್ಯೂಚರ್ ಲಾಸ್ ಬರೋದಿಲ್ಲ. ಇದಕ್ಕೆ ಅವನು 2 ತಿಂಗಳ ರಜೆ ಹಾಕೋದಕ್ಕೆ BO ಆಫೀಸ್ ಇಂದ ಸರ್ಟಿಫಿಕೇಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ ಅಂಡರ್ ದಿ ಸೈನ್ ಅಂಡ್ ಸಿಗ್ನೇಚರ್ ಆಫ್ ದಿ ಇದು. ಅದು ಎಷ್ಟು 47,000 ರೂಪಾಯಿ ಬರ್ಬೇಕು ಅದ್ರ ಮೇಲೆ.
Yes, Mr. What you say about that additional documents?
That document I don't have it.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಇಲ್ಲಿ ಫೈಲ್ ರಿಸೀವ್ ನೀವು.
ಏನಿಲ್ಲ ಅದರಲ್ಲಿ ಇದು ದೃಢೀಕರಣ ಪತ್ರ issued by BO ಆಫೀಸ್, ಗವರ್ಮೆಂಟ್ ಗೆಜೆಟೆಡ್ ಆಫೀಸರ್, ಕ್ಷೇತ್ರ ಶಿಕ್ಷಣ ಅಧಿಕಾರಿಗಳು.
ನೋಟಿಸ್ ಇವಾಗ ಮಾಡಿದ್ದಾ?
ಇಲ್ಲ, I filed ವಕಾಲತ್ ಮಾಡಿಸಿನ್ 22 only. 22 I filed ವಕಾಲತ್.
No, but Shastri, you have written on that application, respondent not yet appeared. Therefore, you have not served.
ಆವಾಗ ಇಲ್ಲ ಆಗಿತ್ತಾನ ಅದು ಬಹುಶಃ. ಅಲ್ಲ, ನಾ ಕೊಡ್ತೇನೆ. ಅದ್ರಲ್ಲೇನು ಬರೀ 47,000 2 ತಿಂಗಳ ಸಂಬಳ ಗೌರ್ಮೆಂಟ್ ಆಫೀಸರ್ ಇವ್ರು ಕೊಟ್ಟಿದ್ದು. ಪ್ರಿಂಟೆಡ್ ಫಾರ್ಮ್ ಅಲ್ಲಿ ಇದೆ
Give
ನೋಡಿ
the
ಸ್ವಾಮಿ.
copy to him.
ಅಡ್ಡಿಲ್ಲ, ಕೊಡ್ತೇನೆ.
I have
ಅದಕ್ಕಿಂತ ಇನ್ನೊಂದು ಇಂಪಾರ್ಟೆಂಟ್ ಗ್ರೌಂಡ್ ಇದೆ. ಏನಂದ್ರೆ
ಏನು?
2 ಲಕ್ಷ ರೂಪಾಯಿ ಮೆಡಿಕಲ್ ಬಿಲ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿಲ್ಲ. ದಟ್ ಇಸ್ ದ ರೆಕಾರ್ಡ್ ಶೋಸ್. 2,65,711 ರೂಪಾಯಿ ಟೋಟಲ್ ಬಿಲ್ಲು. ಅದ್ರಲ್ಲಿ ಆ ಫಸ್ಟ್ ಬಿಲ್ ಒಂದು ಇಟ್ಕೊಂಡು ಮುಂದೆ ಕ್ಯಾಲ್ಕುಲೇಟೇ ಮಾಡಿಲ್ಲ. ಅದು 46,000 ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
What you say, Mr. Patil, regarding?
ದಟ್ ಇಸ್ ದ ಮಾರ್ಕ್ ಡಾಕ್ಯುಮೆಂಟ್.
There is no discussion about that, my lords.
ಅಲ್ಲ, ಇದು ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದ್ಯಾ?
ಬಂದಿದೆ.
Will secure the records for.
ರೆಕಾರ್ಡ್ಸ್ ಇಲ್ಲದೆ ಆಗದೇ ಇಲ್ಲ ಸ್ವಾಮಿ, ರೆಕಾರ್ಡ್ಸ್ ಬೇಕು.
Yes, office is directed. In the meantime, you survey IA to Patil.
ಅಡ್ಡಿಲ್ಲ.
Yes.
ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ 522. ಇದರಲ್ಲೂ ಬರೇ ಕ್ವಾಂಟಮ್ ಸ್ವಾಮಿ.
Serial number 18. B Pradeep.
ಮೇಲಾಡ ಇದರಲ್ಲೂ ಒಂದು ಮಾರ್ಜಿನಲ್ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್.
Serial number
18 ಮೇಲೆ
18.
ಮೇಲಾಡ
Third respondent in this case.
page 8 para 21 ಮೇಲೆ ಮೇಲಾಡ
yes.
It's a pedestrian hit by a motorcycle. Minor age 11 years.
ಏನ್ ಲಯಬಿಲಿಟಿ ಏನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ?
ಇಲ್ಲ.
Only enhancement.
Enhancement ಡಾಕ್ಟರ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ, 1,15,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಏನು ಇಂಜುರಿ ಏನು?
ಫ್ರಾಕ್ಚರ್ ಆಫ್ ರೈಟ್ ಲೆಗ್ ಅಂತ ಹೇಳ್ತಾರೆ. 3 ಬದಿಗೆ 25 ದಿನ ಇನ್ ಪೇಷಂಟ್. 3 ಹಾಸ್ಪಿಟಲ್ ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದಾನೆ. 11 ವರ್ಷ ಹುಡುಗ ಓಪನ್ ಡಿಡಕ್ಷನ್ ಇಂಟರ್ನಲ್ ಫಿಕ್ಸೇಷನ್ ಆಗಿದೆ. ಆಮೇಲೆ
ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ. ಎಷ್ಟು ಕೊಡ್ಬೋದು?
ಇಟ್ಸ್ ಅ ಕೇಸ್ ಆಫ್ ಗ್ಲೋಬಲಿ
1 ಲಕ್ಷ ಡಾಕ್ಟರ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡದೇ ಇದ್ರು ಸಹ 1 ಲಕ್ಷ ಮಾಸ್ಟರ್ ಮಲ್ಲಿಕಾರ್ಜುನ್ ಅಪ್ಲೈ ಮಾಡಿ
ಕೊಟ್ಟಿದ್ದಾರೆ. 10% ಅಂತ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಕೋರ್ಟ್ ಎಕ್ಸರ್ಸೈಸ್ ಇಟ್ಸ್ ಜುರಿಸ್ಡಿಕ್ಷನ್. ಸಾರಿ, ಅಂಡ್
ಇನ್ನ 1 ಲಕ್ಷ ಅಂದ್ರೆ ಇನ್ನ 50,000 ಕೊಡ್ಬೇಕು.
ಇಲ್ಲ, ಅದ್ರಲ್ಲಿ 10,000 ಮತ್ತೆ 5,000 ಸಪರೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ, ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ರೆ ಈಗ
ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ. Doctor evidence ಇಲ್ಲ melody. If doctor evidence is there, melody, what melodship saying is correct.
Yes, Mr. How much you are expecting, Mr. Shastri?
ನಾವು ಕೊಟ್ಟಷ್ಟು ಸ್ವಾಮಿ. ಇದು ಫ್ರಾಕ್ಚರ್ ಆಫ್ ರೈಟ್ ಲೆಗ್ ಅಂತೂ ಇದೆ. 25 ದಿನ ಆ ಮಗು 25 ದಿನ ಇನ್ ಪೇಷಂಟ್. ಓಪನ್ ಡಿಡಕ್ಷನ್
20,000 ಕೊಡಬಹುದು ಸರ್.
ಇಲ್ಲ, 20,000
35.
1 lakh ಆಲ್ರೆಡಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
1,15,000 ಇದೆ. ಮೇಕ್ ಇಟ್ 35. 1.5 ಆಗುತ್ತೆ. Yes. That's all, Mr.
ಯಾಕಂದ್ರೆ 11 ವರ್ಷ ಹುಡುಗ 25 ದಿನ ಇನ್ ಪೇಷಂಟ್. ಒಂದ್ ಸರ್ಜರಿ ಆಗಿದೆ. ಅದನ್ನ ಅಟ್ಲೀಸ್ಟ್ ಅಲ್ಲ, ಈ ಡಾಕ್ಟರ್ ನಾವು ಎಕ್ಸಾಮ್ ಮಾಡಿದ್ರೆ ಅವ್ರಿಗೆ ಮತ್ತು ಇದು ಜಾಸ್ತಿ ಆಗತ್ತೆ, ತೊಂದ್ರೆ ಆಗತ್ತೆ. ಇವನು ಮತ್ತೆ
ಡಿಸಬಿಲಿಟಿ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆಯಾ?
ಇಲ್ಲ, ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿಲ್ಲ. ಆದ್ರೆ ಫ್ರಾಕ್ಚರಿಗೆ 50,000 ರೂಪಾಯಿ ಆಗ್ಬಿಡುತ್ತೆ. ಆಮೇಲೆ ಉಳದ್ದು ಡಿಸಬಿಲಿಟಿ ಅಂತ ಹೇಳ್ತಾ ಪ್ರಾಬ್ಲಮ್. ಆದ್ರಿಂದ 50,000 ಮಾಡಿ ಸ್ವಾಮಿ, 50,000 ಮಾಡಿ ಸ್ವಾಮಿ. ಮಗು 11 ವರ್ಷ.
ನಮಗೇನು ಗೊತ್ತಾಗೋದಿಲ್ಲ. ಡಾಕ್ಟರ್ ಹೇಳಿದ್ರೆ ಅದ್ರ ನೋಡ್ಕೊಂಡ್ಬಿಟ್ಟು ನಾವು ಫ್ರಾಕ್ಚರ್ ಅಥವಾ ಡಿಸಬಿಲಿಟೀಸ್, ಅದರ್ವೈಸ್ ವಿ ಆರ್ ನಾಟ್ ಎಕ್ಸ್ಪರ್ಟ್ ಟು ಸೇ ದಟ್.
ಆಯ್ತು ಸ್ವಾಮಿ, ನಿಮ್ಗೆ ನೀವು ಕೊಟ್ಟಷ್ಟು ನಮ್ದು ಅದ್ರಲ್ಲೆಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ. 50,000 ಕೊಡ್ಬೋದು ಅಂತ ನನ್ನ ವಿಚಾರ.
ಇಂಟ್ರೆಸ್ಟ್ 9% ಕೊಟ್ಟಿದ್ದಾರೆ.
ಕಂಟಿನ್ಯೂ ಮಾಡಿ. ಅಲ್ಲಿಗೆ 50,000 ಆಗೋಗುತ್ತೆ.
ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಗೆ 6%.
ನಾಟ್ ರೆಡ್ಯೂಸಿಂಗ್ ದ ಇಂಟ್ರೆಸ್ಟ್ ಆಲ್ಸೋ. Yes. So and so learned counsel appearing for the claimant has contended that due to that extent, claimant has suffered grievous injury. He was a minor. What is his age?
11 years.
11 years.
He was inpatient for a period of
25 days.
25 days. What is the medical bill have you produced?
ಮೆಡಿಕಲ್ ಬಿಲ್
ಅದನ್ನು ಏನಿಲ್ಲ ಸರ್.
ಇಲ್ಲ, ಮೆಡಿಕಲ್ ಬಿಲ್
ಅಂದ್ರೆ ಹಿಂಗೆ
ಯಾವುದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
Yes.
It's only a presumption, my lord, because he inpatient in free.
Compensation awarded by the tribunal is on lower side. Hence, he sought for enhancement of compensation. For contra, B. Pradeep, learned counsel appearing for insurance company, has contended that the claimant has not examined the doctor. He has not produced disability certificate nor any medical records. The overall compensation awarded by the tribunal itself is on higher side. Hence, he sought for dismissal of the appeal.
Heard the learned counsel for the parties. Barrow's judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 4/7/2017 due to rash and negligent driving of rider of motorcycle bearing registration number KA16 EH2192. At the time of the accident, he was aged about 11 years. He has suffered just one injury na.
ಅದು
Fracture of-
ಫ್ರಾಕ್ಚರ್ ಆಫ್ ರೈಟ್ ಲೆಗ್ ಅಂತ ಹೇಳ್ತಾರೆ.
He has suffered one injury and he was inpatient for a period of 24 days.
25 days.
25 days. Considering that injury suffered by the claimant and considering that wound certificate exhibit
Discharge summary exhibit P8 my lord.
P4 and discharge summary exhibit P7 and
And
8. I am of the opinion that the compensation awarded by the tribunal has to be enhanced from 1,15,000 to 1,50,000.
Exhibit P13 bill ಅಂತ ಹೇಳ್ತಾರೆ. ನನಗೆ actually I am handicapped because my counterpart.
ಕ್ಯಾಶ್ ಬಿಲ್ ಅಂತ ಅದು ಇದ್ರದ್ದು ಕ್ಯಾಶ್ ಬಿಲ್ ಅಂತ ಹೇಳ್ತಾರೆ ಬಟ್ ಅದೇನು ಇದಿಲ್ಲ.
Serial number 20 Ravishankar Shastri Ji for appellant Lalita PM.
Who is that, Mr. Lalita?
I have not seen my lord so far.
What is this enhancement?
Small enhancement, my lord. There was two grievous injury, my lord. She was inpatient for a period of 23 days. Doctor was not examined, my lord, to prove the disability aspect.
Adu. Only arguments and
Yes, Mr. My lord, the accident is on 16/12/2015, my lord.
2017.
15, my lord, 16/12/15.
Yes.
40 years, my lord, lady. My lord, she suffered two grievous injuries, my lord. That is rib fractures and, my lord, spleen injury. She was inpatient for a period of 23 days in the hospital, my lord. The total medical bills itself was 84,698. Tribunal, my lord, I was 12,500 towards pain and suffering. Then medical bills as produced. Then incidental expenses at 19,550.
Idilva, disability ilva?
Disability examine madilla, sir. Doctor
exam. Medical bill estide?
84,698 ide, sir. Para, my lord, 33. Internal page 34.
Yelli tribunal en discussion why they have?
Para 33, sir. Internal page 34. MEC 476
medical bills together got marked exhibit total
Yes.
amount mentioned in.
That is a medical bills, my lord, no dispute.
Discharge summary took treatment 21 that considering that ಕೊಟ್ಟಿದ್ದಾರೆ full.
ಅದು ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್. ಕನ್ವೆನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಕಡಿಮೆ ಕೊಟ್ಟಿದ್ದಾರೆ, 12,500 ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ. 23 ದಿವಸ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಇದ್ರು, 2 ಗ್ರೀವಿಯಸ್ ಇಂಜುರಿ ಆಗಿದೆ. ದೆನ್ ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್ ಡ್ಯೂರಿಂಗ್ ಲೇಡ್ ಅಪ್ ಪೀರಿಯಡ್ ಕೊಟ್ಟಿಲ್ಲ, ಲಾಸ್ ಆಫ್ ಎಮ್ಯುನಿಟೀಸ್ ಅಂತ ಕೊಡ್ಬೋದು ಸರ್.
23 ದಿನ ಇದ್ರಾ?
ಹೌದು.
ಚಾರ್ಟ್ ಎಲ್ಲಿದೆ?
ಚಾರ್ಟ್ ಅಂತ ಮಾಡಿಲ್ಲ ಸರ್ ಅವರು.
ನೀವು ಇದ್ರಲ್ಲಿ ಮಾಡಿಲ್ವಾ?
ಸೆನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ ಮಾಡಿದ್ದೀನಿ.
ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ 12,000 ಕೊಟ್ಟಿದ್ದಾರಾ?
12,500 was
injury ಏನು?
2 grievous injury. That is one, my lord, the rib fractures. The other is, my lord, splenic laceration.
So and so learned counsel appearing for. ಆಯ್ತು, ಅದರಲ್ಲಿ ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಅಂತಂದ್ರೆ ಅದ್ರಲ್ಲಿ ಒಂದು ನಿಮಗೆ 40,000, ಇದ್ರಲ್ಲಿ 40, 80,000 rupees ಜಾಸ್ತಿ ಆಗುತ್ತೆ.
ಲೇಡ್ ಅಪ್ ಪೀರಿಯಡ್ ಅಂತ ಕೊಟ್ಟಿಲ್ಲ ಸರ್.
ಲೇಡರ್ ಪೀರಿಯಡ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿಲ್ಲ ಸರ್.
ಆಯ್ತು, ಅದೊಂದು ತಿಂಗಳು ಕೊಡ್ಬೋದು. ವಾಟ್ ಇಸ್ ದಟ್ ಇನ್ಕಮ್? ನಾವು ಇನ್ಕಮ್ ಎಷ್ಟು?
Income, my lord, 2015 accident, my lord.
Yes.
My claimed income 9,000. As per legal services 9,000.
Yes, so and so learned counsel appearing for. The claimant has contended that liability dispute ilva?
Illa sir. R1 KSRTC.
Due to that accident, claimant has suffered grievous injury. He was inpatient for a period of 23 days.
She, my lord.
She has suffered lot of pain during the treatment.
She has to suffer this disability and unhappiness throughout his life. Compensation awarded by the tribunal for pain and suffering is on, and other incidental expenses is on lower side. Tribunal has failed to grant any compensation for loss of immunities and loss of income during the later period. Hence, he sought for enhancement of compensation. The matter is called in that morning session, none appear for the respondent. Hence, it is passed over. Even afternoon session, when the matter is called, none appear for the respondent. Counsel for the appellant is heard, learned counsel for the appellant. It is not in dispute. Claimant has suffered an injury in a road traffic accident occurred on 16/12/2015 due to rash and negligent driving of driver of KSRTC bus bearing registration number KA 19 F3265. Due to the accident, claimant has suffered the following injury. She was inpatient for a period of 23 days. She has suffered a lot of pain during the treatment. She has to suffer this disability and unhappiness throughout his life. Considering that in wound certificate, considering that wound certificate exhibit P6 wound certificate exhibit P6 and discharge summary exhibit P11. I am of the opinion that compensation awarded by the tribunal for pain and suffering has to be enhanced to from 12,500 to 40,000. The claimant is also entitled for loss of income due to the for disability amenities 30,000. As per that chart prepared by Legal Service Authority, notional income for 1 month for the accident occur in 2015, my lord. 2015 as fixed and 9,000. Loss of income during the later period for 1 month is awarded, granted. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. Income later period 3 ತಿಂಗಳು ಕೊಡ್ಬೋದು ಸರ್ 23 ದಿವಸ hospitalized ಆಗಿ 2 months. 2 months, yes. In view of order dated 14/3/2022, not entitled for the interest for enhanced compensation amount for period of 133 days. Case great.
Bill number 55, Satish TS for petitioner, Vinayaka S Pandit.
Petitioners, my lords, in this case,
For the respondent.
it's
number
around
5
delay of
minutes.
latches of around 44 years. It's a PTCL. Maybe.
No, that he
Because
said
The grounds urged are, they were not heard before the DC.
we'll send it back.
Lords, that is one of the grounds, that's all. That's one of the grounds. Lords, the major ground is that, lords, it is land under the Gromor's food scheme. Lords, as PTCL is not applicable for that. Before the assistant commissioner, they don't produce any records. Subsequently, lords, they produce some records.
No, there is a Supreme Court judgment. It said it is applicable. Nobody has
So
placed.
there's
No,
a
this
clear
honorable
finding-
court,
there is a
many
clear
judgments are
finding
there.
Page 25, if he is going on merits, I would also bring to your lords, my lords notice page 25 para 10.
What is
ಅದ್ರಲ್ಲಿ
that?
ಹೇಳ್ತಾ ಇದ್ದಾರೆ. So ಅದನ್ನ ಎಲ್ಲ ಗ್ರಾಂಟ್ಗೆ 100 ರೂಪಾಯಿಗಳ ಕಿಮ್ಮತ್ತಿನಂತೆ ಕಾಯಂ ಮಾಡಿ
The thing is that nobody has brought to the notice of the Supreme Court judgment. Even division bench said it is not applicable. Supreme Court said land granted under 43J, condition can be imposed under 43G if it is free grant or reduced market value. It is a Supreme Court judgment.
No, that, my lords, that is there. I am not under
No,
that.
that is what 43J itself is a Gromor food scheme. If land is granted under Gromor's food scheme, it has to be confirmed only under 43J.
No, that is there, my
If
lords.
it is confirmed under 43J, condition can be put under 43G and the Supreme Court said that 2005.
That is one, my lords, and there is a 44 years of delay in filing the application.
Filing application.
44 years of delay.
Then that we have to be wait for the decision of that. No, if you are saying that you want to raise all this ground before that DC, we can send it. Or you don't want to raise the ground that principle of natural justice not making a party, we can argue other ground, we'll wait for that decision of that constitutional bench challenging that validity before other bench. We'll wait for that.
Yes. Oblige, my lords. Interim order may be extended.
My lords, there's an interim order.
Interim order may be.
Sometime revenue records are already changed even before the interim order was granted. That is my difficulty, my lords. Let them merge. There's also another technical aspect.
No, how can that change
No,
that?
there is another technical aspect.
Within the appeal period also, my lords.
He is LR of Ramaya. There is another person, Timmaya, as my lords have rightly pointed out in the first session. Even he is dead. Aurgu notice issue agbekagittu, technically speaking. So let it go back to the
Saying
DC.
that is immaterial. He has
Immaterial,
another
because
ground to
I
object.
have purchased through him.
See, he
So
is
it is
not
for me.
canvassing on that. I have not given opportunity. He is saying that these are all that legal ground. It need not be sent. The purpose of remaining will be futile because it can be considered here only. That is what he is saying.
Very well,
So,
because in that case, I may be
That two
permitted.
grounds. One, I think, other ground is, it is a valid ground. Now that it is pending before that other bench, we'll wait for that. If he
On
succeed in
merits?
that, he need not remand. He
And
can.
you don't have to, it need not be remanded. I don't have to go through the all process.
Yes.
If
that's
my
what-
lords, if
that
it
is also
goes
true.
the other side, I'll have this ground still left open.
Yes.
Interim order may be extended.
Let's just to bring to my lord's notice.
Yes.
There are two counts. One ado grant to grow more food agidruno reduced price free agi that is there is a specific observation to that, and they've also stated
No,
our
even-
ತಂದೆ ಅವರು objection ಹಾಕಿದ್ದಾರೆ.
No, Mr. Council, even assuming that SC/ST Act is applicable.
Yes.
Now the question is, Supreme Court said application has to be filed reasonable time.
Yes.
Now state has made an amendment. There is no limitation. That has been challenged pending before that. We will wait.
Understand.
Then we can decide that.
There is also,
Or-
lords,
If that validity has been set aside, then he has a defense under the Supreme Court judgment. Nikanti Ram case, delay approaching that.
Nikanti, I understand, my lords, that I understand, my lords, but in view of the amendment, which is still in force as of now, the DC has recorded that and he has passed an order. And if his grievance is that he has to urge his grounds, let it be remanded back, the DC will reconsider it. That is all I am seeking.
Let us see. Suppose, why we have to send it back? Suppose tomorrow DC has held that in view of that amendment, application is in time, then again he will come back to this court. Again that come to square one, back that he is challenging the validity and say that. We'll wait
My
that.
lords, with all due respect, whatever be the outcome, either of the parties, now anta alla, either of the parties, whatever be the outcome of that validity,
My
that will again
roster
be.
in respect of that SC/ST matter, I can't dispose any matter because of that pendency, because all matters, one or the other way, it will connect it to that limitation.
I understand.
Therefore, we are
lords.
waiting.
I was just trying to
Now
make an
that-
attempt to.
Yes.
what
Now
happens,
that,
my lords?
I think matter has been posted on 13. We'll see that. Even division bench also waiting for that decision. We'll wait. Yes.
Pledge. Interim order may be
Matter
extended.
On 20th. Interim order granted earlier is extended till next date of it. Yes.
Oblige, my lords.
Much obliged.
If he is agreed that, no, I will not canvass other ground, it can be go back, I can send it back. But he is saying that, why should I go? I have other valid ground.
In the meantime, I'll also file my objections on merits, my
Yes.
lords. The
Yes.
vacating
Hey,
stay
you
does
have
not.
filed it.
No, vacating stay hakide, sir. Objection hakbud.
I thought. Oblige. Oblige.